Section 17 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 7. DeRestis Clapp had been a police officer since 1828. On 5th December was directed by City Marshal to search the house of Dr. Webster. Took officers Hopkins and Sanderson. The others went upstairs while I remained down. Went to search for a particular parcel of papers in Dr. Webster's house, in consequence of directions which were given me. Asked Mrs. Webster if she had in her possession any particular parcel or package given her by the defendant. She left the room and presently returned, bringing a bundle of papers. The papers, not being articles named in the search warrant, requested Mr. Sanderson to replace in the trunk upstairs we had found them, and to bring the trunk down, which was done. Recognized the handwriting of Dr. Parkman on two of the papers, and put my initials on all of them, for the purpose of identification. The notes bearing the witness's initials were produced and put into the case, the defendant's handwriting being admitted by his counsel. The following are copies of the notes. $400. Boston, June 22nd, 1842. For value received, I promised to pay George Parkman or order the sum of $400 in 15 months from this date, with interest, to be paid at the rate of 6% per annum. J.W. Webster. On the bottom of the note, in pencil marks, admitted to be the handwriting of Dr. Parkman, was the memorandum. This is to be given up on payment of W.'s note of January 22nd, 47. And on the back of the note were two endorsements in ink, also admitted to be by Dr. Parkman of 1845, July 10th. Interest is acted to date by receipt, and $7 of principal, leaving due $393. October 10th, $75. In another place on the back of the same note was an endorsement in pencil which, Mr. Bemis stated, would be shown to be in the defendant's handwriting as follows: $483.64, balance paid, November 22nd, 49. Across the face of the note were two heavy transfer stashes, each about 2.5 inches long, and from 1/8 to 1/4 of an inch in breadth. One of these terminated in a collection of hair or fibrous marks, as if made by an instrument capable of making a number of such marks simultaneously. There was also a single heavy transfer stash across the signature, J.W. Webster. It was stated that it would be hereafter proved that these dashes, and similar ones on the other note, were not made by a pen, as had been represented by the prisoner. The second note was as follows: Boston, January 22nd, 1847. Value received. I promised to pay to George Parkman or order $2,432 within 4 years from date, with interest yearly. A quarter said capital sum being to be paid yearly. J.W. Webster. $2,432. Witness, Charles Cunningham. Underneath the body of the note and on its face were two memoranda, both admitted to be in Dr. Parkman's handwriting, the first in pencil as follows: 500 of the above is GP's, plus 332 equals 832. Balance due, Mr. Charles C. The second memorandum, in ink, with the exception of the words and figures after cancelled, was as follows: on payment to G. Parkman of $832 of this note and interest, Dr. W.'s other mortgage and note to G.P. of June 22nd, 1842 is to be cancelled. Copy W. has 831.83 corrected. Across the face of this note were two heavy dashes, similar to those upon the face of the other note, though still wider. The signature was also dashed out with a similar heavy dash. The word paid was also written twice, transversely, across the face of the note in ink. The counsel for the defense declining to admit that these latter words were in the prisoner's handwriting. It was stated that they would be shown to be so hereafter by the government's proof. On the back of the note, endorsed in pencil, in what was admitted to be Dr. Parkman's handwriting, was the memorandum. 7 November 3rd, $17.56 as by receipt. Also in ink and in Dr. Parkman's handwriting, the further memoranda. 1848, April 18th. Received $187, 50 to 100 by Charles Cunningham and gave receipt. GP. November 11th, $187, 50 to 100 by CC and gave receipt. Mr. Clapp. The memoranda shown to me came from the prisoner's wallet when I searched him at the Leverett Street jail the night of his arrest, November 30th. The first read as follows. November 9th, Friday, received $510, $234.10 out Dr. Bid. Petty cash, $275.90. Dr. P came to lecture room, front left-hand seat. Student stopped. He waited till gone and came to me and asked for money. Desired him to wait till February 23rd, as all the tickets were not paid for, but no doubt would be then. He, good deal excited, went away and I owed him $483.64. Friday, 23rd. Called at his house about 9 a.m., told him I had the money, and if he would call soon after 1, would pay him. He called at past, and I paid him $483.64. 9th, due Dr. P, who called at lecture, $483.64 by his act. Desired him to wait until Friday 23rd, angry. Friday, 1/2/1, paid him, he to clear mortgage. Note, February 13th, 1847, including smaller ones, $2,432. The $125 due him on loan, which the large note covers he agreed to give up toward sale of minerals. Balance due $483.64, paid, and he gave up 2 notes, had not the mortgage, but said he would go and cancel it. Had paid him $375 by Smith, $125 due, $500 the loan. Rest from other persons. On the back of this memorandum, and what was also admitted to be the prisoner's handwriting in ink. Mortgage, 22nd June 1842. Note, $400, June 22nd, 42. Note, $2,432, January 22nd, 47. The second memorandum in ink consisted of the following words: ale, or axe, jug malls, molasses, keys, tin box, paint, solder, $483.64. Mr. Clapp. We received reports through the marshal that Dr. Parkman had been seen in various parts of the city on Saturday, Sunday, Monday, and Tuesday. Tuesday, I was directed to look over the college, all vacant houses in the neighborhood, and the lands about the jail. Took Mr. Fuller and Mr. Rice, and went to the college. Entered the east front through Mr. Littlefield's apartments. Found him there and went in his company to Dr. Webster's apartments. Tried a door and found it fastened. A door to get into the laboratory. We then went up the front entry to the door of Professor Webster's lecture room. Mr. Littlefield said it was the doctor's lecture day, and that it would be but a short time before the lecture would begin. Mr. Littlefield rapped, but no one came. He rapped again, and in about half a minute, Dr. Webster came to the door, informed him that we wished to look over the college. He said that the police had made a search before, but if we wished to do so, we could. I said to him, "We can't believe for a moment, sir, that it is necessary to search your apartments." He asked us to walk in, and we went down 2 steps to his table. I inquired when he had seen Dr. Parkman. He said that he saw him there last on Friday the 23rd, that he came there by appointment. He also said on an inquiry from me how much he paid him that day, that he paid him $483, and I don't remember whether any odd cents. He said that he took the money and went up the steps in a hurried manner, and went out at the door by the way he had come in, and that he had not seen him since. He led us into his back room and pointed out his closets, and also opened the little back room and said that that was where he kept his valuable and dangerous articles. We merely looked into the room, did not search. The whole was a mere passing movement through the premises, and then went down to the lower laboratory. We passed round his tables and apparatus, which were in confusion, but saw nothing to attract attention. We were shown to the passageway to the dissecting room entry by the doctor himself. We went to the stairs in the door where the privy is, and then turned and went back again. Do not recollect looking into the privy window. Did not expect to find anything at the college at all, and hadn't the most distant idea that there was anything wrong about the professor's apartments. We searched the great vault, held the light down myself, could see well around. We searched every inch of Mr. Littlefield's apartments, drawers, clothing, pockets, male and female clothing, crockeryware. Also searched the attics. Friday night, 30th, was called to the college about 6 o'clock. Found Mr. Littlefield, Dr. Bigelow, the marshal, and Mr. Trenholm there. Went down underneath. I was the first to put the light into the hole where the remains were found. After we took the body out, we came up and went into the laboratory. Found a pan of sand on the right side of the furnace where the bones were found. Saw the furnace, which was covered over with a soapstone cover and minerals. Put my hand into the furnace and took out a piece of coal, and found a piece of burnt bone adhering to it. Was sent by the marshal to Cambridge, took a coach, and in company with officers Starkweather and Spur went there. We stopped a few rods from Dr. Webster's house. I went ahead, and as I got to the gate, met the doctor on the front steps, showing a gentleman out of his house. I spoke to the doctor before he got into his house and told him that we were about to search the college again that evening and wished him to be present. He went into his library and put on his boots, coat, and hat. As we passed out, the doctor said, I should like to go back for my keys. Told him that it was not necessary as we had keys enough to unlock the college. He said, very well, and we got into the coach. Don't recollect that Dr. Webster said anything as we walked to the carriage. Told the driver to go over Craigie's Bridge, through East Cambridge. Tried to have a free conversation on a part of the time we conversed about the contemplated railroad to Cambridge. Also, of the efforts to find the body of Dr. Parkman. Told him what distances we had sent, and the stories that had been told. As to his being seen, he said, there is a lady over there pointing towards the port, a Mrs. Bent, who knows something about it. Suppose we ride over there. Told him that we had better postpone it to some other time. Dr. Webster said that he had called at Dr. Parkman's house about 9 on the morning of the 23rd, requesting the doctor to call at the college betwixt 1 and 2. That the doctor did call, that he paid him $483, and that Dr. Parkman was to cancel a mortgage. Inquired if Dr. Parkman had done so. His answer was that he did not know. Then asked him if in case it had not been done, and Dr. Parkman was not found, he would be the loser. His answer was that he presumed not. When we arrived near the bridge, the tide was down. Pointed it out to Dr. Webster and told him that soundings had been had in all those waters above and below the bridge. Told him that a hat had been found at the Navy Yard, which was supposed to be Dr. Parkman's. Do not recollect that he made any comment. When we got to Brighton Street, the doctor said that we were going the wrong way. Replied that the driver might be green, but he would probably find his way to the college in time. We arrived opposite the jail door about 8:30. Got out on the offside to see if there were any spectators in the jail. There were none, and I came out and opened the door on the near side and said, "Gentlemen, I wish you would get out and come into the jail office a few minutes." We all got out and went into the jail office. After we had all got into the outer office, I took the lamp and said, "Gentlemen, suppose we walk into the inner office." The first one that spoke was Dr. Webster. He turned half round to me and said, "What does this mean?" Said I, "Dr. Webster, you recollect that I called your attention at the bridge to soundings, having been had above and below the bridge. We have been sounding in and about the college, and have done looking for the body of Dr. Parkman. We shall not look for his body any more, and you are now in custody on a charge of the murder of Dr. Parkman." He articulated half a sentence. I could not understand what it was, and then said, "I wish you would send word to my family," recommended to him to have it postponed until the morning. Told him that it would be a sad night spared to them. He seemed inclined to talk to me about the crime which was charged to him, and I said to him, "Doctor, I think that you had better not talk to me on the subject." He wished me to notify some of his friends in the city. Told him that it would not be necessary to do it that night, as he could not see them, and he had better wait until morning. Told him that I wished to see if he had any articles about him, and proper to carry into the jail. Took from him, or he handed to me, a gold watch, a wallet, containing 3 memoranda, before produced, $2.40 in money, an omnibus ticket case, and 5 keys. I produced the keys, one of which, an iron key, 4 or 5 inches long and somewhat rusty, has a pasteboard label on it marked privy. The privy key has the label on it. Took all these, and tied them up in a handkerchief and carried them to the marshal's office. Locked them up in my private drawer, of which I had the only key, and did not see them again until Sunday about 12. Left Dr. Webster in the custody of Mr. Starkweather and Mr. Spur in the back office, while I went into the front room to make out a mittimus, or commitment. Requested them not to commit the doctor until they heard from me, and taking Mr. Spur with me, told Mr. Starkweather to remain with the doctor until I returned. Mr. Spur went to the marshal's office. Jailer Andrews was not at the jail when we left our prisoner there. We did not find the marshal or Mr. S.T. Parker. We then went down to the college and found Dr. Webster there in charge of 2 jail officers. Mr. Parker and the coroner and others were there, also several physicians. First saw the party in the laboratory. They were standing by the sink from whence the constituent water runs. Dr. Webster was already downstairs, and there was an inquiry for the key to the privy. Mr. Littlefield went and got several, but none would fit. Did not then know that I had a key in my possession that would unlock the privy. Sunday, found the key marked privy while looking at the articles which I had taken from Professor Webster. Went to the college and found this lock, exhibiting one, on a shelf behind the door. Put the lock on the privy door, put in a screw, and then applied the key and found that it fitted. The attention of the county attorney was called to the bones in the furnace at that time. Soon after, I went into the laboratory, found the doctor standing, facing the north side of the building, and trembling as if in a fit. Someone put a tumbler to his mouth, but he did not appear to have power to drink. He did not seem to notice anyone, or anything that was said to him. He appeared like a person in a fit of delirium tremens, or trembling madness. The first search of the prisoner's house was made on Saturday morning, December 1st. Got Mr. Charles Cunningham to accompany me. We found this bank book in a drawer in the library. Witness produced a small memorandum book, apparently used for the purpose of keeping the prisoner's account with the Charles River Bank. Our search otherwise did not amount to anything. We did not get what we went for. We searched the library very closely, behind the books on the shelves, etc. We also searched the trunk in which the notes and account were afterwards found, but I saw no papers there like them. Then searched the professor's mineralogical cabinet at the college in Cambridge, and his own house again that day, but did not find anything. Cross-examined. There were other private papers in Dr. Webster's wallet at the time of his arrest. Think that Mr. Littlefield tried to open the door by the laboratory stairs when we tried to get into the doctor's apartments on Tuesday. Looked into the back private room. Things looked tidy and snug there. Saw some minerals in the lower laboratory. Do not recollect whether there was a fire in the furnace in the lower laboratory or not. The keys which I have produced were all that I found upon the doctor, or in searching at his house in the college. He said, coming in, that Dr. Parkman was an honest man, and that he did not believe he should suffer any loss if he were never found. The conversation between us was free and easy, as I desired to prevent the suspecting that he was under arrest. Charles W. Little. Am a student in the senior class at Harvard. Knew Dr. George Parkman by sight. Recollect meeting him on Thursday, November 22nd, between 1 and 2 p.m. in Cambridge, in the street leading by the Episcopal Church to Mount Auburn, between the residence of Mr. William Saunders and the Washington Elm, and about a quarter of a mile or less from Dr. Webster's residence. Dr. Parkman was riding alone in a chaise, and he stopped and asked me where Dr. Webster lived. I told him where, and he rode on. Upon my return Sunday morning, heard of his disappearance and recalled the fact of his meeting me. Seth Petit. Reside in Dorchester but do business in Boston. Am discount clerk in the New England Bank and collect funds for the medical college. There are 7 professors in the faculty. My duty is to dispose of the tickets and receive the money. Each professor has his own tickets and receives his own funds. On 7th, received 100 of Professor Webster's tickets to dispose of to the students. Up to 23rd November, had disposed of 55, for which I had received in cash at $15 a ticket, $825. Of the balance have sold some for the promissory notes of the students, and some were given away as third course, or free tickets. Those sold for notes and the free together amounted to 38. And I have 7 on hand, out of the promissory notes, taken in payment. Dr. Webster had realized nothing prior to November 23rd, though $15 had been collected on 2 half-paid tickets. This sum had gone to pay Dr. Bigelow for a debt to the faculty. Previous to the 23rd, the sum of $825, before named, was all that I had collected for Dr. Webster. Do not know how many more tickets than those which I received were sold for his course. The whole number of students attending the lectures was 107. Have only known of 3 instances of tickets being sold for the doctor's course which did not pass through my hands. One was a ticket for a Mr. Ridgway, which Mr. Littlefield sold and collected money for. The course of medical lectures began November 7th. The first payment I made to Dr. Webster was on the 9th. There was then due him $510. I deducted out of the $510 the amount of a note due Dr. Bigelow, $234.10, which Dr. Bigelow had given me to collect, and paid over to Dr. Webster the balance, $275.90 in a check. This check, which I now produce, paid, bears date November 9th. The next division was November 14th. Credited Dr. Webster on my account at that time with 13 tickets, amounting to $195, and paid him by a check. The next division was on November 16th, $30. I paid him with a check to Mr. Littlefield on an order from Dr. Webster. On 23rd, I credited him with $90, the price of 6 tickets. For this, I drew a check for $90 and handed it to him personally at the medical college on the morning of that day. I paid him nothing since. The first time that I ever saw Dr. George Parkman was on November 12th last. He came to the bank and inquired of me whether I collected the funds of the medical college, and if I had any of Dr. Webster's funds in my hands. I replied that I had paid over to Dr. Webster all the funds I had in my hands a few days before. He left the bank and in 15 minutes returned and received a dividend belonging to his wife, which I paid to him. As he was signing a receipt, I inquired of him if Dr. Webster owed him, and he said, "I should think that you might judge so from my manner." A few days after this, the same day that I paid Dr. Webster $195, he called again and asked as before if I had any funds belonging to Dr. Webster. Told him that I had not, as I had just paid him them over. He said that he thought he had given me a hint to retain the funds for him, or something of that sort. Told him that I had no control whatever over the professor's funds, that my duty was merely to collect them and pay them over. He said that I should have been doing justice to himself and Dr. Webster, and all concerned if I had retained the funds for him, and that now he should be obliged to distress Dr. Webster and his family. Suppose that he meant that he should be obliged to commence a suit. Seemed to blame me for not retaining these funds. He then said that Dr. Webster was not an honorable, an honest, or an upright man, and added, "And do you tell Dr. Webster so from me?" Never saw Dr. Parkman again. On morning of 23rd November, went to the college to pay Professor Webster the $90. Took a notice from notice box, a notice to the students when I would be in attendance to deliver the tickets, which I wished to alter so as to change the day of attendance from Thursday to Saturday. Mr. Littlefield gave me the keys to the library, which I unlocked and passed through to the private room in the rear of Professor Ware's lecture room, altered the notice and returned, and then passed down the stairs, through Mr. Littlefield's cellar, by the laboratory stairs, to Dr. Webster's laboratory. The door was not locked. Found Dr. Webster in, excused myself for coming in at that time of the morning, told him that Dr. Parkman had called on me several times and inquired if I had any funds of his in my possession, and as I did not wish to have any of his funds trusted in my hands, or any trouble with Dr. Parkman, I had come to pay them over to him. Professor Webster said, "Dr. Parkman is a peculiar sort of a man, rather nervous, and has been sometimes subject to an aberration of mind, so much so that he was obliged to, or did, put his business out of his hands, and Mr. Blake, a relative, attended to it for him. He said, 'You will have no further trouble with Dr. Parkman, for I have settled with him.' There was no further conversation, and I went away, first paying him the $90 and a check on the Freeman's Bank, drawn by myself. Went to the college in the afternoon of the same day, Friday, sometime between 4 and 5 o'clock. Met Mr. Littlefield at the door. He had sent for me. He was dressed as usual, but came in his stocking feet without shoes. He said that he wanted to see me to fill up a set of tickets for a student who was going to leave in the morning. P.R. Ridgway. Filled up the tickets, and Mr. Littlefield told me that he would give me the money for them on the next day when I called. Called at the college the next day, Saturday, not far from 3 p.m., saw Mr. Littlefield. He was sitting at a table in Professor Ware's lecture room. When I had the interview with Dr. Parkman, can't say that he used any profane language. When I told him that I had paid over the funds to Dr. Webster, he said, "The devil you have," or something like that. His language was hard or harsh, but I do not know that it was coupled with a profane expression. When he sent the message to Dr. Webster about his being a dishonorable man. When I talked to Dr. Webster, I mentioned to him Dr. Parkman's making inquiries about his funds, but did not the message about his being a dishonest or dishonorable man. Cross-examined. Have no means of knowing how many tickets Dr. Webster sold himself. I have no record of any others than those that I sold myself, and those were 97. Presume that the bills paid out by the teller of the New England Bank were New England Bank bills. He pays out no others. Had no other business with Dr. Webster on Friday morning, except in relation to the tickets. John B. Dana. Am cashier of the Charles River Bank at Cambridge. Have known prisoner 20 years. He kept a bank account at our bank. Dr. Webster deposited on November 10th $275.90 and a check on the Freeman's Bank. November 15th, $150 in bills. November 24th, $90, and a check on the Freeman's Bank. On November 23rd, there was a balance due Dr. Webster of $139.16. On November 1st, the balance due him was $4.26. He deposited the 10th, $275.90. After the 22nd, the amount of his drafts was $291. On December 1st, he drew a check for $93.75, which was paid to Mr. White. The next check was for $5 on the 3rd. The next check the same day for $10. The next check for $19 on the same day. At that time, the doctor's balance was $68.78. When a trustee process was served, the balance was paid on December 21st on a check of Dr. Webster in favor of the party who had trusteed, Mr. Richardson, a coal dealer. Daniel Henchman. Am a druggist in Cambridge Street. No defendant. On 23rd November about 10. He asked me if I could give him bills for a check for $10. I gave him one or more bills for his check on the Charles River Bank. The check was not paid for want of funds. James H. Blake. Am nephew of the late Dr. George Parkman. Took part in the search which was made for him. On Sunday afternoon, 25th, about 3 o'clock, one near the college, and while talking with the police officer, Dr. Webster came up towards me from the direction of the college. He had no overcoat on. It had been raining, with a cold easterly wind. He took me by the hand and said that he had seen in the transcript of the evening previous that Dr. Parkman was missing. He said that he had come in on purpose to notify the family that he was the gentleman who went to see Dr. Parkman's house on Friday morning and made the arrangement to meet Dr. Parkman at the college at 1:30 that day. He said that Dr. Parkman met him at the hour appointed, that he paid him the amount of a note, $483, or some such amount. He said that he kept the note, that Dr. Parkman left and said that he would go to East Cambridge and discharge the mortgage. Dr. Webster added, "We all know Dr. Parkman to be an honest man, and I trusted him with it." These were his very words. I inferred from them that Dr. Parkman had the mortgage deed with him. He said that he should go up and see Reverend Dr. Francis Parkman, that he had been to church in the morning, and he thought that he would wait until after dinner, before he came into town. After the conversation, he went into the college. Reverend Francis Parkman. Am a brother of the late Dr. George Parkman. Have known Dr. Webster a great many years. Was his pastor for several years. Was called to perform pastoral offices in his house within 2 months of my brother's disappearance, to baptize his grandchild, the last Thursday in September, the child of his daughter and son-in-law who reside at Vale. Sunday, after the disappearance of my brother, we were in great perplexity and distress. None of us went to church that day. I passed the morning with my brother's family. In the afternoon, Dr. Webster came to my house. On entering the room with our customary salutations, he said, "I come to tell you that I saw your brother at 1:30 on Friday, and paid him some money." It was then said by Mrs. Parkman or myself, "Then you are the gentleman who called at George's house at 9:30 on Friday morning, and made the appointment?" He answered that he was, and that he should have come and told us so before, but that he had not seen the notice of his disappearance until Saturday evening, and he had waited until now, thinking the family might be at church. I said, "Dr. Webster, we are very glad to see you, as it is a relief to us to know who called at my brother's on Friday to make the appointment. We feared that someone who meant him ill and called, and had beguiled him over to East Cambridge." Dr. Webster said, "I was the person, and your brother came to the college at 1:30 p.m., and I paid him $483 and some odd cents. I asked him if he was perfectly certain about the hour, to which he answered, 'I am quite certain. I finished my lecture at 1 o'clock, and I waited 20 or 30 minutes or so for your brother.' I asked him if he had a bundle of papers in his hands, and some person who saw him at 1 o'clock said that they saw him with papers in his hands. To this he replied, he had papers, and he took out one and dashed his pen through it. So, making a motion with his hand as if to imitate a sudden and rapid dash. Dr. Webster went on to say, I told Dr. Parkman that he hadn't discharged the mortgage. He replied, I will see to that. I will see to that. Dr. Webster said my brother went out very rapidly from the room in the college where the interview took place. Dr. Webster's manner was hasty, nervous. He commenced speaking in a business manner immediately upon entering the room. Could not but remark there was no expression of surprise at the mysterious disappearance, and no expression of sympathy with our distress. What particularly struck me was the absence of that expression or tone of sympathy in which it is natural for those approaching persons in affliction to speak. Dr. Webster was not there more than 10 or 15 minutes. My brother's domestic habits were remarkable. He was among the most punctual of mankind, almost always at home, seldom or never out of town, and almost invariably at his regular meals. If likely to be detained, he would take pains to send to notify his family of it, even for very short absences. He has left a wife, a son, and a daughter. His daughter has been a great invalid, and was one for whom he was perpetually anxious. His son was in Europe when he disappeared, but has lately returned. Believe I may say with confidence that I never knew my brother to use profane language. When he was moved, though he was not an irritable man, he would use strong language, but never on any occasion do I recollect hearing him utter a profane word. End of section 17. Section 18 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850. Part 8. March 26th. Ralph Smith. Reside here. Am engaged in mercantile business in Exchange Street. Professor Webster, owing me a small amount last fall, wrote him to the effect, and he replied that he would call and pay the bill on receiving the fees from the medical students. Samuel B. Fuller. Am a police officer. Went to East Cambridge to the Registry of Deeds on 25th November to see if the mortgage was canceled, and was told I could ascertain better by asking Dr. Webster. Went to his house about dark and found him at home. Dr. Webster went to an account book, turned over the leaves 2 or 3 times, and appeared to tremble badly. He left the room, soon returned and said, It is strange. I can't find those papers. He said, My ticket man told me that Dr. Parkman came to him and demanded what money he had in his possession for the tickets he had sold. He refused to let him have the money, and Dr. Parkman told him that I was a damned rascal and a scoundrel. I thought hard of it at the time, but I don't care about it now, as I have settled with Dr. Parkman, and it is all over. Said the mortgage was on personal property and not on real estate. On Tuesday forenoon, I accompanied Officers Clapp and Rice and Mr. Kingsley in the search of the doctor's apartments as described by them. I asked Dr. Webster who was with him when Dr. Parkman paid him this money. He said, No one but myself. I asked at what hour Dr. Parkman was there when he paid the money. He said, between 1:30 and 2 o'clock. I am the officer who discovered the remains in the tea chest. Had been searching all Saturday. After getting out the minerals, I found that there was tan in the chest. Ran my hand into the tan and took out a hunting knife. Took the chest and turned it over, when the trunk of a human body tumbled out, with one of the thighs placed inside of it, the thigh being tied round with a piece of twine at one end. Saw a hole in the left breast just under the left nipple. Found one of the kidneys in the ash hole. On Sunday, in the lower laboratory on the table were found a comforter and 2 woolen blankets, done up in a newspaper. S. Parkman Blake. I am a nephew of late Dr. George Parkman. I took a very active part in the search for him. Called on Dr. Webster at the medical college on Monday morning after his disappearance between 10 and 11. Mr. Littlefield said that he did not lecture that day and that he believed he was then in. He tried the door of the lecture room. It was fastened. Mr. Littlefield asked my name and said he would go round the back way and give my name to Dr. Webster, and he went down the stairs from the front entry. After waiting an unreasonable time, he unbolted the front door of the lecture room, passed out, and I went in. Saw Dr. Webster coming out of his back private room in a smoking cap and working dress. Told him that I had learned that he had an interview with Dr. Parkman, and that I had come to learn all the particulars of that interview. Dr. Webster then said that on the Tuesday preceding Dr. Parkman's disappearance, November 20th, the doctor had called there, before his lecture was finished, that he sat down and waited for the lecture to close. Dr. Webster pointed out the seat he occupied. After the lecture was finished, he went on. Dr. Parkman came up to the table and said, "Doctor, I want some money today." He was very much excited and very angry. "You have $500 in your pocket, and I want some of it." His own countenance lighted up and expressed great anger while relating the interview. Dr. Webster said that he told Dr. Parkman that he could not pay him that day, as he had not collected all the money for his tickets. Then Dr. Parkman asked him when he would pay him, and he said on Friday. That Dr. Parkman then went out. Dr. Webster said that on Friday, 23rd November, on coming into the city, he had called at Dr. Parkman's house, that he saw him at the door and told him if he would come to the lecture room on that day, after lecture, that he would settle with him, and that he did come about 1:30. Said that his lecture had been finished and 3 of the students had stopped after the lecture to ask questions, as they were accustomed to do. The students then went out, and very soon Dr. Parkman appeared. He came in a great hurry up to his table, where he was standing. Dr. Parkman asked him if he was ready for him, and Dr. Webster said he was. Dr. Parkman took out of his side pocket a bundle of papers done up loosely in a brown paper, I think, and drew out some notes, and he, Dr. Webster, took out his money and paid him $483 or $484 and some odd cents. There was a 4 about it, but I cannot tell whether it belonged to the dollars or the cents. He seized the money without counting it and was going off. I said, "There is one thing which you have forgotten, doctor. Where's that mortgage?" Dr. Parkman replied, "I haven't it with me, but I will see that it is properly cancelled." He then rushed out of the lecture room with these bills in his hand, carelessly exposed to view. I asked him what money he paid him, as it might lead to a discovery, but he said that he could recollect but one bill, a $100 bill on the New England Bank. Asked him if they were out-of-town bills or city bills, or large or small denominations. He replied that he could recollect only that one $100 bill. Asked him if he had the notes which Dr. Parkman had given up to him. He answered in the affirmative, but in a way which made an unfavorable impression on my mind. His eyes dropped, and he did not look me in the face. Asked him if anyone was present at the interview, and he said very emphatically, "No." He then turned the conversation to the subject of our families, KL, etc., and I shortly after left. Had been acquainted with the doctor for a good many years. I noticed that his manner was singular on my first entering his room. He seemed to want that cordiality and politeness that are usual to him. Thought that he looked pale. He received me in a stiff and formal manner, and confident that he did not put out his hand to me. When speaking of Dr. Parkman's being angry, he stood, fixed to the spot, and seemed to place himself on the defensive, as if waiting to be interrogated. He made no expression of sympathy for the family of Dr. Parkman, said very little about the search, and made no inquiries at all about the family of Dr. Parkman. The interview lasted some 15 or 20 minutes. He changed his position and manner. went out by the same door at which I entered, heard him bolt the door after me. Charles B. Starkweather. I am a police officer. Took part in the search for Dr. Parkman the day after his disappearance till the remains were found. Accompanied Mr. Kingsley to the college Monday, November 26th. Saw Mr. Littlefield and Dr. Bigelow and Dr. Ainsworth. Told them that we had come to look over the college for Dr. Parkman. They offered no objection and we went in. Mr. Littlefield tried Dr. Webster's lecture room door and it was fastened. He knocked on it 2 or 3 times quite hard, and then Dr. Webster came and opened the door. We told him what we came for. He opened the door. We went in, down the steps to the back laboratory and to the lower laboratory. He followed us down. When we got to the steps of the lower laboratory, Dr. Webster said, "This is all my apartments." We merely looked round the rooms and were not there more than 3 minutes. Was one of the party to arrest Professor Webster on Friday night. Mr. Clapp and Mr. Spur were with me. The doctor talked very freely while coming in, about the railroad to Cambridge, etc. Spoke of a Mrs. Bent, who had seen Dr. Parkman on Friday. He wanted us to drive over to the port to see her. When we got to the corner of 2nd Street, Dr. Webster remarked, "You ought to have turned that corner view going to the college." Something was said about the driver being green, but I could not hear perfectly. I sat on the front seat. Doctor sat beside Mr. Clapp on the back seat. Arrived at the jail. We got out and went into the back office. Dr. Webster was the first person to speak, and he said, "Mr. Clapp, what does this mean?" Mr. Clapp said, "We have done looking for Dr. Parkman, and you are in custody for the murder of Dr. Parkman." "What, me?" says Dr. Webster. "Yes, you, sir, and you are in custody for the murder of Dr. Parkman." Mr. Clapp and Mr. Spur then left us and said that they would go and see if they could find Mr. Parker and the marshal. Mr. Clapp made out a mittimus, handed it to me, and said, "Don't commit the doctor until I get back." He had previously searched his person. Immediately after, Dr. Webster called for a pitcher of water and drank several times. He asked me if they had found Dr. Parkman. Told him that I wished he would not ask me any questions, as it was not proper for me to answer them. He said, "You might tell me something about it. Where did they find him? Did they find the whole of the body? How came they to suspect me? Oh, my children, what will they do? Oh, what will they think of me? Where did you get the information?" Asked the doctor if anybody had access to his private apartments but himself. "Nobody has access to my private apartments," he replied, "but the porter who makes the fire." The doctor added, "That villain, I am a ruined man." There was no further conversation. The doctor would walk the floor and wring his hands, and then he would sit down. Saw the doctor put his hand in his vest pocket and put it up to his mouth. He had a spasm. Went to him and said, "Doctor, haven't you been taking anything?" He replied that he had not. Helped him up from the settee, and he walked the floor. Was with him about an hour when Mr. Clapp came back and told me to commit him. Went to him, told him that I must commit him. Took hold of his right arm and he could not stand. Mr. Cummings, an attendant, and I led him to the lockup. Told Mr. Cummings I thought he had been taking something and he had better send for a physician in the doctor's hearing. Mr. Clapp thought that he had better not send for a physician, but go down every few minutes and look to him. Had to lift the doctor up and lay him in his berth. We laid him upon his side and he turned over upon his face. He had a spasm every now and then, like a man in a fit. Next saw him about 3/4 of an hour afterwards at the medical college with Mr. Parker, Mr. Andrews, Mr. Platt, and several others, in the upper laboratory. Someone asked where the furnace was, and Mr. Littlefield walked towards it and pointed it out. In the laboratory, the doctor appeared very much agitated, more so than he did upstairs. I've had some fish hooks and twine in my possession, which I now produce. These were found as they now are in Dr. Webster's private room in his upper laboratory. The hooks were arranged in the form of grapples and attached to them leaden sinkers of a pound's weight or more. Pieces of twine, of perhaps 6 or 8 yards in length, were wound around each. The fish hooks were some 6 inches long with a bend an inch or an inch and a half across. Took the hooks and twine on Saturday. They were rolled up in a paper on the shelf in the back private room. On Saturday was in the upper laboratory and saw Mr. Fuller bring out a tea chest. Upon the thigh of the body found in it, there was a quantity of twine wound round. Found a bunch of skeleton keys, 24 in number, mostly new, or bearing marks of recent filing, in Dr. Webster's back private room in a drawer tied up, as they now are. Mr. Bemis, did you make any trial of the keys to see what doors of the college they fitted? Mr. Sohere objected to this evidence as not sufficiently connected with the prisoner. Mr. Bemis stated that it would be shown that the prisoner had represented that he found the keys in the street but tied in the same bunch with the skeleton keys were other keys, acknowledged by the prisoner to be his, as the chemical rooms were separated from the rest of the college and had no necessary connection with the others, as testified by Dr. Holmes. It might become material to show that the prisoner had provided or designed to provide himself with the means of access to other apartments besides his own. The court held the testimony admissible. Mr. Starkweather, this key fits the dissecting room. There's one of the locks of the door between the lecture room and the back room, and this one, the storeroom door, cannot find that the skeleton keys fit any of the locks of the college. These 2 brass keys, also found in the same drawer of the back private room, but on a separate string, fit the upper and lower front doors, also found in the drawers of the back private room, or rather in a cupboard, which was painted on the outside so as to resemble drawers. Mr. Sohere, I should like to inquire before permitting the witness to answer further what the government expect to prove in relation to that cupboard. Mr. Bemis, we expect to show that it contained a considerable quantity and variety of ardent spirits. I will add that I do not know in candor that there is any necessary connection between the presence of spirits there and the commission of the homicide by the prisoner, but we submit the evidence for what it is worth, as having a possible connection with his acts. The court held the evidence inadmissible. Mr. Starkweather, have heard Dr. Webster make some statements in regard to the skeleton keys. While waiting in the police judge's private room, I said to him in the presence of Mr. Andrews, the jailer, Doctor, I found some keys in your back room. What says he? Those that are filed? I picked them up in Fruit Street one day and threw them in there, into the cupboard. Cross-examined. Found the keys all tied together as at present on a shelf in the back private room. Did not say to Dr. Webster that I had found skeleton keys. Recollect about the doctor proposing to go back for his keys and Mr. Clapp telling him that we had keys enough to gain admission with. Charles B. Rice, am a police officer, was one of the party who went to search Dr. Webster's apartments the Tuesday after Dr. Parkman's disappearance, as already described. Samuel Lane, Jr., am in the hardware business in this city. Saw Dr. Webster in my place of business about the first Monday or Tuesday after Dr. Parkman disappeared. Dr. Webster came in and inquired for fish hooks, replied that we did not keep them, and he went out. Mr. Stephen B. Kimball was clerk in the store with me at the time, the store of Mr. R.C. Warren. Stephen B. Kimball, am clerk for Mr. R.C. Warren. Monday or Tuesday of Thanksgiving week, Dr. Webster called at the store and inquired for large-sized fish hooks. James W. Edgerly, I am a hardware dealer in this city. Remember the time of Dr. Parkman's disappearance. A person came into my store Tuesday following about night and inquired for the largest sized fish hooks. He bought and paid for a half dozen. These shown me are the same. I think defendant is the person who bought them of me. William W. Meade, I am a hardware dealer. On Friday, November 30th, a person came into the store and inquired for fish hooks to make a grapple with. He bought 3. I put them together and showed him how to form a grapple. The size was considerably smaller than those produced in court. Think that it was Professor Webster should not swear positively to it. He was dressed in dark clothing. William N. Tyler. Am a rope maker and a twine and line manufacturer for 45 years. Have been called upon frequently to give an opinion as to the quality and manufacture of twine. The twine shown me, consisting of specimens from that tied round the thigh, that used with the grapple, and that found on the ball in the back private room, in what is called two-threaded marline. Have not the slightest doubt that all the pieces are of one and the same manufacture and quality. They're all made of good Russia clean hemp, which is unusual in this sort of marline at the present day. Nathaniel Waterman. I am a tin plate worker. Saw a prisoner in my place of business November 30th, about 10 o'clock in the forenoon. Went up to him and said, "Excuse me, doctor, but I want to know how Dr. Parkman appeared when you paid him that note." He said he took the papers in his hand and darted out in his usual manner. If that is the case, said I, he did not get far from the college before he was murdered, as someone seeing his money may have enticed him into one of his houses. And I believe that if he is ever found, he will be found in one of his own houses, for I do not believe the story of his going over Craigie's Bridge. Dr. Webster said he did go to Cambridge. He said this energetically, as if he was sure of it. He then said, "Only think of it, Mr. Waterman. A mesmerizing woman has told the number of the cab he went away or off in, and Mr. Fitzhenry Homer has found the cab and blood has been found on the lining. He wanted a tin box. He said that he was going to have small things, say books, etc., put in. Spoke of having the handles made very strong, and never made any such apparatus as this for Dr. Webster before, nor anything precisely like it for anyone else. On Saturday morning it came down from the shop labeled. It has not since been called for." Charles B. Lothrop, informant of Mr. Waterman. Remember Dr. Webster calling for a tin box. Wanted a square tin box made of thick tin. Mr. Waterman told him that if he would send the box in after he got his things in, he would solder it up for him. "No, Mr. Waterman," said the doctor. "I have got to send it out of town, and I have got soldering irons, and will do it myself." Samuel N. Brown. I am one of the toll gatherers on West Boston Bridge. Knew Dr. George Parkman and Dr. Webster. On 30th November saw Dr. Webster pass by the window. Asked him if he could recognize a $20 bill that I had taken in the morning. Did not show the bill to him. In the morning of the 30th, an Irishman offered me a $20 bill to take his toll of 1 cent from. He said he had nothing smaller. Changed the bill for him. I asked Dr. Webster if he could recognize that bill. He said no, that the money he paid Dr. Parkman he had received from the students, some in large and some in small denominations. Dr. Parkman, on the Wednesday or Thursday before he disappeared, came to the toll house and asked me if I had seen Dr. Webster that morning. Told him I had not, and he turned and went back to the city. He had been down to the toll house twice within 4 or 6 days to inquire for Dr. Webster. Betsy Bent Coleman. Reside in Cambridgeport. Have known Dr. Webster for years. He called at my house the day of his arrest, about 4 in the afternoon. He said he had called respecting Dr. Parkman, and asked what day I thought I had seen him. Told him I thought I saw him on Thursday before Thanksgiving, the day before his disappearance, as I was sitting at my window in the afternoon. Dr. Webster said, "Was it not Friday you saw him?" I said no. I was very busy on Friday down in the lower part of the house. He asked how he was dressed, and I told him that he was dressed in dark clothes and had a cane. Asked Dr. Webster if he had heard anything from Dr. Parkman. He said that a cloak or coat had been flashed up, which was thought to be his, which had spots of blood on it, and I said, "Oh dear, then I am afraid he is murdered." He says, "We are afraid that he is, that there was a $20 bill left at the toll house by an Irishman that was suspicious. He asked me 2 or 3 times, and at the door in leaving if I was sure that it was on Thursday. Samuel D. Parker was at home Friday, 30th November, about 8 in the evening, when 10 or 15 gentlemen came in suddenly upon me. Among them Dr. Henry J. Bigelow, Mr. Edward Blake, Mr. Robert G. Shaw, Jr., Marshall Tukey, and others. They stated that certain discoveries had been made at the medical college, supposed to be connected with Dr. Parkman's remains, and that Dr. Webster was in jail. Told them that if they were satisfied that the remains were human, the coroner should be sent for. The matter of holding Dr. Webster was next talked of. I told them that a complaint must be made before a magistrate, and Kingsley volunteered to make it. We went to the jail, and soon the officers came up with Dr. Webster, supporting him and placing him in an armchair. He was much agitated and convulsed, and asked for water. He recognized me and called me by name, and also Dr. Gay. Water was handed to him, but he could not hold the glass. He appeared in great distress in regard to his separation from his family, begged him to be calm, told him of extraordinary discoveries made at the medical college, that these discoveries required explanations which perhaps he could give, that I wished that he would go with the officers and see them opened. He said that he would go if he could. I told him that there was a coach at the door all ready to carry him. He wished to have Mr. Franklin Dexter or Mr. William B. Prescott sent for. I told him that Mr. Dexter lived out of town. He said that some of Mr. Dexter's family were at the Revere House. I told him that it was too late that night to notify the gentleman he had named, but that they should have early notice the next morning. He spoke 2 or 3 times of the distress of his family, which induced me to remark that there was another family which had been in great distress for a week, and that we owed duties to society as well as ourselves. I also said to him that there would be an opportunity afforded to him to make any explanation which he saw fit, and that I hoped to God he would be able to explain the whole of it. When I left my house, I was incredulous of his guilt. At the jail, I tried to soothe him all that I could, and I said to the officers that he was not to be interrogated. I did not accompany him, but rode down to the college before him in another conveyance. While at the college, I did not speak to him at all. John M. Cummings, am watchman and turnkey at the jail, was present when Dr. Webster was first brought to the jail, assisted him downstairs into the lockup. He could not walk and was in a very bad state. Had to hoist him up into his berth and laid him in with his face downwards. He spoke of his family several times and wanted water. Later in the evening, Mr. Samuel D. Parker and several other gentlemen came to see Dr. Webster, told him that I wanted him to come upstairs, that Mr. Parker wanted to see him. He did not take any notice of what I said. He appeared to be very much agitated and made the remark, I expected this. Went upstairs and told Mr. Parker that he could not come up. Then Dr. Gay, Mr. Layton, Mr. Pratt, and Mr. Jones came down with me. Dr. Gay asked him if he could not get up and go upstairs. He made no answer. We took hold of him in his berth, and he made a spring and grabbed his arm about Mr. Jones's neck, as if frightened. We brought him up into the back office and set him up in an armchair. Mr. Layton and I helped Dr. Webster into the carriage to go to the college, helped him out of the carriage and up the steps. He trembled and had a cold sweat on him. His face was quite wet. The wind blew at the time, and the weather was cold. We lifted him into the coach when we left the college. He could not help himself at all. He spoke of his family again as we rode back to the jail. Had to carry him down to his cell. Went down to see him twice after this, at 1 and again at 2:30. He lay just as we left him, awake, but seeming to be in distress. Gustavus Andrews, innkeeper of the Leverett Street Jail, was at the jail when Dr. Webster arrived. First saw him at the college. A number of gentlemen came down the stairs. Mr. Parker called my attention to the furnace. Saw fragments of bones, a piece of skull. When I turned round, Dr. Webster was standing about 3 feet from the privy door in a state of very great excitement. About the time that the privy door was broken open, accompanied the party into the room where the remains were exhibited. When we went in, Dr. Webster placed his feet down firm, as if to brace himself up, but as soon as the remains were brought up, he commenced trembling again. I took upon myself to direct that he should be taken to the carriage again, found that Dr. Webster was unable to get in. His limbs were perfectly stiff. He could not bend his legs. I got in first and helped draw him in, as if his body was in one straight piece. We placed him on the back seat, and he fell back as if faint and unable to support himself. The first thing he said was, "Why don't they ask Littlefield? He can explain all this. He has the care of the dissecting room. They wanted me to explain, but they didn't ask me anything." He then said, "Oh dear, what will my family think of my absence?" I said to him, "I pity you, and I am sorry for you, my dear sir." He replied, "Do you pity me? Are you sorry for me?" "What for?" I said, "To see you so excited. I hope you will be calmer." He said, "Oh, that's it." We took him to the jail and put him into his cell. We lifted him in and left him lying upon his back with his head bolstered, had a lantern placed in his cell, and watched him some time. Seeing he did not move, I left him for the night, visited him in the morning, and found him just as we had left him at midnight. Don't think that he had moved an inch all night long. In the course of the forenoon, he was able to sit up in a chair. During that morning, Saturday, Dr. Webster said, "That is no more Dr. Parkman's body than it is mine. But how in the world it came there, I don't know." He said, "I never liked the looks of Littlefield, the janitor. I opposed his coming there all I could." The doctor was in such a state of perspiration the night before that I could feel the dampness upon his shoulder blades through his coat. I have a letter of prisoners which came into my hands, as letters generally do, from those confined in the jail by being brought to the office by the turnkey. The rule is that all letters shall be examined before they go out or into the jail. This letter was brought up Tuesday morning, December 4th, open. Cannot say who brought it up. The letter was detained and never sent. It was addressed to Miss Mary Ann Webster, Cambridge. Boston, Monday evening. My dearest Mary Ann, I wrote Mamma yesterday, and Mr. C., who was here this morning, told me he had sent it out. I had a good sleep last night and dreamt of you all. I got my clothes off for the first time and woke in the morning quite hungry. It was a long time before my first breakfast when Parker's came, and it relished, I can assure you. At 1 o'clock I was notified that I must appear at the courtroom. All was arranged with great regard to my comfort and avoidance of publicity, and this first ceremony went off better than I anticipated. On my return I had a bit of turkey and rice from Parker's. They send much more than I can eat, and I have directed the steward to distribute the surplus to any poor ones here. If you will send me a small canister of tea, I can make my own. A little pepper I may want some day. You can put it up to come with some bundle. I would send my dirty clothes, but they were taken to dry and have not been returned. I send a kind note I received today from Mr. Curtis. Professors Pierce and Horsford called today. Half a dozen Rochelle powders I should like. Tell Mamma not to open the little bundle I gave her the other day, but to keep it just as she received it. Hope you will soon be cheered by receipt of letters from Fayelle. With many kisses to you all. Good night, your affectionate father. P.S. My tongue troubles me yet very much, and I must have bitten it in my distress the other night. It is painful and swollen, affecting my speech somewhat. Had Mamma better send for Nancy? I think so, or Aunt Amelia. Couple of colored neck handkerchiefs, one mattress. End of section 18. Section 19 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 9. Francis Tukey, recalled. 3 letters were exhibited to witness, one enclosed in a yellow envelope bearing a postmark of Boston, November 26th, one in a red envelope bearing the postmark East Cambridge, November 30th, and one bearing the postmark like the last, of Boston, November 30th, and he was asked when, if ever, and from what source he had received said letters. The first of the letters I received through the Boston Post Office on the day of its postmark, November 26th, the second from the hands of the East Cambridge postmaster on November 30th, at about 12:30, and the third I took from the Boston Post Office on the same day. The anonymous letters were now put in. Boston, November 31st, 49. Mr. Tukey, dear sir, I have been considerably interested in the recent affair of Dr. Parkman, and I think I can recommend means the adoption of which might result in bringing to light some of the mysteries connected with the disappearance of the aforementioned gentleman. In the first place, with regard to the searching of houses, etc., I would recommend that particular attention be paid to the appearance of cellar floors. Do they present the appearance of having been recently dug into and covered up again? Or might not the part of the cellar where he was buried have been covered by the piling of wood? Secondly, have the outhouses and necessaries been carefully examined? Have they been raked sufficiently? Probably his body was cut up and placed in a stout bag, containing heavy weights, and thrown off one of the bridges, perhaps Craigie's, and I would recommend the firing of cannon from some of these bridges, and from various parts of the harbor and river, in order to cause the parts of the body to rise to the surface of the water. This, I think, will be the last resort, and it should be done effectually, and I recommend that the cellars of the houses in East Cambridge be examined. Yours respectfully, Civis. 2. Doctor, sir. You will find Dr. Parkman murdered on Brooklyn Heights. Yours, M., Captain of the Dart. 3. Dr. Parkman was took on board the ship Herculeum, and this is all I dare to say, as I shall be killed East Cambridge. One of the men give me his watch, but I was feared to keep it, and throwed it in the water right side the road to the Cambridge to Boston. Nathaniel D. Gould. Have known prisoner for a long time by sight. Have never seen him write. Am familiar with his signature. Have seen it appended to the diplomas given by the medical college for 20 years, in connection with those of the other medical professors, having been employed as a penman to fill out those diplomas for the college. Have paid particular attention to the subject of penmanship, having practiced it in every way and instructed in it for some 50 years. Have also published on the subject. Mr. Bemis. Look at the 3 letters produced by Mr. Tukey and state in whose handwriting they are, or by whom, in your opinion, they were written. Mr. Sohere. We object to this proof. No proper foundation has yet been laid by the government for the statement of the witness's opinion. The witness has never seen the prisoner write, nor heard him admit any writing to be his. Chief Justice. He has had occasion officially to know his handwriting for many years. Mr. Sohere. This kind of evidence, if admissible at all, belongs to a class of evidence exceedingly liable to error, and we do not intend to take the responsibility of permitting it to be introduced without interposing an objection. We suppose that it is offered on the ground of the decision in the case of Moody v. Rowell, 17 Pick 490. We do not mean to object to the authority of that decision, but trust that the court will not go beyond it. That case, as we understand it, sustains 3 propositions. First, that general handwriting may be laid before the jury for the purpose of comparison, with that alleged to be by the same person. Secondly, that an expert may determine and testify from knowledge gained by comparing such specimens whether the handwriting in question is genuine or not. And thirdly, that an expert may be permitted to give an opinion whether the imitation of another's handwriting is in a disguised or simulated hand. This case does not come under either of these propositions. The government do not now propose to prove that these letters are in the handwriting of the prisoner, but that though he wrote them, they are not in his ordinary handwriting, and they call an expert with a view, doubtless, of instituting a comparison between the writings now in the case, or which may hereafter be put in order to enable him to form an opinion upon that point. The Attorney General. I think that the learned counsel misapprehends the ground upon which we offer this evidence. We do propose strictly to prove that these letters are in the handwriting of the defendant, using the term handwriting in its proper and enlarged sense. The gentleman's argument supposes that if a person's handwriting were generally uniform, but he was occasionally to vary it, that evidence of the varied style would be incompetent, whereas if it were always uniform, we might have the opinion of the expert to prove or disprove it. Such a distinction cannot have any foundation in principle. It is conceded that the opinion of the expert is competent to prove a forgery by another. We seek here only to show that the defendant has been attempting to conceal or disguise his own style of writing, upon principle, which is the more suitable subject for proof, by the expert. Plainly the latter, for the expert's opinion then is only required to extend to a knowledge of one person's handwriting, to show how much a writer differs from himself, whereas in the other case he is expected to be able to tell how much the writer differs from some third person. The case of Moody v. Rowell, I submit, fully covers the ground contended for, but there is one English authority also directly in point. I refer to Rex v. Cato, 4 S. 117. In that case, which was prosecution for libel, the point was distinctly ruled that an expert might prove that a document was written in a disguised hand by the prisoner. I may be permitted, perhaps, to refer also to the ruling of a lower court, the municipal court, and two other trials, which were considered of great importance, that of George Miller, where both of my learned friends were engaged, and that of Eastman, Fondy, and Company, a case which attracted great attention at the time. In both these cases, experts were admitted to testify to handwriting, for the purpose of which we offer the same kind of evidence now. Nor am I aware that there is any decided case at variance with our position. Mr. Merrick, the precise question now presented to the court has never been decided, that I am aware of. In Moody v. Rowell, the genuineness of the instrument was denied. Here its authenticity is asserted by the government. The papers there purported to have been written by the party in whose name they stood, whereas here there is no suggestion that these letters purport to have come from Dr. Webster. Their very idea, as suggested upon the other side, is that of anonymous or disguised communication and in a disguised hand. Mr. Clifford, we shall contend that one of them is in Dr. Webster's handwriting upon its very face. Mr. Merrick, the attempted mode of proof of that fact at any rate is not the common one. It is proposed that an expert may take these papers, which do not purport to have been written by the defendant, and which it is not pretended are in the similitude of his handwriting, and may testify whether they are or not of his writing. It will be attempted to be shown by this expert, I presume, that they may be, or actually are, his, by analyzing the letters and tracing the form of particular strokes of the pen, so as to connect the character of the manuscript with his. And now when we say that all experimental proof of handwriting by opinion is of the weakest and most questionable kind of evidence, we submit whether it will not be an extension of the rule to permit experts to testify in the manner proposed. The Attorney General. I find that my friends on the other side confine their remarks to one particular letter, which is of a peculiar character. I ought to have added, when I was up just now, that we expect to show that that document could not have been written by a pen. We also expect to satisfy the jury from the testimony of Mr. Gould that it could only have been written by an instrument which was found in the private room of Dr. Webster. This presents another ground for the proof of that particular document in the manner in question. Mr. Merrick, I have only to say that we do not object to the rule which has been heretofore adopted. It is only to its further extension. With respect to the last suggestion, I have no opinion to express. Whether an expert can or cannot prove that a writing was produced by some other instrument than a pen. Certainly the witness has not yet laid the foundation for the expression of any such opinion by showing a knowledge or skill upon the point. The Chief Justice. We do not see that the precise point presented gives rise to the objection which has been taken and discussed. The witness was asked whether he had a personal knowledge of the defendant's handwriting, and he has stated that he has. His experience qualifies him to say this. Papers have passed under his notice in a business or official capacity, which have given him a long and familiar acquaintance with the defendant's handwriting, and he seems, therefore, confident to give an opinion in regard to it, independent of any skill of his own as a penman, or as a judge of penmanship. In regard to the term handwriting, we think that it should include generally what the party has written with his hand, and not merely his common and usual style of chirography. This question of proof of handwriting most commonly arises, and is discussed in cases of forgery. But there are other cases where the evidence of experts is applied to handwriting. One is in prosecutions for threatening letters or for arson. There, the question is generally made that they are not genuine on the part of the person purporting to send them, but simulated and disguised, and the proof shows that the writer did not seek to imitate a hand but to depart as far as possible from his own. The evidence has always been considered admissible in those instances. How much further the counsel for the government mean to go, here we do not know, but at the present we think that the letters may be put into the hands of the witness for the purpose of allowing him to say whether they were, or were not, written by the defendant. Mr. Bemis, state then whether you can recognize the handwriting of this letter, showing Civis' letter, and whose, in your opinion, it is. State also your reasons for your opinion. Mr. Gold, I think it is in Dr. Webster's handwriting. In giving my reasons for my opinion, there are some circumstances which may appear trifling to a person who has not attended to the subject, but yet I consider them important. When anyone undertakes to forge a hand, there are only two ways in which he can do it. Mr. Merrick, did I understand the court that the witness could go farther than give his opinion? Or is he to state the grounds and reasons for that opinion, which will involve the whole point in issue? The witness has stated his belief that this is the handwriting of Dr. Webster, and he suggests that it is a delicate theory by which he may be enabled to explain it. This is somewhat peculiar and different from the ordinary practice. The Attorney General. If you will allow me, I will make one suggestion more. I suppose that the witness, so far as he is introduced here as an expert, stands precisely upon the footing of any other expert, like Mr. Tyler, the twine manufacturer, for instance, who was examined yesterday. If so, then he is to state the foundations of his opinion like any other expert. The delicacy of the theory, as it is termed by the learned counsel, may be a matter of opinion. It may be that this delicate theory will be made so perfectly transparent by the witness as to satisfy every mind that it is palpable and clear in the nature of things, and that I suppose is for the jury to decide, and not to be predetermined here. I trust that the witness will be allowed to explain the grounds of his opinion. The Chief Justice. I do not understand that there is any theory to advance. It is an opinion upon the question of handwriting. The witness has stated that he believes it to be the defendant's, and we think that it is perfectly competent for him to point out the circumstances which constitute the grounds of that opinion. Mr. Bemis. I suppose that it will be competent for the witness to make use of one or more of the genuine letters in the case as a means of explanation of his opinion. the Chief Justice. That would be a subject for consideration hereafter, if necessary. Mr. Bemis, state the grounds of your opinion, then, that this is in Dr. Webster's handwriting from your own personal observation of it. Mr. Gould, it is impossible for me to explain the reasons for my opinion without going into some particulars which may seem very trivial, but which are absolutely necessary for my purpose. In all the practice that I have ever had in writing, I never have been able to satisfy myself that I could make two letters precisely alike, so perfectly similar as to correspond throughout, if placed one upon the other. And yet, I never saw two handwritings which I could not distinguish. When I have had a large number of scholars in writing, I have always been able to tell which of them wrote the specimens exhibited to me. There is some peculiarity in everyone's writing which enables the person to identify it, and it is next to impossible to get rid of that peculiarity when the attempt is made to disguise it. I should be very glad to answer only yes or no, but I can only point out those similarities of handwriting inquired of in my own way. Every man who undertakes to disguise his hand must do it either by carelessness or by carefulness. By carelessly letting his hand play entirely loose, as in mere flourishing, or by carefully guarding every stroke which he makes in order to prevent its being seen to be his. In this latter mode, it is next to impossible for any person to continue his observation for any great length of time, or through any considerable amount of writing, without which are peculiar to himself or making them in that peculiar manner which he has been accustomed to. Frequently, these will consist of only a single particle or character, but which will yet furnish a key for detection of the real writer. I have already examined and acquainted myself with the specimens put into the case. They have been submitted to me some time since for examination. I have no doubt that the Civis letter was written by the prisoner, also the captain of the Dart letter, also the East Cambridge letter. This last was not written with a pen. It could not have been. It was done with something soft. The top of the letter shows this. It could not have been done with a brush, for a brush does not begin a stroke in that way. Mr. Gould here explained at length the reasons for his opinion. The two promissory notes were handed the witness, and he was asked in whose handwriting were certain words on them, which the witness more fully particularizes in his answer. Mr. Gould, the two words, paid, written across the face of the large note, the $2,432 are in the defendant's handwriting. So is the memorandum on the back of the $400 note, in pencil. $483.64 balance paid November 22nd, 47. The erasures or dashes on the face of the two notes and over the signature could not have been made with a pen or with anything that had a point to it. They have none of the characteristics of penmanship about them. They are the same indications of the tracing of some fibrous substance in the ink as in the East Cambridge letter. George G. Smith, am an engraver and have been called frequently to give an opinion of handwriting as an expert in court. Am acquainted with the defendant's signature from seeing it appended to medical diplomas. Have also received notes from him in former years. In regard to the Dart letter, I find certain peculiarities as in the other. Think that it might be his, but cannot speak of it with any great degree of confidence. Of the East Cambridge letter, I only speak with the same degree of confidence as of the last. The Civis, Dart, and East Cambridge letters are in the prisoner's handwriting, in my opinion. I am confident as to the first. Mr. Bemis said he could call a single additional witness of whose testimony he had only recently been apprised, and who had arrived in town from the interior of the state since last night's adjournment. Fisher A. Bosworth, am a physician of Grafton, attended medical lectures at the Medical College in Boston during the winters of 1847 and 1848, knew Dr. George Parkman, and also Littlefield, the janitor. Had occasion to call at the Medical College on 23rd November between 1:30 and 2 o'clock. Found the door ajar. Met Dr. Parkman coming round the corner of the steps very fast, on his way up to the front door. Turned my head and saw him nearly at the top of the stairs. About 3 o'clock went back again to the college, rang the front door bell, and inquired of Mr. Littlefield if Mr. Cawthorne, a student whom I wished to see, was there. He replied that he was probably in the dissecting room. Found Mr. Cawthorne there. Opening of Mr. Sohere for the prisoner. Mr. Sohere: May it please your honor and gentlemen of the jury, I am aware that it is usual, perhaps it may be considered as imperative upon the counsel, in a case like this, to call the attention of the jury to the situation of their client, and to comment in strong language upon the importance, the vast importance, of the interest which he has at stake. But, gentlemen, I shall not do this. I cannot do it. I fear much, gentlemen, that, should I permit my attention here to wander from the cause to the party, from the record to the dock, I might be lost. I might perchance perceive nothing but the man who, for more than a quarter of a century, has been a respected professor in that university which is the pride of our state, a respected lecturer in that college which is one of the boasts of our city, the man under whose instruction many now present at this trial were educated, myself among the rest. I should see him struggling for his life, struggling for his reputation, struggling to avert infamy from himself and from his children, in that self-same dock where we have been accustomed to see felon after felon, to abide the judgment of the law. I might think of these things, gentlemen, and I might wander from the case. I must, on the contrary, rather follow, though necessarily it needs must be at a long and humble distance, in the footsteps of the eloquent counsel who opened this case in behalf of the government. And I must allude, gentlemen, briefly, to our duties here, to our relative situation and relative responsibility to the cause, the rules of law applicable to the charge involved in it, and the rules of evidence as applicable to its long details of circumstantial testimony. We are here, gentlemen, as the learned counsel told you, in the discharge of our various duties as officers and as ministers of the court, to discuss and determine that one great question which, for months, has absorbed the attention, has agitated to the very lowest depths the feelings of a great community, to wit, is the life of Professor Webster, now the prisoner at the bar, forfeited to the laws of his country upon the ground, and for the reason that it has been proved here beyond a most reasonable doubt that he has been guilty of one of the most horrible offenses that can be found in the long dark catalogue of crime. A grave and serious duty has devolved upon us, has devolved upon you, the judges, and upon us, who represent him in this more than mortal struggle. It devolves upon you to say whether Professor Webster shall depart hence to his family, and there remain, what he has ever been to them, the very center of their affections, the very object of their idolatry, or whether he shall depart hence to the scaffold, leaving to that family a name which they would prefer to bury in the grave, which they would conceive to be their greatest curse, their only disgrace. Yet it does devolve upon you to say whether the fire upon his hearthstone shall burn brightly, or whether your breath, Mr. Foreman, when you pronounce the verdict, shall extinguish that fire so as to cause all its ashes to be scattered to the winds, to be forgotten in kindness by his friends, and in mercy by his enemies. This duty does devolve upon you, and if you err, you see the victim. He it is, and his is the family, who must be offered up as an atoning sacrifice to that error, unless indeed you err on mercy's side, upon the side of that quality in which it is permitted man to approach nearer than in any other to the nature of his God, on a side where no prison is groan, no widow's sob or orphan's tear bears witness to it. And here only, is your lot happier than ours. If we err here, we can err in no safe place. We must answer to the prisoner and his friends. We must answer it to an exacting and scrutinizing profession. We must answer it to our consciences. There is no place for us to err in. There is a place for you. Standing then as we do, and as you do, engaged in one and the same duty, to wit, in examining, discussing, and deciding this great question, it behooves us to stand in no antagonistic position to each other, but on the contrary, to aid and assist each other, so far as in us lies, and as we can truly do it. Ill would it become us, by any management and chicane, to obtain a verdict in this case, and ill would it become you to permit this defendant to suffer by any error of ours. It is your duty and your right and privilege to constitute yourselves the counsel for this defendant, to see that he has the benefit of everything that could be urged in his defense, to see that he shall have the evidence presented in every possible view that can be taken of it, whether we assume those views or not. And it is your duty to remember, and never for a moment to forget, that, in the words of your oath, it is this defendant whom you have in charge. Yet it is not this defendant only, but this defendant's family whom you have in charge. And here I pray that you will allow me to make a few remarks upon a subject I would not address men like you upon, on any less important cause, or any less momentous occasion. But in the name of this defendant, and all that he has at stake, I must entreat you to commence the examination of this case, by examining your own minds, and that you do it with a strong, settled, stern determination to eradicate everything that partakes aught of prejudice, or savours of suspicion. I remember well that, before you took your oaths of office, by virtue of which the law has permitted you to exercise this trust, you each said that you were not sensible of prejudice. But can you say so now that we stand at the end of this week of testimony, which the government have been pouring in upon us? Are you sure that you ever could say so, without an accurate and scrutinizing examination? What safety is there in the fact that a man is not sensible of prejudice, when we all know that it is the very essence and the very quality of prejudice to lurk unseen in the mind of man, blinding his perceptive faculties, weakening his reasoning powers, distorting his judgment, so that the very source to which we look for safety and protection becomes a source of ruin? There is no safety in the fact that a man is not sensible of prejudice, and I ask you to commence the examination of this case by discarding prejudice. No man can be safe without seeking to remove it. Why? If prejudice exists in a single mind, it is contagious. It is communicated by the intonation of the voice. It flies from eye to eye, and is imparted, as by an electric shock, from hand to hand. And there is no safety. We ask you then to search for it, and to extirpate it. As between the prisoner and his jury, as between man and man, speaking as between friends, I do not pretend to any that we have felt, or can feel positive, that there is no man upon your panel untainted by prejudice. By no means are we to forget, gentlemen, or are we to suppose that you have forgotten the great excitement which existed in this city when it was first bruited abroad that George Parkman was murdered. Do we now forget that men then quit their avocations, that they were clustered together in the corners, in the doors, in the stores, the houses, and the churches, and that the conversation was upon this one point, and upon no other? Have we forgotten the great indignation that was excited in this community, so creditable to the community, but so dangerous to the defendant, when it was first announced that his body was found in the medical college, in the laboratory? Have we forgotten the prejudice against Professor Webster? Have we forgotten these things? By no means. They are burned into our memories, and we shall not forget them. Are we to say that it is a certain and fixed positive fact that there can be no prejudice? By no means. And therefore it is that after you have heard and listened to the government evidence, we ask you, in the name of the defendant, to examine your minds, and to examine his side of the case free from all taint of prejudice. I have thought, gentlemen, that in opening this case, I might perhaps the best diminish the labors of the closing counsel, instead of stating to you minutely or in detail the circumstances which we intend to prove here in defense, by calling your attention first to the rules of law, which are descriptive of the offense charged. What it is, gentlemen, what the definition is of the offense, as the government have charged it against him. End of section 19. Section 20 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 10. Secondly, that I should call your attention to the rules of law, as applicable to the manner in which that offense is charged, that is, to the indictment. Thirdly, gentlemen, that I should call your attention to the nature of the government's evidence, and to the rules of law applicable to that kind of proof. Then, gentlemen, that I should state to you with great brevity, and merely by scheduling together in heads, what the facts are which we intend to give in evidence, which facts, when proved, taken in connection with such of the government's facts as you shall conceive to be entitled to credit, on which you can rely with any confidence, will constitute the entire mass of evidence on which you will eventually have to pass. First, then, with regard to the rules of law which describe the offense charged. The offense charged here, gentlemen, generally is murder. That is the offense charged in the indictment, the murder of George Parkman. We then wish to inquire and ascertain what are the rules describing this offense, so that we may know when it has been proved and when it is left in doubt. Murder is a division of homicide, the word homicide extending to every possible killing of a human being. If a man is killed under any circumstances, anywhere, or by anybody, the word homicide covers that act. A homicide must necessarily at once be divided into two great divisions. First, that which is criminal, and therefore punishable. Secondly, that which is not criminal, and therefore which is not punishable by the law. Now, the criminal homicide, which is the only species of homicide with which we now have anything to do, is divided into two parts, into two divisions. First, murder, which is punished capitally by the death of the offender. Secondly, manslaughter, which is not punished capitally, but which is punished ignominiously, though not with death. These two divisions constitute homicide. Now, inasmuch as this indictment charges Professor Webster with murder, and inasmuch as it is always competent for a jury to acquit of murder and convict of manslaughter, or acquit of both, every man who is indicted for murder is in the same position as if he were indicted twice, first for one offense and then for the other. The first question is, what is murder, taking it by itself? The second question then will be, what is manslaughter, taking that too by itself? Murder is defined to be the killing of any person with malice, prepense, or forethought, either expressed or implied by law. Two things are necessary to constitute murder. First, the killing. Secondly, malice. And this definition is precisely no definition, because it gives you no idea of what is intended by the word murder, unless you have an accurate and well-defined idea what the meaning of the word malice is as used in this connection. Malice is divided by all criminal writers into two counts. First, what is called expressed malice, and secondly, malice which is implied. Those are the definitions of the word malice. Express malice. When we use that term, we mean what is always meant by malice in its common outdoor use. It means a wicked disposition and perverse mind, which does induce a man, or may induce him, to commit a certain act. Express malice, says the books, is when one person kills another with a sedate, deliberate mind and well-formed design, such design being evidenced by the noticed actions, antecedent menaces, former grudges, and an attempt to do great bodily harm. This is easily understood without being dwelt upon at the bar. We come next to what is meant by what is called implied malice, and here the definition is not so easy. Implied malice is where the malice is implied by the law. Now, it is a theory of the law that it punishes not so much the overt act as it does the wicked and depraved mind which prompts to that overt act. It punishes the mind in the wicked and perverted intention as much as it does the overt act. But you will ask at once, how is the law to arrive at the mind of man? How shall it dive down into the hidden recesses and bring up the malice? It cannot do it, except by judging of the mind by the acts, considering them to be the fruit of the mind. Then, gentlemen, by the fruit, the law undertakes to know the mind. The law then, gentlemen, has adopted certain acts which it alleges to be, and assumes to be, evidence of latent malice. The law says that when certain acts, and we now confine ourselves to homicide, when a homicide is committed in a certain manner, under certain circumstances, malice shall be implied from the act, and that is the mode in which the law arrives at this matter of implied malice. When we undertake to define it, all that we can say is that when certain acts are committed in a certain manner and with certain means, then the malice is implied. If we would know what it is, we must ascertain what are the acts and the circumstances. What are the acts? We must arrive at what the malice is by saying what the acts are from which it is to be inferred. What then are the acts from which the law will imply malice in this matter of homicide? For we are to consider only this one single matter, malice in homicide. Malice, gentlemen, is implied by law from any deliberate and cruel act. I pray your attention to these words: from any deliberate, cruel act committed by one person to another, however sudden. Therefore, where one person kills another suddenly without any or without considerable provocation, the law implies malice. Malice is inferred from a deliberate and cruel act, as where one kills another without any or without considerable provocation. When, therefore, you ask what malice is implied by law, you must look at the acts from which the law says malice is to be defined, and that is the only way in which it is to be defined. A deliberate, cruel act, without any or without considerable provocation, and then the law is that it is to be implied malice. That is the definition which I shall state to you for the purposes of this trial. Having stated this, you see shadowed out at once the real distinction between implied malice and manslaughter, for one is almost the reverse of the other. Murder from an implied malice is a deliberate and cruel act, without any or without considerable provocation. Now manslaughter, as I have shown you, is the reverse. Manslaughter is not deliberate. It is a sudden act. It is not a cruel act, but it is done in the heat of blood. Manslaughter is not without provocation, but with it, and therefore, in terms, is most distinctly the reverse of murder from implied malice. Whenever death ensues from sudden transport and without malice, or if upon sudden combat, it will be manslaughter. That, gentlemen, is the definition of manslaughter, and here is shadowed out the line between the two. One is considered deliberate and cruel, without provocation. The other is inconsiderate, sudden, in the heat of blood, and with provocation or sudden combat, one of the two. Now this may be a very narrow line of distinction, but it is not to be lost sight of by a jury. For on one side is life, on the other death. Life, it may be, encumbered with long and severe punishment, but still it is life. Life which is clung to, life rendered radiant with hope. And though this line may be a narrow line, And though the circumstances may fade into each other, they are not to be lost sight of. And as one is deliberate, cruel, and without provocation, the other is hasty and hate of blood, and with provocation or sudden combat. Thus much, gentlemen, for murder from implied malice, and thus much for the general definition of manslaughter. But, gentlemen, it is necessary to go a little further here, as I have undertaken to give a definition of both of these offenses. The law states, as I have already remarked to you, that manslaughter is in the heat of blood, with reasonable provocation. Now the question arises, what is sufficient provocation to reduce a murder to a manslaughter? What does the law deem to be a reasonable provocation? To answer this, we must go to the books, and it is easy to answer from the books, because the different acts of provocation have been well known and long defined for numerous years. In ascertaining, gentlemen, what is deemed to be a reasonable provocation, the law always regards the weapon or the instrument with which the homicide is committed, for you will see at once that one kind of provocation might be considered sufficient to excuse a blow with one weapon, which may be very insufficient to excuse a blow with another. The provocation that might excuse a blow with a stick might be insufficient to excuse it with an iron bar. In considering what is a reasonable provocation to extenuate the murder into manslaughter, it is necessary to ascertain what the weapon is, because from the weapon the provocation is to be estimated. Now, when we speak of deaths by a weapon, they may be divided into death from two general classes of weapons, those which are likely to produce death, and those which are not, those which are deadly, and those which are not. Now, that is the question raised at once. What is considered a reasonable provocation to reduce a homicide from murder to manslaughter, where a deadly weapon is used? And then, what is a sufficient provocation to reduce it where a weapon not deadly is used? I am dwelling upon this in regard to the manner of death, because by and by it will become material when it is necessary to speak. When we come to speak of the indictment, it may be essential to our positions by and by. What is a reasonable provocation for the use of a dangerous weapon, and then for a weapon not dangerous? I will answer that first question from a book, and I read from East's plea for the Crown. Any assault made with violence or circumstances of indignity upon a man's person, as by pulling him by the nose, if it be resented immediately by the death of the aggressor, and it appears that the party acted in the heat of blood upon that provocation, will reduce the crime to manslaughter. Take Lenoir's case, as it is called, where a person was riding upon a highway and another individual whipped his horse out of the track. Then the rider killed the aggressor. That was considered as manslaughter, because the rider was considered as having reasonable provocation. I will also refer to Taylor's case, the same chapter. 3 Scotch soldiers were drinking together in a public house. Some strangers in another box abused the Scotch nation and used several provoking expressions towards the soldiers, on which one of them, the prisoner, struck one of the strangers with a small rattan cane, not bigger than a man's little finger. The stranger went out for assistance, and, in the meantime, an altercation ensued between the prisoner and the deceased, who then came into the room and who, on the prisoner's offering to go without paying his reckoning, laid hold of him by the collar and threw him against a settle. The altercation increased, and when the soldier had paid the reckoning, the deceased again collared him and shoved him from the room into the passage. Upon this, the soldier exclaimed that he did not mind killing an Englishman more than eating a mess of cowdrey. The deceased, assisted by another person, then violently pushed the soldier out of the house, whereupon the latter instantly turned around, drew his sword, and stabbed the deceased to the heart, adjudged manslaughter. That illustrates the position. An assault here existed, turning him out of the house, upon the heat of blood occasioned by this assault. He killed his opponent, and it is held to be manslaughter. I state these as among the provocations to reduce the offense to manslaughter, if the homicide is committed with a dangerous weapon. The next question is, what is considered a sufficient provocation for a homicide which is committed with some weapon not likely in itself to produce death? The whole doctrine is summed up in East, chapter 5, section 20. Words of reproach, how grievous soever, are not provocation sufficient to free the party killing from the guilt of murder, nor are contemptuous or insulting actions or gestures without assault upon the person, nor is any trespass against lands or goods. This rule governs every case where the party killing, upon such provocation, made use of a deadly weapon or otherwise manifested an intention to kill, or to do some great bodily harm. But if he had given the other a box on the ear, or had struck him with a stick, or other weapon not likely to kill, and had unluckily and against his intention killed him, it had been but manslaughter. And this, gentlemen, is the answer to that question. What is reasonable provocation? Always look at the weapon. If it is a deadly one, it must be an assault upon a person. If not a deadly one, words, actions are sufficient to produce it. The next question is, what is meant in the law by sudden combat? For the rules state this: manslaughter is a killing on reasonable provocation or on sudden combat. What then is sudden combat, as it is stated? I will answer by reading from the same book, section 24 of the same chapter. There are cases where, upon words of reproach, or indeed any other sudden provocation, the parties came to blows and a combat ensues, no undue advantage being taken or sought on either side. If death ensue, this amounts to manslaughter, and here it matters not what the cause be, whether real or imagined, or who draws or strikes first, provided the occasion be sudden. It is thus, gentlemen, that if two persons get into what is called a combat with each other, no matter which begins it, if they get into the combat and then being heated by the combat, one kills the other, then the law considers the frailty of human nature, and under such circumstances, the offense is reduced from murder to manslaughter. An example is given. A uses provoking language towards B, who thereupon strikes him, and a combat ensues, wherein A is killed. Held manslaughter, but was a sudden affray, and they fought upon equal terms. But this has nothing to do with it except when they commence. If they get excited on equal terms, and they commence their quarrel with the fist, and afterwards have some other weapon, it is excused, as caused by heat of blood, excited by the quarrel. This is stated perhaps a little stronger in Whitley's case, which I cite from Lewis's Report 175, in which the justice says, when persons fight on fair terms and merely with fists, where life is not likely to be at hazard, and the blows passing between them are not likely to occasion death, if death ensues, it is manslaughter. These authorities which I have stated show the real distinction between murder from implied malice and manslaughter, the one being, as I have said, the reverse of the other, one being voluntary, deliberate, and without provocation, the other being hasty and on provocation, or with a sudden affray, the provocation being in violent assault when a deadly weapon is used, the provocation being words, when a weapon not deadly is used, and when, they being excited by the combat, one chances to destroy the other. These are the definitions which I bring to your mind. Professor Webster stands charged with murder and manslaughter. If he committed the murder, it must have been either express or implied malice, or that he killed him in a deliberate and cruel manner, without reasonable provocation, malice being judged of by the manner and the want of provocation, and the provocation being judged of by the weapon, and hence follows the extreme and vital importance in a case of this kind, of the government's alleging and proving the manner beyond all reasonable doubt, for it is the manner of death, the manner in which the homicide is committed, which creates the crime of murder, from which all the distinguishing marks are to be drawn between murder and manslaughter, and therefore it is that I have been over this, that we may bear it in mind, and apply it when we consider this part of the case. When the government say that Professor Webster killed Dr. Parkman with implied malice, they say he killed him cruelly, deliberately, and without provocation, and this is to be judged of by the manner. When the government says that he committed the act of manslaughter, then it virtually alleges that he killed him not deliberately, but in heat of blood, and with some provocation. And there, gentlemen, as we apprehend, is the definition, and this is a statement of the rules of law, defining the various offenses which are embraced virtually under this indictment. I come then, gentlemen, to state what we conceive to be the rules of law applicable to the manner in which the crime shall be charged. That is, the rules of law applicable to the indictment. In examining in criminal cases, it is essential that the jury should bear in mind not only what the rules are defining the offense charged, but they should bear in mind particularly and strictly what the various particulars of the offense are, which is charged, not only what the offense is in general, but what the particulars of the offense are. Gentlemen, it is to be borne in mind, and this is the rule of law which is essential absolutely to the safety of everyone, that it is a matter of no consequence how many crimes a man has committed, if he has not committed the particular crime set forth in his indictment. It is a matter of no consequence if he has committed the crime charged, if he has not committed it by the means charged. This is the position which we take, and it is a rule of law intended for the protection of the citizen. And if it is broken in upon, man has no safety. If a man is to be tried for particulars of offense, or for an offense in which the facts are erroneously set forth, no man can provide for his defense. And therefore, it is that no man shall be tried for any offense, unless that offense is fully, substantially, plainly, formally set forth. Not only must the statement be full, but it must be plain, so that everyone shall understand it. Not only must it be substantially, but it must be formally made. If this rule is departed from, there is no safety for anyone. It is essential that we should examine this indictment, and it is essential that we should understand precisely what it is that the government undertakes to charge the defendant with. What are the particulars of the offense which Professor Webster is now set in the bar to answer? These particulars must be fully, plainly, substantially, and formally set forth, and I must, therefore, ask your attention to the indictment. This indictment contains 4 counts, that is, it is set forth in 4 distinct forms the charge, and the government are at liberty to prove any one. First, the allegation is that the prisoner, Professor Webster, killed Dr. Parkman by striking him with a knife. Secondly, that he killed him by striking him with a hammer. Thirdly, that he killed him by striking him with his fists and his feet, and striking him against the floor. Fourthly, that he killed him in some way or by some means, instruments and weapons to the grand jury unknown. Now may it please the court and gentlemen of the jury, I must ask your attention to the rules of law applicable to this indictment, and I shall in the first place ask your attention to the rules of law, as I conceive them to be applicable to the 3 first counts, which can all be readily considered together. In an indictment for murder, gentlemen, it is an imperative rule that the means of death shall be accurately described, and when we say that a thing is to be accurately described, we mean that the government shall prove it as they have described it. They shall state the means of death accurately. That is to say, their proof shall sustain their statement of the means of death. End of section 20. Section 21 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 11. Now I ask your attention to another position. I understand it to be a well-settled rule of law that there are certain means by which human nature may be overcome, which have been settled and adjudicated by the law to be totally separate and distinct from each other. One very large class of means of death is embraced under the head of striking with a weapon. Another class, gentlemen, very distinct upon authority, is striking a man against an object. That is another class as I apprehend. And there are various other means of death, well distinguished from each other, such as poisoning, strangling, burning, starving, and others. I put this by way of illustration, and I put the position that these particular means of death are distinct and separate from each other, to wit, striking a man with a weapon, striking a man against an object, poisoning a man, strangling a man, burning him, starving him, drowning him, and the like. They are separate and distinct means of death. Whichever of these means which I have mentioned, and you will notice I say means, whichever of these means the government see fit to adopt, and charges the means used, the government is bound to prove and prove beyond reasonable doubt the particular means. Now, under this class of means, as I call it, producing death by striking, it is usual for the government to allege some particular weapon, but it is not necessary that the particular and expressed weapon should be proved. Any weapon which will produce death by the means stated, that is to say, by the striking, would answer in proof instead of what the government charge. For instance, suppose the government charged that the man produced death by means of striking with a knife, and it turns out that he struck with a hatchet. It is sufficient, because the means, the class, is spoken of, and if it turns out that it is produced by some other weapon, the case is made out. For instance, the government charged Professor Webster with striking with a knife, and it turns out that he actually produced death by a hammer. The case is proved. But if they charge that he did it in a separate manner, to wit, by strangling, or by seizing a man, and striking him against a door, and the death is produced, as before, by the blow of the hammer, the indictment would not be sustained. The weapon is of no consequence, but that such a means were used is of consequence, and must be proved. I refer to Kelly's case, Moody's Crown Cases, page 113, also to Thompson's case, 139. An indictment for murder or manslaughter, when the cause of death is knocking a person down with a stone or other substance, and the mortal wound is from the stone or substance, the charge should be accordingly. A charge that the prisoner struck a mortal blow will not be sufficient. Also in Thompson's case, the indictment stated that the prisoner assaulted the deceased and beat him on the head. The evidence was that the prisoner knocked the deceased down with a blow on the head, and the mortal wound proceeded from the ground. The learned judge thought the case did not come within the indictment. I will also refer to another case, to Martin 5, page 128. In this case, the other two cases which I have cited were confirmed. Here a man was indicted for producing death by striking. The charge was that the prisoner willfully struck him with a hammer. The kind of instrument is not material. The truth was, there was doubt whether the death was produced by being struck against the door or by the hammer. The judge ruled that there was nothing in the count about being struck against a door, and unless the jury was satisfied that the death was produced by the blow and not by the door, the indictment would not be sustained. Unless the government proved the means asserted, it don't prove the indictment. The law, as I understand it, is that the particular means stated must be proved to the satisfaction of the jury. Now then, gentlemen, putting our attention to those first two counts, the government alleges that death was produced by striking. What becomes of their evidence? The government alleged in the first two counts, and therefore the government must prove that the killing, here in this case, was by striking with some weapon or other. In the third count, the government, if they rely upon it, assert that the striking was with hands, or fists, or beating against the floor, And that is precisely what the government must sustain upon this count. I come now to the fourth count. We shall submit here, if it be regular in this part of the case, that this count, may it please your honors, is totally insufficient and ought not to be considered by a jury, and that the government had no right to introduce any proof under this count. That is an insufficient count. And in the second place, if the government have a right to introduce proof until it, still, they have not introduced it at all. This count states, as I have said, that the death was produced in some way or manner, and by some means to the jurors unknown. Now we shall submit that there is no precedent whatever for any such count, and if there is no precedent for it, the precedents are all against it. There is no authority for it which we have been able to find anywhere, and the authorities are directly against it. I will cite, may it please your honors, in the first place, from Hale's Pleas of the Crown, page 185, an indictment of murder or manslaughter hath these certainties or requisites to be added to it, more than any other indictments, for it must not only be felony se, and ascertain the time of the act done, but must also declare how and with what it was done. Yet, if the party were killed with another weapon, it maintains the indictment. But if it were with another kind of death, as poisoning or strangling, it doth not maintain the indictment upon evidence. The same doctrine is laid down in Hawkins' Pleas of the Crown, Book 2nd, 8423. The doctrine is laid down in these words: if the killing were with a weapon, the count must show with what weapon in particular. And yet, if upon the evidence it shall appear that the killing was not by such a weapon, but by some other, the variance is immaterial, and the appellee ought to be convicted, as shall be shown more at large under the chapter of evidence. And if the killing were not by a weapon, but by some other means, as by poisoning, drowning, suffocating, burning, or the like, the count must set forth the circumstances of the fact especially, as the nature of it will admit. East Pleas of the Crown, C5, section 107. It is essentially necessary to set forth particularly the manner of the death and the means by which it was effected, and an omission in this respect is not aided by a general conclusion from the evidence that he was murdered, etc. The count, may it please your honors, now under consideration is clearly distinguishable from the count made use of in the case of Colt. There is one of the counts which charged that the crime was committed, in the first place, by striking the deceased with a hatchet, and another count charged it to have been committed by striking and cutting him with a certain instrument to the jurors unknown. This case comes nearer to disproving my position than any before the court, but the means of death are stated, and the means are, to wit, striking with the instrument which is alleged to be unknown to the jury, and the instrument is immaterial. If it be a striking instrument, he might have struck him with a ramrod, and it would make no difference. The distinction between our case and that is that the means of death are clearly stated, but the instrument is stated to be unknown, and we apprehend, may it please your honors, that this mode, which the government have adopted in the fourth count, of alleging an indictment would give rise to great confusion. We apprehend that it might contravene many established rules. Why, under a count of this kind, may it please your honors, there may be an indefinite number of issues tried. Killing in every possible way in which human life may be taken may be tried under an issue of this kind. We submit, then, so far as one of these counts is concerned, that it is imperfect and insufficient, for the reasons that I have stated to the court, in regard to the three others. The first two allege a death by striking, the third a death produced by striking with hands and feet, and beating against the floor. Now then, gentlemen, the question presented to you is this: has the government proved beyond reasonable doubt that Professor Webster destroyed George Parkman by striking him with a weapon? That is the point. The government must prove the killing by the means stated. That is the first proposition. And if the killing is proved by the government to be in any other mode, then they fail upon their own proof. And if the jury, upon the evidence, are left in doubt whether the killing was produced by the means stated or by some other means, then they are bound to acquit under their oaths, because it is the right of the defendant, it is his right and privilege, and it is every man's right and privilege, to have the government held strictly and distinctly to prove what they allege, in all its material particulars. Here they allege, in these two counts, a striking by a weapon. If they fail in this, there is an end of the case. If you are left in doubt, there is an end to this case. If you believe that he killed him in this way, but you are left in doubt, then you are bound to acquit him. This is no hardship upon the government. The government may allege as many counts as they choose. They may bring forward charges of death committed by burning, strangling, poisoning, or in any other way. They never need suffer from the privilege which they have to give in stating the means. But then the law holds them to prove some one of the means alleged, and if they fail in that, they fail in their case. To recapitulate that point, to convict on these first two counts, you must be satisfied, beyond reasonable doubt, that the death was produced by the means of striking. Under the third count, that it was produced by means of striking with the hands and fists, and beating against the floor. And we shall submit to you that, with regard to that point, there is not a tittle of proof. I do not suppose that the government will contend that the death was produced in that way, and I apprehend that we might pass from that and carry you more particularly to the first two counts of death by striking, because on those the government have produced some apparent proof. I say that these counts are to be proved here, and proved beyond reasonable doubt, and this brings me to the third statement which I intended to make, what it is that the government must do to entitle themselves to a conviction, supposing the defendant introduces no proof whatever. What are the government to do, under any circumstances, to produce a conviction? They are to prove that Professor Webster destroyed Dr. Parkman, according to the allegations read over to you, and that he destroyed him by means of striking with a deadly weapon. And if they fail, beyond reasonable doubt, there is an end to the government's case. I say, beyond reasonable doubt, and as I am upon that point, I should like to dwell upon it for a moment. I am perfectly aware, gentlemen, that there is an idea abroad that this matter of reasonable doubt is something that the law accords to the prisoner as a gratuity, something that he is not entitled to, something by which guilty men sometimes escape punishment. But there never was a greater mistake in the world. This matter, that the government are to prove a man guilty beyond all reasonable doubt, is no privilege to the individual, for which he does not have to give full compensation. It is not accorded to him as a gratuity, and the examination of our criminal system showed that I am right here. Under different systems of law, different criminal codes are adopted. I have no doubt but that ours is as perfect as any. Look at it, and see how imperfect it would be if it were not for the checks put upon it. Every man must be proved to be guilty. What is our system? We take a man from his family. We arrest him upon the charge of a heavy, heinous offense. We lock him up in a jail, and while his mind is paralyzed by his physician, he is told to procure a defense, to proceed and prepare for his defense. What next? Why, ex parte proceedings go on. The matter is tried and adjudicated before a coroner's jury, where he is not present. It is afterwards tried before a grand jury, where he is not represented. An indictment is found, and then, with all this accumulation of public opinion necessarily formed upon these proceedings, he is brought into court and put upon his trial. How then is he placed? I am not taking the general position of a party. I am not referring to particular instances. How then is he placed, and what is his position? Why, he is placed at the bar. His mouth is shut. If he opens it at all, what he says is to go for nothing. and then witnesses are let loose upon him by the government. And who are they? In many instances, they are malicious, swearing on account of some old grudge. In many cases, they are interested, sometimes for rewards and property, interested sometimes in swearing of crimes from themselves, sometimes interested for still worse motives. Now, in this situation thus placed, and thus presented before a jury, what chance would many and many an innocent man have of an acquittal? It would be very small indeed were it not for checks and counterbalances, which we have provided in our system for him. And one of them is this same matter of reasonable doubt. The law says you may take a man in this way. You may lock him up. You may try him over and over again. You may put him upon trial. You may close his mouth. You may produce your witnesses against him. But here you shall stop. And if, with all this, you cannot prove him guilty beyond reasonable doubt, he is to be acquitted. This is all the protection that an innocent man has. You may, any one of you, be charged with an offense done when you are alone. You cannot prove that you did not do it. Persons will be mistaken about identity, but you can prove your previous character and that there is a reasonable doubt. You are, we say to the government, to prove your murder by your means, and beyond all reasonable doubt. And this is as much my privilege as you have the privilege of trying me, and at your particular leisure. And therefore, it is most certain and true that this matter of reasonable doubt, so far from being a gratuity to a defendant, is his right. It is what the law has provided for him as his shield. And though it may be that guilty men may occasionally take shelter under that shield, what does the motto say? But that 100 guilty would better escape than an innocent man be punished. The government are to prove it beyond reasonable doubt, and if they fail, there is an end to their case. It may be asked, what is a reasonable doubt? The answer is well stated in the first volume of Starkey. A juror ought not to condemn unless the evidence exclude from his mind all reasonable doubt as to the guilt of the accused, and as has been well said, unless he be so convinced as he would venture to act upon the conviction in manners of the highest concern to his own interest. It must be such a certainty then, gentlemen, that you would not hesitate to act upon it in manners of the highest concern to your own interest. It must be such a certainty, I contend, that you would act upon it if your lives depended on it, in the highest concerns of your own interest. If it be such a certainty that you would not venture your own life upon it, what right have you to venture his? You should be convinced, gentlemen, and convinced beyond a reasonable doubt. These remarks, gentlemen, bring me to the fourth head to which I said I should ask your attention, which was to the nature of the government's evidence and to the rules of law applicable to evidence of that kind. Evidence, gentlemen, so far as there is any occasion of dividing it, for the purpose of this opening, may be divided into direct and circumstantial proof. Direct evidence needs no explanation, and in point of fact there is none of it in this case, but merely for the purpose of convenience. I will say that direct evidence consists of this, where the testimony is derived from persons who have actual knowledge of the facts in dispute, from persons who have actual knowledge of the matter they come to prove. For instance, gentlemen, if a person comes here and swears he saw a certain transaction take place, there is direct evidence, and all the jury would have to inquire into would be whether they believed the man or not. If they believed him, there is direct evidence of a particular fact, which he is brought to sustain. But circumstantial evidence is, where a fact is attempted to be proved, not by anybody who saw it, not by anyone who knows it, but by proving in advance certain other circumstances and certain other facts, and then drawing a conclusion from those facts and circumstances that these particular facts which are endeavoring to ascertain exist. This is called circumstantial evidence, where the government, for instance, taking a case like this, where the government undertake to prove a certain fact, to wit, that a man was murdered. They bring nobody who saw it, but they go to work and prove a certain quantity of other facts. They may be many, or they may be few. And having proved those other facts, they say we draw a conclusion that the main fact was as they contend it was. That is, that the murder was committed. Now, gentlemen, as you see at once in this matter of evidence, there is no comparison between the strength of direct and circumstantial evidence. Circumstantial evidence is weak compared with direct, and for the reason that the opportunities for human error are multiplied. All we can do in the investigation of facts, all we can ever do, is to approximate towards certainty. Nothing human is infallible. On the contrary, everything is fallible. All we can do is to approximate, and we approximate near or at a distance, in accordance with the means we have at our command. Now, gentlemen, if a murder is proved by direct evidence, what are the chances of error? A man comes here and swears to a certain fact. What are the chances of a jury being led into error? The chances depend upon his lying. If he swears falsely, then we are misled. But he comes and swears to a solitary fact, but he is not likely to mislead us because it is so simple. Take a case of circumstantial evidence. The proof sometimes consists, as in this case, of numerous facts, of scores of facts. Every single fact is a distinct issue. Every single fact must be proved beyond a reasonable doubt. Very well. Here the chances of error accumulate. If they prove one fact by one man, he may lie. If they prove another fact by another man, he may lie. And so the chances of error multiply. And then, after all the circumstances are in, what do you do with them? Then you are to draw the correct conclusion from them. Human judgment is called in to draw the accurate conclusion from these facts. And here there is a great source of error. Circumstantial proof is exposed to error from beginning to end. Errors in testimony from which the circumstances are intended to be established. Errors in the inferences and conclusions which we draw from after we have collected them. Take the most simple case we can possibly put. Suppose a man is seen killed upon the sidewalk. Suppose the watchman comes and swears that he saw a man running away. A second swears that, the house being pointed out to him, he went in and arrested a man who appeared to be out of breath. A third comes to say that he afterwards found blood on some clothes belonging to the prisoner. Take the first witness. He may be mistaken about the man and about the house, and he may lie, through chances of error. The second may be mistaken about the man whom he arrested, or the house which he thought was pointed out, or he may lie. 3 more chances of error. And the third may be able to detect blood or not, and he may be mistaken about his statement whether the clothes were those of the prisoner, or he may lie too. Here are all these accumulated chances of error, and then when they are all proved, correct conclusions are to be drawn from them. It may be that he did commit murder. It may be that he was an innocent man who was running along that way. It may be that he ran away from terror at seeing such a blow struck. It may be he was a friend of the deceased. I put this as a simple case, and yet you see how great the chances of error are. But when you come to such a case as this, there is no telling to what a height those chances reach. It is, gentlemen, necessary also to remember, as I apprehend, certainly it is not the least important part of this evidence, that we are always drawing incorrect conclusions, and hence the number of innocent persons who have suffered from circumstantial proofs have lost their lives, so far as we can judge from cases made up from incorrect inferences, not so much from paucity on the part of witnesses, as from the incorrect inferences drawn by the jurors. Take that most common of all cases cited continually, where an uncle and a niece lived together, and the niece one evening was heard crying out, begging him not to kill her. On the next morning she had disappeared. He, being charged with the deed and being put to his wits' end, found another girl to simulate his niece. The deception was found out and the man was convicted and hanged. But it afterwards appeared that the niece came back, having only run away. Here were these circumstances laid before conscientious jurors, circumstances proved by conscientious witnesses, but they erred. He who is arrested with stolen goods in his possession has to answer for it. It implies a theft. There is an old and well-established case, in illustration of this, where a man who had stolen a horse got a countryman to hold him, knowing he was pursued. Presently, the constable came up and arrested the countryman. Here was a plain case. He was found with the stolen property in his possession immediately after the theft had taken place, and he was hanged for it. I am induced to dwell upon this for a moment because I am perfectly aware that there are certain opinions that circumstantial evidence is necessarily correct, and that circumstances cannot lie, and various other sayings that are totally false, sayings which probably apply to the circumstances in connection with which they were first mentioned, but by being stupidly repeated over and over again, have received the dignity of proverbs. The truth is that circumstances do not, but the witnesses undertake to prove them may lie, and the conclusions drawn from them by human judgments may lie, and it is all idle to suppose that there is any particular virtue in circumstantial evidence. But on the contrary, it should be remembered that it is always weak and uncertain. I will read, merely as a part of my argument, from Mr. Best's work on Presumptions of the Law, page 253, speaking on this very point and in regard to this prevalent idea, that circumstantial evidence is strong. He says, juries have been told from the bench, even in capital cases, that where a violent presumption necessarily arises from circumstances, they are more convincing and satisfactory than any other kind of evidence, because facts cannot lie. Numerous remarks might be made on this strange proposition. The first that presents itself is that the moment we talk of anything as a consequence necessarily following from others, all idea of presumptive reasons is at an end. Secondly, even assuming the truth of the assertion that facts or circumstances cannot lie, still, so long as witnesses and documents by which the existence of these facts is to be established can, so long will it be impossible to arrive at infallible conclusions. But without dwelling on these considerations, look at the broad proposition. Facts cannot lie. Can they not, indeed? When in order to effect the ruin of a poor servant, his box is opened with a false key, and a quantity of goods stolen from his master deposited in it, or when a man is found dead, with a bloody weapon lying beside him, which is proved to belong to a person with whom he had a quarrel a short time before, and the footmarks of that person are traced near the corpse, but the murder has, in reality, been committed by a third person, who, owing a spite to both, put on the shoes and borrowed the weapon of one to kill the other. Did not the circumstances lie? Wickedly, cruelly lie? There is a reason to fear blind reliance upon the dictum that circumstances cannot lie, as occasionally exercised a mischievous effect in the administration of justice. Another great cause, gentlemen, why circumstantial evidence is not to be relied on, to a great extent, is what is called a moral cause, that there is a well-known tendency of the mind, when great crimes are suspected, which leads witnesses particularly, and even jurors, to exaggerate facts, and to place great reliance upon their own shrewdness. This, gentlemen, is also alluded to in the same book from which I have quoted. I will read it as a part of my argument. Speaking on this very subject, Mr. Best says, there is an anxiety naturally felt for the detection of crimes, particularly such as are either very heinous or peculiar in their circumstances, which often leads witnesses to mistake or exaggerate facts, and tribunals to draw rash inferences. And there is also natural to the human mind a tendency to suppose greater order and conformity in things than really exist, and a sort of pride or vanity in drawing conclusions from an isolated number of facts, which is apt to deceive the judgment. Accordingly, the true meaning of the expression so frequently to be found in our books, that all presumptive evidence of felony should be warily pressed and admitted cautiously. So far, with regard to the government's evidence, in this case it consists entirely, solely, of circumstantial proof, and in many cases the circumstances relied upon are actually proved by other circumstances. It is undertaken to prove circumstances by circumstantial evidence itself, and who shall say to what extent the sources of error have thus multiplied? Owing to this known tendency of circumstantial evidence to mislead the mind, owing to the danger which is likely to arise, the law has adopted certain rules which are to govern and to guide juries in considering it. Some of these rules I shall call your attention to because I consider them pertinent. There may be others mentioned hereafter. The first rule which the law has adopted for the purpose of guarding, as far as possible, against error. As for guarding against it entirely, it cannot be done. There is no human tribunal where it can be guarded against. But to guard against error to some extent, certain rules of law have been adopted. The first rule I shall name is this. It is an established rule of law that every circumstance which is relied on must in itself be proved beyond all reasonable doubt. The first rule is that every single circumstance from which the conclusion is to be drawn must be proved in itself beyond all reasonable doubt. That, of course, shows you that every circumstance is a separate issue in itself. Every circumstance is to be proved beyond reasonable doubt, and that, you understand, means this. You must find that it is proved beyond all reasonable doubt when all the evidence is in, not that any one witness proves a point particularly, but when you come to consider all the evidence in the case, introduced by each side upon each point, you are to be satisfied of each individual circumstance, beyond all reasonable doubt. Therefore, it follows necessarily that if in a long train of circumstances upon which the case is hung up by the government, there is any one single circumstance which fails, there is an end to the whole case at once. They undertake to anchor their case by a chain of circumstances. If one link breaks by its own intrinsic weakness, or by any force which the opposite party brings against it, there is an end to the case. Secondly, gentlemen, the circumstances which are proved when you find that they are proved beyond reasonable doubt, those circumstances must establish to a moral certainty the particular hypothesis attempted to be proved by them. That is to say, if the government undertake to prove a certain fact by circumstances, and you are to consider it proved by an inference drawn from those circumstances, the circumstance must prove that the inference is correct. That is to say, not only the circumstance must be proved beyond reasonable doubt, but also you must be satisfied that the inference is proved beyond all reasonable doubt. And that is the second circumstance. Thirdly, gentlemen, the circumstances, and I pray your attention to this rule. These circumstances which are proved beyond reasonable doubt must not only support the particular hypothesis which the government intend they shall support, but they must not support any other hypothesis. That is to say, they must not only sustain the inference which the government draws from them, but they must exclude every other possible inference, because if a set of circumstances could establish two distinct hypotheses, and one is contrary to what the government assert, and the other in accordance with it, that is to say, if one is in favor of the defendant's guilt, and the other of his innocence, there is an end of their case. The jury are bound to take his innocence for granted, and it is from this rule's being disregarded being overlooked that a vast quantity of misery has been inflicted upon innocent people. I will refer to best upon presumptions of the law, page 282, the evidence against the accused. Mr. Clifford, I do not understand that work is authority in these courts. I have not been much in this court, but I suppose that this is the work of a very extravagant man, and I do not know that it has been passed upon by the court. End of section 21. Section 22 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 12. Mr. Sohere, it is a work that has been cited here very often, and I am not sure that it was not cited in Peter York's case. I think it was. Best refers to Starkey's evidence and to Willis on circumstantial evidence as authorities. The rule as stated is taken from several works that the evidence must be such as to exclude, to a moral certainty, every hypothesis but that of the guilt of the defendant. And if any other hypothesis can be sustained, it is for the jury to assume that hypothesis to be the true one. And Mr. Best says that this must be understood by reference to instances where inattention to contrary hypotheses has led into error. In the first place, then, the safety of individuals has occasionally been jeopardized by the fabrication of circumstances, which may be either casual or intentional. Under the former are ranked those cases where the accused, although innocent, is shown to have had peculiar temptations or facilities for committing the act with which he is charged, as where, in cases of murder, he has lived with the deceased or had an interest in his death, or where a man becomes covered with blood by coming in contact in the dark with the bleeding body, or death is produced by a weapon which is proved to be the property of a person who, nevertheless, is not the real criminal. These are cases which I shall read if they are proper authority. Chief Justice Shaw, taken with the qualification that it must be consistent with every other reasonable hypothesis. Mr. Sohere, the particular case which I was going to state to the jury, and there are several cases stated, was this. A servant girl was indicted for the murder of her mistress. The chief evidence against her was that no one person lived in the house but the prisoner and the deceased, and all the doors and windows were secure as usual. After the prisoner was condemned and executed, it appeared by the confession of one of the real criminals that they had gained admittance into the house, which was situated in a very narrow street, by means of a board thrust across the street from an upper window of an opposite house to an upper window of that in which the deceased lived, and having committed the murder, returned the same way, leaving no trace behind them. And there are numerous other cases. I put this by way of illustration as a case in which the circumstances were proved. The error was in the inferences, and cases are continually occurring in almost every man's life when these circumstances might take place. And hence these rules are considered most essential for every citizen, and they can never be lost sight of without endangering the party, and every other person who may be placed in the same situation. I wish to draw your attention for a single moment to these rules. There is only one of them to which I will ask your attention. Take the government's evidence. I will merely state it generally. What is the government's evidence? Why, it consists of one great chain of circumstantial proof, with which they have endeavored to surround the defendant, and by the weight of which they have endeavored to crush him. This chain consists, of course, of two great divisions, two great parts. First, what is called the corpus delicti, that is, that George Parkman came to his death by violence from somebody. That is the first link. Secondly, that Professor Webster was the party who produced that, and that he produced it in the manner alleged. These are the two great divisions, and each of these divisions, of course, goes into various subdivisions, and the subdivisions into various links. But without stopping to consider that, let us see how the government support their case. Take the first great division of their chain. They say that Dr. George Parkman was murdered. That is the very first point with which they start, that he came to his death by violence. How do they undertake to prove that? By various circumstances, all leading to one end, that Dr. Parkman, being in the medical college where it is admitted he was, never came out. And that is the circumstance upon which they begin to build their chain. Now you notice at once the various circumstances on which they rely. The handbills, search, and everything else. That is the first part of the division of their proof. That being there, he never came out. Take the second. They have a link of precisely the same kind or a duplicate of the other. They say that Professor Webster destroyed him by violence. Why? Because he was the last person with whom he was known to be. And if he did not destroy him by violence, the government do not know who did. Now suppose that he left the college. If that one link be broken, their whole chain runs away. Take another department of their case. They say they prove the identity of the body, and that constitutes one department of their proof. How do they prove it? Principally by the teeth found in the furnace, by marks upon the teeth. Suppose it should turn out that there is no very great peculiarity. There is an end of their identity. If it was built upon other circumstances, it might stand upon them. I have put these points solely by way of illustration. The great points to be borne in mind are, first, that every circumstance relied upon must be proved beyond reasonable doubt. Secondly, that the circumstances must establish to a moral certainty the guilt of Professor Webster. To do that, the third rule must come in, that these circumstances must not support any other hypothesis. If they do, there is an end to the case. What must be the line of defense taken up by any man who is indicted and tried upon circumstantial evidence? It must consist in denying this. It must consist simply in this, to wit, that the circumstances relied on by the government are not, and cannot be considered to be, when all the evidence is in, established beyond all reasonable doubt. And that is the point which we take, that these circumstances are not and cannot be established when our evidence is in beyond all reasonable doubt. Secondly, that these circumstances do not sustain the hypothesis attempted to be founded upon them, to the exclusion of all others. But upon the contrary, conclusions can be drawn from these circumstances better in favor of the innocence than in the favor of the guilt of Dr. Webster. So much with regard to the rules of law as applicable to the crime charged, as applicable to the manner in which it is charged, as applicable to the nature of the evidence which has been adduced here. I come then to state very briefly and very generally merely the heads under which we intend to introduce some evidence. We do not intend, gentlemen, in this stage of the proceedings, for it is not necessary, and it would, in my opinion, be totally irregular, to go into any examination of the circumstances which the government had been attempting to prove, or to show which of these circumstances we deny, and which we admit. That is to be explained in another stage of the case. My duty is to show to you the heads under which we intend to introduce our proof. We say we do not intend to produce any direct evidence for the purpose of explaining by what means those human remains came into that laboratory, or beneath it. Professor Webster remains on the position which he originally took. He knows nothing about it. Those are the remains of a human body. We can no more explain those than the government can. We can explain it only by hypothesis, as the government has explained it. The defendant stands as you would stand if similar remains were found upon your premises, under the foundation of your house, in your workshop, anywhere. So he stands, and so he must stand. And we know of no direct proof by which anything of the kind can be explained. Again, in regard to the interview which took place between Dr. Webster and Dr. Parkman, it is impossible for us to introduce direct proof. In the nature of things, no direct proof can be introduced, for, as you see, the circumstances exclude all direct proof. The statement of the case, as put to you, is that the parties met alone and that the interview was an interview by themselves. Of course, there can be no proof brought about that interview. The evidence in regard to this, seeing that we have no direct proof, seeing that from the nature of things we can have no direct proof, must be circumstantial, and such circumstances as we can introduce in connection with such of the government circumstances as you give credit to, must constitute the bulk of the testimony in this case, upon which you must render your verdict. The evidence under the heads in which we shall introduce it is simply this. Professor Webster stands charged here with having committed a cruel and an inhuman act. That is the charge against him. In regard to his being the person to commit an act of that kind, we shall introduce his character and reputation. The law, gentlemen, I am free to say to you, does not give the same weight to character where direct evidence is brought to bear upon a party, which it does in all doubtful cases, or where the government depends upon circumstantial evidence, which make up, of course, doubtful cases, and which must be doubtful cases. Where a man stands charged on circumstantial evidence, and in a doubtful case with the commission of a great crime, the very greatest weight is to be given to character, and his character is always admissible with this view. If a man should be proved by direct evidence to have committed murder, it would be of little importance to prove that he had previously been of good character. The only issues that could be made of his character in such a case would be to show that the witnesses who swore to the fact could not be true. The argument would be that the witnesses did not swear to what he did do. But when you come to a doubtful case, a case of circumstantial evidence, then there is weight to be placed on character, and a man has a right to be judged of by his fellow citizens, by a character which he has earned and established by a long life. Now, in introducing character, a man shall be at liberty to introduce it simply and solely so far as his traits of character have a direct bearing upon the offense charged. For instance, suppose a man should be indicted for felony and larceny. It would be perfectly ridiculous to show his character for humanity was good. His character for honesty would be an issue. Suppose a man was indicted for perjury. His character for truth and veracity would be at stake. Professor Webster is charged with doing a violent, inhuman, and cruel act, and I shall introduce evidence with regard to his character, by which you will judge whether he would do this act, and I shall be very much mistaken if we do not establish strongly upon that ground. Again, we shall undertake to show, so far as proof is accessible to us, for you will bear in mind that the arrest of Professor Webster took place after a week in which many of his acts were committed, what his conduct was, and how he spent his time during that period. We shall also introduce proof, gentlemen, in regard to the question whether Dr. Parkman was ever out of that college after that fatal Friday noon, for we are mistaken if there is not proof to show that he did come out of it. That may not have bearing as to whether that is his body or not, but it will have an important bearing as to whether he was destroyed by Professor Webster, as is alleged by the government. The facts are simply these, in regard to the evidence we introduce. In regard to the character and to the various heads to which I have alluded, Professor Webster is a person who has all his life been devoted to the pursuit of chemistry. He is a person of nervous disposition, but a man exceedingly peaceable and harmless in his habits and his conduct. We make no question in regard to his nervousness. He may sometimes show petulance, but so far from being a violent man, familiar with deeds of blood. Nothing can be further than this. He is naturally a timid man. He has, gentlemen, as I have stated to you, always been devoted to this pursuit, and he has devoted his days and his nights to it. Whatever advancement he may have made in this pursuit of chemistry, whatever accumulated wisdom he may have, we do not claim for him. In reference to dealing with the world, he is not a shrewd man. On the contrary, he may be considered the reverse. That is his character so far as we know it. But it is not a new thing for him to be locked up in his laboratory, days and nights. It is no new thing for him to exclude the janitor or anybody else when he is conducting his experiments. It is a safe and necessary practice in all laboratories. True it is that, at the time when these pipes were new, certain persons had access to them for the purpose of keeping them clear. But for certain very good reasons, he stopped that use of it and let the water run off. All this is, and this alone, the head and front of his offending. The interview took place precisely as Dr. Webster has stated, and Dr. Parkman left the college, and Dr. Webster left the college at quite an early hour for him on that Friday afternoon. We shall show you how Professor Webster passed the rest of the week, that he was at home almost every day at dinner, almost every night at tea. These are all the peculiar circumstances under which we are prepared to produce evidence, excepting that we may introduce evidence directly contrary to what the government have put in upon certain points. This is the statement, and all the statement, that we intend to make to you upon the opening of the case. End of section 22. Section 23 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 13. Witnesses for the prisoner. A number of prominent residents of Boston and Cambridge testified that they had known him well and long, that he had the reputation of a quiet and peaceable man, sometimes irritable, but never violent. These gentlemen were Joseph T. Buckingham, John G. Palfrey, James Walker, Francis Bowen, Joseph Lovering, George P. Sanger, Converse Francis, Abel Willard, John Chamberlain, Joel Giles, Edmund T. Hastings, John A. Fulton, James D. Green, Charles H. Hovey, Daniel Treadwell, Nathaniel I. Bowditch, J. Dunham Hodge, James Kavanaugh, Abraham Edwards, Peleg W. Chandler, Morrill Wyman, President Jared Sparks, Robert E. Abthorpe, Samuel P. Fay. Footnote: Buckingham Joseph Tinker, 1779 to 1861, born Windham, Connecticut, edited New England Magazine, 1831 to 1834, Boston Courier, 1828 to 1848, author of Specimens of Newspaper Literature, Recollections of Editorial Life. Palfrey John Gorham, 1796 to 1881, born Boston, Massachusetts, Unitarian minister, editor North American Review for many years, professor of sacred literature, Harvard, 1830 to 1838, member Massachusetts General Court, 1847 to 1849, Secretary of State Conference, 1847 to 1849, Postmaster, City of Boston, 1861, author of a number of works. Walker James, 1794 to 1874, born Burlington, Massachusetts, Unitarian clergyman, 1818 to 1838, President Harvard University, 1853 to 1860, author of many lectures and sermons. Bowen Francis, 1811 to 1890, born Charlestown, Massachusetts. Professor of philosophy, Harvard University for many years, and editor of North American Review. Lovering Joseph, born Boston, Massachusetts, 1813. Professor of mathematics and natural philosophy, Harvard University. Sanger, George Partridge, 1819 to 1890, born Dover, Massachusetts. Lawyer and journalist, editor of American Almanac, Boston Law Reporter, and other legal works. Francis Converse, 1795 to 1863, born Cambridge, Massachusetts, clergyman and author. Parkman Professor of Pulpit Eloquence, Harvard University, 1843 to 1863. Hovey Charles Mason, 1810 to 1887, born Cambridge, Massachusetts, noted horticulturist. Twedwell Davis, 1791 to 1872, born Ipswich, Massachusetts, inventor and author. Rumford Professor, Harvard University, 1834 to 1845. Bowditch Nathaniel Ingersoll, 1805 to 1861, born Salem, Massachusetts, conveyancer and author. Chandler Peleg Whitman, 1816 to 1889, born New Gloucester, Maine, admitted to Boston Bar, 1837, founded Boston Law Reporter, 1838, author of American Criminal Trials, 1841, Member State Legislature, 1845, and City Solicitor of Boston, 1846 to 1853. Wyman Morrill, born 1812, Chelmsford, Massachusetts, physician and author. Sparks Jared, 1789 to 1886, born Wellington, Connecticut, Unitarian clergyman, Baltimore, 1819 to 1823, professor of history, 1839 to 1849, president of Harvard University, 1849 to 1853, author of American Biography, Life of Governor Morris, and editor of works of Franklin and Washington. End of footnote. March 28th, Charles O. Eaton, a sign and ornamental painter, had been employed by Professor Webster to do painting for him during the last 3 years, had been to the medical college frequently to see him, more during the medical lectures than at any other time. Always found him in his private room or in the lecture room. He always told me to come to his private room by the door leading from the dissecting room entry. Had frequently been to the college to see him when I could not get admission to his rooms anyway, the doors being all locked on the inside. Had been there when the janitor himself could not gain admission, and have gone away a great many times in consequence of finding the doors fastened up. Have oftener found the doors bolted than otherwise when I called, unless it would be at lecture hours. Presume that Professor Webster was in his rooms at these times, as Mr. Littlefield would tell me so when I saw him. Samuel S. Green, reside in Cambridge, gave the information to the city marshal that Dr. Parkman had been seen to go over to Cambridge, was at the Toll House the evening when 2 men stopped in and entered into conversation. One was Mr. Littlefield. He said that he had seen Dr. Webster pay Dr. Parkman $470. I was sitting back in the Toll House when the conversation occurred, and there was a police officer near me. I understood Mr. Littlefield to say that he saw Dr. Parkman go out of the college the Friday, when the money was paid him. Noticed the discrepancy in his statements and remarked upon it at the time after he went out. Cross-examined. There were several persons present. Mr. Edward Whitney was one, and he understood him as I did at first, but has since changed his mind. Mr. Fifield, the toll man, was there, didn't know the police officer or others. He named the sum as $480. He did not give any odd cents. Mr. Bemis, you stated a moment since that it was $470. No, I said it was $480. Two of the jurors simultaneously. He said $470. Mr. Green. Well, it was $480, and I made a mistake in saying that it was $470 if I said so. Cannot recollect where he said he stood when he saw this money paid, in what particular room. Don't recollect his saying anything about seeing Dr. Parkman come into the college. Samuel P. Fay saw Dr. Webster the day of Dr. Parkman's disappearance in the evening. Called at a mutual friend's house with my wife and Dr. Morel Wyman and wife. Stayed there about an hour. Dr. Webster's appearance did not attract attention. He seemed as usual and participated in the conversation upon the common topics of the day. One subject broached with Dr. Wyman was in regard to recent improvements or discoveries in ventilation. Saw Professor Webster several times the following week. Was at his house Sunday or Monday evening, and again Tuesday evening. Called Sunday evening to make inquiries in regard to Dr. Parkman, supposing that Dr. Webster would be likely to know it. Another evening, Monday or Tuesday, spent 2 or 3 hours at his house, playing whist, having been invited to play with himself and family, and played 3 or 4 games. Dr. Webster and his daughter playing against Mrs. Webster and myself. Joseph Kidder. Am a druggist in this city, saw Professor Webster the day of Dr. Parkman's disappearance in my shop about 5 o'clock. He called to buy a box of cologne and purchased a whole one. A box contained 6 bottles. Marian Webster. Am a daughter of Dr. Webster. Friday the 23rd. Father was at home at tea a little before 6 o'clock. He remained till 8, then went to a neighbor's house with mother, my 2 sisters and myself to a friend's house, to a small party, and left us at the gate. When we returned home at 12:30, he opened the door for us. We remained up a half hour talking, and he retired to his room at 1 o'clock. Don't know where he spent the evening. It was his custom to breakfast at home, but not being up early Saturday morning, did not breakfast with him. Saw him again Saturday afternoon, a little after 1. He dined at home with us after dinner, did not see him again till dark at tea time. He stayed at home that evening, reading aloud and playing whist with us. This was not one of the evenings when Judge Fay was at our house. Remember seeing Father come from his study to the tea table. I'm certain he was at home during the evening. We all went to bed about 10 o'clock. Sunday morning, don't remember seeing Father until I saw him at church, at the college chapel. After church, he walked with mother and sister and returned to dinner at 12:30. We generally dine at 1 on Sundays, but dined earlier that day, that he might go to Boston and inform Dr. Francis Parkman of his having seen his brother the Friday before. Father dined at home on Monday, came home just at dinner time, which is 2 o'clock on weekdays. He was not at home after dinner. Saw him at tea, but think he was away during the afternoon. He was at home in the evening, spent the whole evening with us, had a friend visiting us, and Judge Fay called in and played whist. Went to bed about 10 o'clock. Father was then in and the rest of the family up. Tuesday, Father was at home at dinner and a little while after. Don't recollect as to the afternoon. He was at home at tea and during the evening. Saw him at home between 10 and 11 o'clock. Left him up at that time. When I went to bed. Wednesday, saw him at 11 o'clock in the forenoon. He came into the house at that hour, was in the dining room reading a book, and he came in and made some remark about the book, and went out into the garden to trim the grapevines, and worked there till dinner time. He dined at home and remained at home till after 6, when he came into Boston with us to a family party at Mr. Cunningham's. We left Mr. Cunningham's at 10:30 o'clock, and took the 11 o'clock hour late to Cambridge. Left him up when I went to bed that night, sitting in his dressing gown and reading a newspaper. Thursday, Thanksgiving Day. Father was at home, He spent the most part of the morning in the garden and spent the evening at home. Recollect first seeing him on Friday at dinner. He was at home about half an hour after dinner, and then again at sunset, also a part of the evening till his arrest. Have a married sister abroad, at Vale. There is a constant intercourse kept up between our family and the family there. We keep a journal of all the passing occurrences, from which we write to our sister there. It is from this journal that I have refreshed my memory in regard to the facts which I have testified to. Father frequently sends things to Fayal, frequently sends plans put up in airtight boxes. Know that he intended to send some this winter, but cannot say whether he had made any preparations towards it. Father has also had corals sent him from Fayal. Harriet P. Webster. Am a daughter. On Friday, 23rd November, saw Father between 5:30 and 6 o'clock at home, at tea. He remained at home till 8 o'clock, when he accompanied us to Mr. Batchelor's. We got home from 12:30 to 1 o'clock. When I saw him again, he opened the door for us and sat up half an hour with us. He went upstairs at the same time that I did, to go to bed. Saturday saw him at 1 o'clock and afterwards at dinner at 2 o'clock. He spent the afternoon at home till about dark, when he went out for about half an hour. When he came back, he brought home a new book with him. He spent the evening with us, reading aloud from the book which he had purchased, an illustrated edition of Milton's Allegro and Il Penseroso. We played whist, saw him Sunday morning. About breakfast time, he went to church and was at home at dinner. After dinner, he went into town to inform Dr. Francis Parkman of his interview with his brother. Had heard him mention his intention in the morning, but Mother dissuaded him, and he put it off till afternoon. Recollect seeing him again in the evening, but don't remember at what time. It was after 10 that I retired. Think I left him up. Saw him on Monday at dinner time. Don't remember seeing him in the afternoon of that day. He was at home in the evening. Miss Wells and Judge Fay were there, and we played whist. On Tuesday saw him at dinner time. Don't recollect seeing him again till tea time. In the evening he read aloud part of the time, and a part of the time he played whist. Wednesday morning breakfasted with him. Saw him again about 11 o'clock. He spent the rest of the forenoon in the garden. He was at home in the afternoon, and about 6 o'clock came into town with my two sisters. Thursday, he passed the day at home in the garden, the evening with us. Friday, he dined at home. Saw him again about 5 o'clock in the afternoon. He took tea at home. Anne Finnegan. I live in Dr. Webster's family as a domestic. The doctor usually breakfasted from 7:30 to 8 o'clock. His usual dining hour was 2 o'clock. Wednesday before Thanksgiving, the doctor was at home earlier than usual. He came into the kitchen at 12 o'clock, and I was frightened, thinking that it was dinner time or 2 o'clock. Know that the doctor breakfasted at home every morning while I was there, before his arrest. First missed him the morning after. Catherine P. Webster. Am a daughter of Dr. Webster. Wednesday, before Thanksgiving, saw Father soon after breakfast. He came home again between 11 and 12 and went into the garden to work. Before dinner, he was at home till 6:30, when he went to Mr. Cunningham's with my sister and myself. We took the 11 o'clock omnibus for Cambridge. While waiting at the toll house, noticed the handbill offering a reward for the discovery of Dr. Parkman. My sister pointed it out to Father, and he read it aloud, as it was posted rather high up above our reach. Winslow Lewis, Jr., recalled. When Dr. Webster was at the Mason Street College, he used to lock his doors against intrusion. I have often found difficulty there in gaining admission to him. Was at that time demonstrator of anatomy, and he a professor. Took very special notice of the cut under the fifth rib in the remains of the medical college, and am sure that it was anything but a clean cut. It had a ragged opening, would not necessarily follow from its being a clean cut that was made before death. Oliver W. Holmes recalled, "There are two leading authorities on the quantity of blood there is in the human body, Haller and Valentine. One says that it is 1/5 of the weight of the whole body, which in the instance of a person weighing 140 pounds would make 28 pounds. The other states it at from 1/5 to 1/4, which in the case before supposed would give from 28 to 35 pounds. This last quantity would probably measure something less than 17 quarts. The condition of a fracture of a bone after calcination would depend upon the degree of calcination. If the calcination had been very complete, the bone would easily crumble, if only partially calcined. The bone might split and break in any direction. In either case, one could not give a very reliable opinion whether the fracture was before or after calcination. Such is the result of my observations." To the Attorney General. Upon this, I should not defer to Professor Wyman. It is a simple physical fact open to the observation of anyone. I have examined the piece referred to by Professor Wyman, and cannot see any sufficient reasons for deciding whether the fracture was before or after calcination. Evan N. Horsford. Footnote. Horsford, Evan Norton, 1818 to 1893. Born Moscow, New York. Rumford Professor, Harvard, 1847 to 1863. One of the founders of the Lawson Scientific School. Am instructor in chemistry in the University at Cambridge in the Lawson Scientific School. Have delivered part of the course of chemical lectures at the Medical College in this city since Dr. Webster's address. Have nitrate of copper in my laboratory. Should not consider it the best article to remove stains of blood. Have made some experiments to see how shortly bone and flesh can be dissolved with nitric acid and potash. Being kept in a temperature a little below boiling, the bone had disappeared, all except a very few small pieces, in 4 hours and 20 minutes, and in 5 hours and 20 minutes not a vestige of it was to be seen. The flesh disappeared in 3 or 4 hours, so that the liquid was perfectly clear. I have also tried the experiment of dissolving human flesh. It took less time than the beef. I have not made any experiments in dissolving human bones. Occupied Professor Webster's laboratory after his arrest. Found salts of copper there. These salts, or solutions, might be wanted for sanctuarious thermometers, such as I saw there. Also saw copper solutions in 2 other vessels. Human blood is not infrequently used for chemical experiments. After Professor Webster's arrest, sent out various articles of clothing from the laboratory to his house at Cambridge. An old blanket, perhaps more than one. 2 pairs of pantaloons, 1 of 2 coats. A pair of blue overalls and a light-colored summer cap. Can find no trace of blood upon them. William T.G. Morton. Footnote. Morton, William Thomas Green, 1819 to 1868. Born Charlestown, Massachusetts. Discoverer of the anesthetic treatment in dentistry. I am a physician, practice dentistry, and have done so for about 8 years. Usually manufacture the mineral teeth which I use. Have had an opportunity of seeing becoming acquainted with Dr. Keefe's mode of making his mineral teeth. Was instructed in it some 5 years ago. See no particular marks about these teeth by which to identify them. Should think nothing could be judged from the material. Should say that they had been ground after being finished, but this is not an unusual thing. Don't think that the teeth, as they are now, fit the blocks with any great degree of exactness. I have a block of my own which fits the right side of the cast of the lower jaw of Dr. Parkman. As the block shown to me did not appear to have been fused, or to have had an opportunity to warp, should say that it might have been made on this model, as probably upon any other, and not more so, that as some of the accompanying blocks seem to have warped so as to fall over, I should think that there was a liability of this having morphed out of its original shape, and so into a shape to fit the mold. Cross-examined. No, Dr. George Parkman, I don't know how to answer your question, whether his jaw was a peculiar one. No two jaws are alike, though there is a general resemblance among all jaws. Never saw a person's that his could not be distinguished from, yet I have seen many persons whose underjaw projected as much as his. Could identify individuals among my patients who have as prominent a lower jaw as his, but prefer not to do so, from motives of professional delicacy. Perhaps these teeth taken from the furnace might be capable of identification if they had not been subjected to the action of heat. Can identify my own work in many cases. Mr. Bemis, did you ever see a set of artificial teeth made for one person's jaw that would fit another's? The teeth might answer for another person's jaw, perhaps. The plate would not. The Chief Justice, take a complete set, sir, fitted to the plate. I never saw a set thus complete, made for one person, that would answer for another. The case might happen once in 1,000 times. Mr. Bemis, would the difficulty be enhanced in attempting to find a set that would fit both jaws in connection? I mean that would fit both upper and lower jaw, and at the same time conform to the adaptation of the two jaws to each other? Certainly there would be very much less likelihood of finding such a coincidence in all these respects at the same time. The most prominent specimen of absorption among the casts produced by me is that of a person about 55 years old. The absorption has taken a different shape in this instance from that of Dr. Keefe's model of Dr. Parkman's mouth. The absorption on the right side also is not coincident with that of the right side of the model. Daniel Treadwell. Live in the neighborhood of Dr. Webster at Cambridge and saw him on Friday, November 23rd, at my house at about 8:30. He called with his wife. Dr. Muriel Wyman and wife and Mrs. Treadwell and myself were present when they entered. Judge Fay afterwards came in. A general conversation ensued on a variety of topics, and Dr. and Mrs. Webster left at about 10:00. Have endeavored to recall the particulars of the interview, but can recollect nothing unusual. He conversed upon any subject that was introduced, and appeared cheerful and perfectly self-possessed. There was nothing like distraction or absent-mindedness in his manner. I am familiar with his usual demeanor. Saw Dr. Webster twice in the course of the ensuing week. First, Tuesday evening near the burying ground, about 6:00. I had taken tea and was walking downtown. We stopped and had a moment's conversation together. Met him again on some other occasion, but cannot say when. At both interviews I noticed nothing unusual in his demeanor. We talked of Dr. Parkman's disappearance, and he spoke of it in his usual manner, perhaps with some animation, but not differently from what he would of any other passing subject, which excited interest. On this occasion or the other, after we had spoken of Dr. Parkman, he pointed up to a star that was particularly bright and asked some question in regard to it. James W. Stone recalled. The hole under the rib in the remains shown to us at the medical college was not a clean cut. There is no difficulty in making a clean cut after death, so long as the intercostal muscles remain tense. No more difficulty than for a butcher to make a clean cut of a piece of beef. Paulina G.B. Hatch, am the wife of Joseph Hatch, knew Dr. George Parkman for 14 years. Last saw him on Friday, 23rd November in Cambridge Street, between Blossom and North Russell. Was going towards home in the direction of Cambridge Bridge, and he in the opposite direction towards Court Street. The time was a little before 10 minutes before 2:00. Looked at the clock when I got home, and it wanted either 10 or 12 minutes of 2. I fixed the day by my husband starting the morning before, the 22nd, on a journey to Vermont, and that same night, the 22nd, my sister came to stay with me from Maine on a visit. The next day, 23rd, I went up to the south end to inform her daughter, my niece, of her arrival, and it was on my way back that I met Dr. Parkman, looked at the clock to see how long I had been gone, recalled this to mind the Sunday following when I was told that Dr. Parkman was missing, said at once that he could not have been missing long, for I saw him Friday afternoon. I mentioned the circumstances of my meeting him to my sister as soon as I got home. Cross-examined. Did not turn round to see what direction Dr. Parkman took after meeting me. Don't know, but that he himself turned directly round and walked towards the medical college. Was not his keeper. Mentioned it to my sister to cheer her up and make her smile, as she was rather gloomy. Told my sister I had met Chin in the street. She asked me who I meant, and I told her Dr. Parkman. Everybody knows that he had a very large chin. Joseph Hatch, am husband of last witness, left the city to go to Vermont on 22nd November last. Did not return till 3rd December. William V. Thompson, reside at East Cambridge, am clerk in Registry of Deeds. Went to Professor Webster's house Sunday evening, November 25th, with Mr. Fuller, the officer, to ascertain the date of a mortgage. Found Professor Webster at home. Asked him if he had recollected the time he gave the mortgage to Dr. Parkman. He looked into a trunk on the floor and said that it was strange that he could not find the papers. Said he could give me the information another way, and read from his journal. He gave me the date of a mortgage and said, "But I suppose that is not the one you want." Told him I wanted the date of the one upon which he had paid the money, the Friday preceding. He gave me the date, and on calling on Mr. Page, the city clerk, found a mortgage on personalty and not on realty. Dr. Webster said that he had been over to see Dr. Francis Parkman and told him that he was the person who was to meet his brother. That on his return he asked the toll man if he saw Dr. Parkman come over the bridge to Cambridge, as he had understood that he did. That he had called on Mr. Page, the city clerk, to see if the mortgage had been cancelled. He said he did not find Mr. Page at home, as he was not aware that Communion Day in his church came on the last Sunday of the month instead of the first, and so that he was detained. That he had ascertained from him that the mortgage was not discharged. I said we could call at Mr. Page's ourselves and make the inquiry of our own satisfaction as we returned home. That Mr. Page might have overlooked the cancellation, saw nothing peculiar about him except his giving me the date of the wrong mortgage. Didn't notice any trembling. Was acquainted with Dr. George Parkman for 10 years. Saw him very frequently. Saw him last on Friday, 23rd November, in Causeway Street, 10 or 15 minutes past 2 p.m. Was going down the street and he was coming up. I fixed the day because I paid for this coat, which I now have on, that day. Also made an abstract of a title for a merchant in India Street, which was paid for that day, and of which I had the copy of the receipt which I gave. Had not been in Boston before for 9 days. I started from East Cambridge to walk over at 2. The first place that I called at in Boston was the store of Orr and Town, corner of Elm and Hanover Street. Stopped there to leave some deeds. Took out my watch to see the time and found that it was about 25 past 2. This was after I met Dr. Parkman. I walked in from East Cambridge through Leverett, Causeway, Merrimack, or Portland Streets to Mr. Towns at a quick pace. Noticed Dr. Parkman's appearance when I met him. He was dressed in a dark frock coat, dark pants, and dark hat. He had his hands behind him and appeared excited, as if angry about some matter. Did not turn round to look after him. Recalled this to mind on Sunday following, and so stated to Mr. James H. Blake. Cross-examined. Never used spectacles. Am not nearsighted. My eyes are sometimes weak, and I use glasses slightly colored. My occupation is mainly that of copying. Suppose that it tends to weaken my eyes, but not to impair my sight. The broadest part of Causeway Street is opposite Lowell Street, where I met Dr. Parkman in Causeway Street was at the corner of Lancaster Street, not Merrimack Street. After examination of this map, I should now say that it is Merrimack Street. Do not carry a magnifying glass for my own use. Have one with me now, which I sometimes use to examine fine writing. Sometimes write in a very fine hand. Have never written so finely at one time that I could not read it at another. Have never made this statement to anyone. Mr. Bemis, have you never told anyone that you could write so finely in the mesmeric state that no one else could read it in the natural state? No, sir. Mr. Bemis, have you never said anything about writing in the mesmeric state? No, sir. I never used the term mesmeric. I may have said something about the biological state. I sometimes lecture on biology. Mr. Bemis, what have you said about writing in the biological state? I may have told Mr. Andrews that I could write a very fine hand in the biological state. Never told him that I could write so finely in that state that I could not read it in my natural state. May have told him that others could not read it without a glass. I simply carried the glass for others to use, not for my own satisfaction. Do not pretend to say that I have a better sight at any one time than at another. Mr. Sohere objected to the mode of cross-examination pursued. Mr. Clifford and Mr. Bemis contended that the inquiry as to the strength or kind of vision possessed by the witness was material and pertinent. The court ruled the line of inquiry competent. Mr. Thompson, do not know whether my power of vision is augmented in the biological state or not, nor whether I can see better in that state at a distance. Never use a glass to aid me to see distant objects. Dr. Parkman did not speak to me when I met him, nor did he bow. There was further conversation at Dr. Webster's house Sunday night. I asked Dr. Webster how Dr. Parkman appeared when he paid him the money. He said that he seemed angry and excited, that Dr. Parkman had called on Mr. Petit and inquired if he had any money in his hands belonging to Dr. Webster, that Mr. Petit told Dr. Parkman that he had some of his, Dr. Webster's, money in his hands, and that Dr. Parkman urged him to pay it over to him, and he would give him his receipt. Mr. Petit, he said, refused, and Dr. Parkman was very angry and said that Professor Webster was a damned whelp. When we went out, Dr. Webster said, I trust that you will be successful in your search, that he should be happy to render any assistance that he could. That is my signature and my handwriting, made it at request of Mr. Andrews. It is a rough outline of what occurred at the Sunday evening's interview. Dr. Webster did speak of Dr. Parkman's disappearance, creating great feeling in his family and the community. He also said that Dr. Parkman had been very insulting to him every time that he met him, that he had told Dr. Parkman that he would pay him when he got his money for the tickets to his lectures, and that Dr. Parkman said that he would not believe his word. Mr. Andrews was the secretary of the coroner's inquest and has been employed in collecting testimony for the government. He came to the registry of deeds and inquired of me about the interview. Told him that either Dr. Webster said that two persons, one of whom was the janitor of the college, were present when the money was paid, or the moment before, or that was my impression of what he said. Told him I could not swear to it, but he said that I might as well put it down and sign my name to the paper, and I did so. And Section 23. Section 24 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 14. Samuel A. Wentworth. am a provision dealer at the corner of Lind and Cambridge Streets, Boston. Knew Dr. George Parkman for 2 years. Last saw him in Court Street, Friday, 23rd November, between 2:30 and 3:30 p.m. Fixed the time by my dinner hour being 1 o'clock. Went to dinner, returned, and then my young man went to his dinner at 2 o'clock. Waited for him to come back to my shop, and after he returned, having been gone more than half an hour, went downtown to get my marketing for Saturday. Went towards Haymarket Square, and went in Court Street, nearly opposite the head of Sudbury Street. Met Dr. Parkman, opposite Mrs. Kidder's medicine store. He was on the same side of the street with me, and after I had passed, he suddenly faced half round towards the middle of the street with his hands behind him, and appeared to be looking up towards the tops of the houses opposite. Did not notice whether he left the sidewalk. He was going towards Bowdoin Square when he stopped. First called this to mind Saturday evening when I went home from my shop, about 10 or 10:30. My wife told me the 2 men had been there to inquire about Dr. Parkman. I immediately made the remark that I guessed that he hadn't gone a great ways, for I saw him in Court Street yesterday afternoon. Cross-examined. There was another lady present when I communicated this to my wife. I also communicated it to Mr. Henry L. Foster, who lives in Blossom Street, after the remains were found. Did not mention it to the police. I can't be precise as to the time when I met Mr. Parkman. Should think that it was about 3 o'clock. It must have been after 2:30. Am sure that it was not Thursday, for I never buy my Saturday's marketing till Friday. There was with me Mr. Isaac H. Russell, who recollects seeing Dr. Parkman at some time, but cannot recollect the day. Did not mention the fact of seeing Dr. Parkman out of my house till I told it to Mr. Foster, the Saturday after the remains were found. Knew that the search was going on for Dr. Parkman, and that rewards were offered for the discovery of his body. Samuel Cleland. Reside in Chelsea, but do business at number 26 South Market Street, Boston. Was acquainted with Dr. George Parkman. Was a tenant of his in 1839. Last saw him on Friday, 23rd November, in Washington Street between Milk and Franklin, between 1/4 and 3:30 on the east side of Washington Street, going towards Roxbury. Fixed the hour for my going up to see the Reverend George Wiles that afternoon. Always called on him, as he officiated occasionally for our church in Chelsea, at 3 o'clock. It was on my way from there that I met Dr. Parkman. Know that the day was Friday in this way. On Wednesday, 21st, I addressed a note to Reverend Mr. Allen of East Boston, requesting him to officiate at St. Luke's Church in Chelsea on the Sunday following. Not receiving any answer Friday morning, I wrote another note to him and sent it by a boy to East Boston. The boy returned and said that he could not find Mr. Allen. He brought back the note and I preserved it, and now have it in my pocket. About 11, I addressed a note to Reverend Mr. Ward of Christ Church, asking him to preach for us, and sent a boy with it. He returned with an answer, which I have now in my pocket, stating that he could not preach all day the next Sunday. Waited till 3 o'clock in hopes of seeing Mr. Wiles. Remember distinctly leaving my store at 3 o'clock. Went out through Devonshire Street and Theatre Alley to Franklin Street and found Mr. Wiles in. Spent a few minutes with him and started to come back again to the store through Washington Street. And coming down Washington Street, saw Dr. Parkman. Thought that he was walking with a laboring man, and that attracted my attention. On getting nearer, saw that he was alone. We passed on the same side, nearly touching each other. Did not speak to him, as I have not done so for several years. First heard of his disappearance on the Monday following. Cross-examined. First communicated the fact of my meeting Dr. Parkman to my partner Monday morning, when he read the notice of his disappearance from the newspaper. Did not tell this to Dr. Parkman's family or the city marshal. Met Mr. Knapp, the clerk of the police court, and told him of it, and he said that it was unnecessary to speak about it as Dr. Parkman had been seen at a later hour at the South End. Saw the advertisement offering a reward in Monday's papers. Cannot fix the exact place in Washington Street where I saw Dr. Parkman. Think that it was halfway between Franklin and Milk Streets. The street was not much crowded. He might have been 4 or 5 rods off. When I first noticed him, I was on the inner side of the sidewalk and he on the outer. There were persons between us at first. He was walking at his usual pace. Made no statement about the occurrence to Mr. Lee, the superintendent of the Providence Railroad. May have conversed with him about it. Was not aware of any advertisement requesting notice to be given to the police of any information about Dr. Parkman. Lucius R. Page. Am city clerk of the city of Cambridge. Keep the records of the mortgages and personal property. Saw Dr. Webster at my house on Sunday succeeding, 23rd of November in the afternoon. He stated that he had called to see if Dr. Parkman had been there since Friday noon to discharge a mortgage. Replied at once that I knew Dr. Parkman, and that I was very sure that he had not been there. Abbey B. Rhodes. Reside in Minot Street. Knew Dr. George Parkman enough to bow to him for 25 years. Last saw him Friday, 23rd November, in Green Street, near the corner of Lyman Place, in front of Emery Souther's apothecary shop, about 5:15 p.m. There was another man with him, was on the inside of the sidewalk, and my daughter, who was walking with me, was between me and the doctor. As he passed us, as near as he could, we were going towards Chambers Street and Dr. Parkman towards Bowdoin Square. We bowed as we passed, fixed the day, because there was no other day that week when my daughter and myself went home together through Green Street. We had been out shopping and made some purchases at Mr. Hubby's store. After leaving there, we went into Hanover Street, my daughter taking the bundle with her. The purchase 11 yards to Lane. I paid for it at the time, so that no charge was made against me. Have been there since and ascertained that there was an entry made that day on their books of that amount of cash received for what I bought. Have taken the greatest pains to be sure of the day. Know that I was at the house the next day, Saturday, all day. The day before, Thursday, I was at home also all day. Communicated my recollection of meeting Dr. Parkman to his brother, Reverend Dr. Francis Parkman, on the Tuesday following. First heard of Dr. Parkman's disappearance Sunday morning in one of the newspapers. My daughter first recalled my attention to the fact of having met him on Tuesday. There was conversation at dinner about the doctor's disappearance, and she asked me if I didn't remember meeting him in Green Street Friday, when he bowed to us, and it then occurred to my recollection immediately. Have a memorandum of my purchase at home. I cannot be mistaken in the day. Remember all my engagements that day before and after meeting him. Did not go out until after dinner between 2 and 3 o'clock. I did my shopping and I was on my way home when I met him. Cross-examined. Have been a parishioner of the Reverend Dr. Francis Parkman, and felt a great interest in the matter of his brother's disappearance. Asked my son some questions about it on Tuesday at dinner, which led to my daughter's asking me the question which I have mentioned. Have never expressed any doubts or misgivings about the accuracy of my recollection. I have not done so to Miss Patterson. I have talked with her about it, but do not recollect saying anything of the nature of my doubting my memory. If I have, I didn't mean to do so. Never told Mrs. Harrington, my sister, that if I hadn't said so often that I had seen Dr. Parkman Friday, I shouldn't feel confident of it now. Didn't know the gentleman who was walking with Dr. Parkman. It was not Dr. Webster. He was taller and stouter than Dr. Webster. Don't know whether they were talking together. They passed so quickly that I could not see. I don't recollect what the weather was that afternoon. Mary Rhodes. Am daughter of Mrs. Rhodes. Knew Dr. George Parkman nearly 10 years. Saw him last Friday, 23rd November, in Green Street, opposite Mr. Souther's apothecary shop. My mother was with me. We had come from Mr. Hubby's store in Winter Street. Dr. Parkman was walking with another gentleman and bowed to Mother as he passed. He was nearer to me than to my mother, and I had to move my bundle to avoid hitting him. The bundle was some Delaine, which we had bought at Mr. Hubby's. Went to Lexington Saturday and heard of Dr. Parkman's disappearance. There, the same day. I first mentioned my recollection of seeing Dr. Parkman to my mother and brother Tuesday. I did not mention it to anyone before coming to Boston. Have taken a great deal of pains to fix the time when I saw Dr. Parkman. The hour was between 4:30 and 5, near dark. Cross-examined. Did not mention this fact at Lexington. Heard no discussion there about it. The gentleman where I was staying read the advertisement aloud from the newspaper to the family. Thought it related to his disappearing the same day. Heard nothing more said about it till I came into town Tuesday, and mentioned to nobody in the meantime that I had seen him. Did not inquire myself when I came to town whether Dr. Parkman had been heard of. I don't know whether my mother said anything about a reward being offered for him before I told her where we had met him Friday. The gentleman walking with Dr. Parkman was a stout man, not so tall as Dr. Parkman. He was dressed in a dark surtout. Don't recollect the streets through which we returned from Mr. Hubby's. Sarah Greenough. Reside in Cambridge. Knew Dr. George Parkman personally for many years, in early life, but only know him by sight for a few years past. Saw him last on Friday of the week before Thanksgiving, in Cambridge Street, between Belknap and South Russell Streets, about 10 minutes before 3:00 p.m. Had an engagement at tea and wished to be at my son's house before 3:00, at which hour he was in the habit of leaving it. Had the horse harnessed, and was brought down from my house in Cambridge to the bridge, and then walked over the bridge, thinking that I should have time to get to my son's in Temple Street before he left. Looked at my watch after getting across the bridge and into Cambridge Street, and it wanted 10 minutes of 3. Saw Dr. Parkman just about that time on the opposite side of the street. Was on the left-hand side and he on the right-hand side. Reached my son's just as he was leaving. Know that it was the Friday before Thanksgiving, that I had an engagement to take tea with a lady in the city, and that it was Friday that I wished to see my son. Cross-examined. Dr. Parkman was going towards the bridge. Had no particular occasion to notice him. Only saw him just as he was passing abreast of me, and probably should never have thought of it again, except for the report of his disappearance. Do not mean to be positive of having seen him, only believe so. Samuel B. Dean, am salesman for C.F. Hubby and Company, Winter Street, sold 11 yards of muslin Delaine on 23rd November at 20 cents a yard, coming to $2.20. There was no other cash sale that day of that kind of article. Made the memorandum of it at the time. Cannot tell to whom it was sold, nor the time of day. From the position of entry should infer that it was in the latter part of the day. In rebuttal, Joseph Sanderson, am a police officer of Cambridge. Mr. Sohere, we should like to be informed what point this witness is called, for the purpose of rebutting to know if the evidence is admissible. Mr. Bemis, we intend to show by him where the defendant was on one of the nights subsequent to the 23rd, when he attempts to account for himself. Mr. Sanderson, have known Dr. Webster for 4 years. Saw him late one night between Sunday and Thanksgiving of the week succeeding Miss Dr. Parkman's disappearance in Harvard Square, in Old Cambridge, close to the colleges where the omnibuses stop. Saw him get out at the theater or late omnibus, there one night between 11 and 12 o'clock. No one was with him and no other person, though others got out at the same time, was standing near the omnibus when he got out, and I turned and followed him in the direction of his house. Don't recollect seeing him after he passed Graduates Hall. Am a watchman, and was on duty at the time. Met Mr. John Bryant, another watchman, directly after Dr. Webster passed, and made some remarks about his passing. Dr. Webster passed near enough to me to have touched me if he had pleased. I first mentioned the fact of seeing Dr. Webster on Saturday after his arrest to Mr. Bryant. Talked over the fact of our seeing him, but did not specify the night. Can't say that it was not Wednesday night. Am confident that it was after Dr. Parkman's disappearance. It was not Thanksgiving night, for that was pleasant. This evening there was a moon, but it was a little hazy so that a person would not cast a shadow. Followed Dr. Webster some considerable distance in the direction of his house. I did not speak to Dr. Webster. I know him. Daniel Harwood. Am a dentist in the city. The counsel for the defense inquired as to the rebutting character of the proposed testimony. The Attorney General replied that the prosecution expected to prove by this witness and other dentists in opposition to the testimony of Dr. Morton that there were marks of identification about mineral teeth which would enable the maker to recognize his own work, and also that there was a peculiarity about Dr. Keefe's work, in particular which made it distinguishable from other dentists. The court deemed the evidence competent. Mr. Harwood. I have resided and practiced dentistry here since 1829, am a member of the Massachusetts Medical Society, and one of its counselors. Was one of the first who did anything extensively in the city in the manufacture and setting of mineral teeth. A dentist would be as able to recognize large cases of his own manufacture as a sculptor the product of his own chisel, or a merchant his own handwriting. By large cases, I mean, where there are several teeth or several blocks of teeth, all connected together upon one plate. A dentist cannot recognize single teeth, except from their composition, but in teeth in combination, there are characteristics of form and arrangement by which he is able to recognize his own work. Could not always identify Dr. Keefe's work, but can usually. Dentists often examine other work than their own, expressing an opinion as to the dentist. I frequently say to patients, this is Dr. Keefe's work, or Dr. Flagg's work, or Dr. Tucker's work, when teeth come into my laboratory of other manufacture. The makers are recognized by my assistants as well as by myself. The blocks of mineral teeth found in the furnace were exhibited to the witness, and he was asked if he could identify them as of Dr. Keefe's manufacture. Mr. Harwood, these are covered with foreign substances, and some were changed from their original appearance. Some other dentists in this vicinity use the same material for the composition of their teeth as Dr. Keefe. Dr. Keefe's teeth appear to have but very little, if any, pipe clay in their composition. Feel confident that these are of Dr. Keefe's manufacture. The block is certainly in his style. He does not separate the teeth down to the gum, as I and many others do. If I had made such a block of teeth as this, and had the mold, I think that I could recognize them, and that Dr. Keefe could not be mistaken in saying that he could identify them. Cross-examined. The block itself has a peculiarity such as I never saw. A projection below the molded teeth, amounting to an extraordinary absorption. From this, as well as the general workmanship and style of making, should know them if they were mine. The material is not peculiar. The peculiarity consists in the composition of the block. I never saw an absorption like this. I think that Dr. Keefe could not have been mistaken. Joshua Tucker. Am a dentist in this city, have been in practice 21 years. The teeth found in the furnace were exhibited to the witness, and he was asked if he could observe upon them any means of identification. The left lower block affords as complete a means of identification, and the maker could as certainly recognize it as the artist who has spent a week studying a face and painting it on canvas can tell that the portrait is his work whenever he may see it. Willard W. Codman. I'm a dentist and have been practicing 17 years. The blocks of teeth were here exhibited. Think that the dentist who made them could identify them in their present condition from the workmanship and materials. Benjamin H. Todd was present at a conversation at the Toll House on Craigies Bridge the Sunday succeeding Dr. Parkman's disappearance. Mr. Littlefield and myself were going over to East Cambridge. Mr. Littlefield asked the toll man if the policeman had been along over, and he replied that there had been some by, but that they had gone back again. I asked the tollman if he was the person who saw Dr. Parkman pass over, in company with an Irishman, and he replied that he was not, but that it was the young man who had gone to tea. Mr. Littlefield remarked that he wasn't concerned or employed at the college, and one of us spoke of the report that Dr. Webster had paid Dr. Parkman money. Mr. Littlefield then said that he saw Dr. Parkman coming towards the college Friday afternoon, and that is all I recollect of his saying about Dr. Parkman. Isaac H. Russell, am a dry goods dealer of the firm of Jacobs and Company, Boston. No, Mr. S.A. Wentworth. Have no recollection of walking with him or being in his company Friday, November 23rd. Think that I have been in his company once, when he pointed out Dr. Parkman to me, but I don't recollect how shortly it was before his disappearance. It might have been 1 day or 3 months before. If it had been that day, think that I should have recollected it. Heard of Dr. Parkman's disappearance shortly after it occurred. Can't tell the day, but I saw advertisements in the newspapers about Dr. Parkman, and didn't then recollect having seen him. Have no recollection of the place where I was with Mr. Wentworth when we saw Dr. Parkman. Cross-examined. Know Mr. Wentworth and sometimes walk with him. Have no doubt that I should have remembered the fact of seeing Dr. Parkman if it had occurred about the time of his disappearance. Don't recollect when, where, or how I first heard of his disappearance. The Attorney General stated to the court that there were some 4 or 5 witnesses who had been summoned on the part of the government, whom he wished to call to show that there was a person about the streets of Boston at the time of Dr. Parkman's disappearance, who bore a strong resemblance to him in form, gait, and manner, so strong that he was approached and spoken to for him by persons well acquainted with Dr. Parkman. Mr. Merrick objected to the evidence as unusual in its character, and as amounting to nothing more than that the witnesses were persons of such poor perception that they could not distinguish one man from another. The Attorney General said that the witnesses for the defense had been allowed to testify to seeing some person whom they believed to be Dr. Parkman, but to whom they had not spoken or offered to speak while in the present instance. The witnesses had addressed or been upon the point of addressing the supposed Dr. Parkman, and then discovered their mistake. The court deemed the evidence incompetent, the Chief Justice remarking that there would perhaps be no objection to the introduction of the very person supposed to resemble Dr. Parkman, but that this testimony of the resemblance of an unknown stranger was quite too remote and unsatisfactory. George W. Fifield, am keeper of the toll house on Craigies Bridge. Recollect when the clock was put up on the courthouse at East Cambridge. It is not kept accurate time. It is often stopped and does not agree with other clocks. Samuel D. Fuller, am toll keeper on the Cambridge end of the West Boston Bridge. Had observed the courthouse clock at East Cambridge. It has not been an accurate timekeeper. Closing argument of Mr. Merrick. Mr. Merrick, I need not say to you, gentlemen, with what feeling of embarrassment I rise to address you at the close of this protracted investigation. I cannot be more sensible than you are of the difficulty to be encountered in the examination of so much testimony, nor of the interest there is that all this testimony shall be rightly understood, and the consequences which properly ensue from it be rightly deduced. A case, gentlemen, is presented to you, transcending in public interest any that has heretofore occupied the attention of our judicial tribunals. A few months since, a well-known and highly respectable individual suddenly disappeared from this city. His disappearance was followed by inquiries broad, extensive, almost universal. An individual connected with a family well known in this community, himself connected with large and great interest in it, who had been accustomed day by day, and month by month, and year after year, to mingle freely in the community without any known cause, was lost. His friends naturally, inevitably, took the deepest interest in his discovery and in his recovery. They enlisted the entire official force of the community in their service. Much more than that, they enlisted the entire sympathies of the whole community. When all inquiry and all investigation and all effort seemed to be utterly baffled, and there was no hope left, and there was, in reference to this individual, one universal darkness, a sudden and astounding notice fell upon us all. The mangled remains of his dead body, it was believed, were found. The perpetrator of the awful crime, which brought that body to the condition in which it was found, was said also to have been detected, and that individual was one who, in the ordinary course of things, would have been no more suspected of such atrocious criminality than you, or any one of you, or of us, who are engaged in this present trial. That discovery, gentlemen, so astounding, so overwhelming, was instantaneously followed by a disclosure to the community, in every form in which disclosure can be made, of the various circumstances tending to establish the facts that these remains which were found were the remains of the body of Dr. George Parkman, and that the prisoner at the bar was connected with the scene of his death. Incident after incident was communicated to the public, and everything which could bear against this unhappy prisoner was spread abroad, as it were on the wings of the wind. Every sheet that was published, every hour that passed, gave new tokens to the community, at once of the death of Dr. Parkman and, as it was supposed, of the guilt of this prisoner. In the meantime, gentlemen, the prisoner now at the bar was in the cells of your prison, a silent sufferer, while every incident tending most unfavorably to affect him was the subject of daily communication and discussion abroad. He was alone and without friends and without help to repel these accumulating circumstances of the charge against him. Gentlemen, he waited not only in silence, but in hope and in confidence. He sent forth no appeal to the community. He suffered these communications of which I have spoken to be spread broadcast through the community, till the voice of the echo returned from the most distant parts of our country and from other lands, without ever once asking this community even to suspend the formation of their judgment. He waited, gentlemen, in silence and in hope and in confidence, because he had lived long in our midst and knew who were finally to be his judges. He knew that a time was coming when passion would subside, when prejudice would give way, when calm reason would intervene, and his country would try him fairly in the midst of her tribunals of justice. That hope and that expectation are not disappointed. He never asked, gentlemen of the jury, 1 hour's delay of this investigation, but so soon as it was the pleasure and convenience of the government, consistently with the arrangements of this court, to enter upon this trial, he was prepared. Not prepared, gentlemen, by a series of experiments and investigations, which he could make in his silent and solitary cell, but prepared in that consciousness which enabled him, or would enable him, to come before a jury of his country, and say, whatever might be the appearance against him, he could confidently trust at once his cause and his life with an impartial jury, under the instructions of a learned and impartial court. Gentlemen, it is impossible that you yourselves did not know much of this cause before you took the seat you now occupy. It is impossible that you have not in one form or in another form heard much of that which has been detailed to you in the evidence which the government have produced upon the present trial. And yet, one and all of you, under as solemn responsibilities as can be imposed upon you, and declared that all those circumstances and all the comments which may have been made upon them created not only no prejudice in your minds, but not even a bias against the prisoner. And if, gentlemen, these circumstances, though known as well before as since this trial, could not then produce even so much as a bias on your minds, I have some ground upon which I may estimate the effect which the same evidence now presented in a judicial form is entitled to produce on the same minds. What, gentlemen, is the charge that the government have made against the prisoner? What is the issue to be tried, and what the proofs by which that issue is to be determined? The government charged that, on the 23rd of November, 1849, George Parkman was murdered by the prisoner at the bar, in various forms, such as the officer of the government chose to make, upon the investigation which took place before the grand jury. The charge is presented in the indictment upon which the prisoner is now tried. It has been stated to you that it is competent for the government, or the officer of the government, in preparing an indictment, to present the charge in various forms, because upon the trial, the final trial, some difference of evidence may render the different statement of the particular grounds of the charge essential. It is competent, and the government have availed themselves of that competency to present different counts. I do not now speak, gentlemen. It is not necessary that at this moment I should, upon the different manners in which the government have, in this indictment, charged this defendant with this crime. Enough that the defendant is on trial for his life, charged with a capital offense. End of section 24. Section 25 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 15. To establish this charge against the defendant, there are certain facts which it is indispensable that the government must prove. They must prove the death of George Parkman. They must prove that his death was by the agency of another person. They must prove that the prisoner at the bar was that agent, and that, in causing the death of George Parkman, he acted with malice aforethought. If any one of these facts is not proved, the government cannot claim nor ask for a conviction. Unless the death is proved, and that it was by the agency of the individual, they can have no ground of conviction. Unless they show that the death occurred and by the agency of the defendant, and that it was also with malice aforethought, they can have no verdict for murder, but may have a verdict for a less offense, for manslaughter. These facts, then, gentlemen, which the government must prove, they have undertaken to establish by much evidence. Time has been exhausted to an unusual extent, not to an unnecessary extent, but to an unusual extent, in gathering together the facts which are called the proofs in this case against the prisoner at the bar. Though, gentlemen, we have spent day after day, not one single fact is proved which comes directly to any one of the great facts which the government are bound to establish. By no direct evidence is it shown, even that Dr. George Parkman is no longer in the land of the living. By no direct evidence that he was slain by the agency of another human being. By no direct evidence is it claimed that it is shown that the defendant had any direct agency in causing or procuring that death. But every one of these facts is sought to be proved by collateral circumstances, thus asking you to say that certain facts which are not proved are known, and from those facts you may draw by inference those other facts which are yet unknown. Let us see then, gentlemen, precisely what the proposition of the government is. Let us see precisely what the prisoner at the bar concedes, and then we shall find the precise issue to be tried. and the question which you, upon your high responsibility of jurors, are called upon to determine. The precise proposition which the government undertakes to establish by the indirect testimony which the counsel has introduced here is that on the 23rd of November, 1849, Dr. George Parkman, between the hours of 1 and 2 o'clock, entered into the medical college and had an interview there with the prisoner at the bar, and that he never left that building, that he and the prisoner never separated, but that shortly afterwards the body of Dr. Parkman was found dead in the same building. This is the proposition which the government undertake to establish. Mark, gentlemen, that the government do not undertake to establish, nor is there any evidence in the case from which it is by possibility to be inferred, that these parties ever met again. If they separated there is no proof that they have seen each other since. None, gentlemen, unless George Parkman was the victim of violence then. There is nothing to connect his death with the hand of the prisoner at the bar. This is the proposition of the government. What does the defendant say? He concedes that which he has always stated, that at half after 1 o'clock on the 23rd of November, 1849, there was an interview at that college for a specific purpose between him and Dr. Parkman, that specific purpose was then accomplished, and that Dr. Parkman then in life and inactivity left that building, or at least the room in which the interview between the parties then took place. That is the proposition of the prisoner at the bar, whose life is in your hands, that Dr. Parkman left this building after a short interview of half a moment at half after 1 o'clock. That is all the prisoner at the bar concedes. Beyond that, he denies everything. And if the government will have it that George Parkman was in that building or in that room at a later hour than that, they must prove it. The prisoner concedes no time to them at all. It was half after 1 o'clock, as he says, that this interview took place, and it terminated then. Now, gentlemen, we stand upon these two propositions, which make the issue between the government and the prisoner. Whether Dr. Parkman did, in fact, leave that building or not is to be determined. We are to examine here all the evidence which is in this case, to show that he did not leave this building, that he was slain there, that the interview terminated in the death of Dr. Parkman. They must prove that he never left that building. All the evidence of the government is in the case. I do not mean to say to you, gentlemen, by any means, that this mass of circumstantial evidence that the government have brought in here has not a tendency, or, if you please, a very strong tendency, to show the truth of the fact charged upon the prisoner, without explanation, and without further examination, and without the closest analysis. That would be saying more than one could assert, after this long chain of circumstances has been presented. If it did not have such a tendency, the grand inquest would have found no indictment, and we should have had no trial. It is because it has such a tendency that it is here, and it is for you to say that this tendency is such as to produce irresistible conviction upon your minds. If it does not, the prisoner is entitled to an acquittal. On the other side, we have undertaken to satisfy you by proofs that Dr. George Parkman did leave this building and was abroad in various parts of this city at a late hour that same day. Suppose, gentlemen, that you shall be satisfied of this latter fact. Suppose that the evidence in the case shall convince you that Dr. Parkman separated himself from Dr. Webster and went his way, where he would. In the absence of all evidence that these parties ever met again on earth, there is no proof that Dr. Parkman came to his death by the hand of Dr. Webster. Say, if you please, gentlemen of the jury, in this state of things, that the remains found on Friday, the 30th of November, are the remnants of the body of George Parkman. Say that there are proofs, conclusive proofs, for the purpose of this argument, that he was slain by violence. Say, gentlemen, further, if you please, that we cannot tell, except by this connection with Dr. Webster, how all these things were brought about. What is the conclusion? Why, gentlemen, simply this, that if these parties separated once, and there is no proof that they ever met again, there is behind it all one great inexplicable mystery, that with all our efforts, earnest, zealous, persevering, these facts of human life have baffled human reason and human investigation, and that is all. And so, gentlemen, is the everyday experience of life. It has been said that realities are stranger than fiction. The imagination cannot keep pace with the extraordinary events of life. And there are mysteries in the order of providence and in the course of human life, which human reason cannot fathom, which lie deeper and lower than the human mind can sound. Then, gentlemen of the jury, if these parties separated, although it may be that the remains of Dr. George Parkman were found lying in dishonor under the foundations of the medical college, if these parties separated, then there is no proof, none that touches or can touch the life of the prisoner at the bar, none that can connect him with the sad events which transpired on, or immediately after, the 23rd of November. And how, gentlemen, does the proof stand? Did they separate or did they not? We have called, gentlemen, several witnesses of respectability, inhabitants of this community, to testify to you upon this subject. See the condition in which Dr. Webster has been placed in reference to the discovery of the witnesses, alone in his cell, with no great opulent family around him, of large connections to aid and assist him, with a wife and the 3 daughters whom you have seen upon this stand, occupying his mansion in a neighboring city. These witnesses have sprung up, as it were, by their casual recollections, and we have been enabled to discover these proofs and bring them to your attention. Gentlemen, the number of witnesses is not large, but contrasting it, even in this respect, with the number of witnesses whom the government, with all their search, with the aid of the municipal government here, its police officers searching night and day, their agents employed tracking Dr. Parkman's footsteps. Compare the number of witnesses we have brought here, who have seen Dr. Parkman in the afternoon, with the number whom the government brought here, who saw him in the morning, when he was engaged in his ordinary pursuits. And even in that light, our proof does not stand in a disadvantageous position in comparison with that of the government. We have presented to you the testimony of Mr. Thompson, Mr. Wentworth, Mr. Cleland, Mrs. Greenow, and Mrs. and Miss Rhodes. We have called also before us Mrs. Hatch. I shall not at this moment dwell upon the testimony of Mrs. Hatch. She testifies, to speak simply of her testimony, that at 2:15 on Friday, the 23rd of November, she saw Dr. Parkman in Cambridge Street, going toward Court Street. At 10 minutes before 2, according to the government's testimony, that is, 5 minutes after he was seen by Mrs. Hatch, he was seen going to the medical college, and that he turned from Cambridge Street into one of the streets leading to the medical college, furnishes the explanation that the government may give to this. Of this testimony I shall have occasion to speak hereafter, in a connection of the highest importance, most pregnant of suggestions, and worthy, as I think evidently will be found, of the highest moment and consideration. But, passing from her testimony to the testimony of others, Mr. Thompson says that he came in from Cambridge that afternoon, and that about 20 minutes after 2:00, and an hour confessedly much after Dr. Parkman entered the medical college, he met Dr. Parkman in Causeway Street. He knew him very well. He had seen him many times before. He had known him 10 years. For the last 5 years, as a clerk in the Registry of Deeds in East Cambridge, he had had occasion often to see Dr. Parkman, and he knew him, I suppose, vastly better than I know any one of you. He knew him perfectly well, as he says. He asserts that he passed Dr. Parkman, that he recognized him and passed his way, that he transacted his business and returned home. If this is true, these parties did separate. Why is it not true? I did not know from the cross-examination, but that an attempt would be made to show that this witness had given at another time a different account, said something which would be calculated to create a distrust of the accuracy of the statement which he has given here, that he had made a different statement somewhere else. And when the Attorney General cross-examined that witness from a paper subscribed to be by that witness, I did not know but what you thought that the paper did not conform to his testimony here. The witness stated how that was. Mr. Andrews asked him to write down the testimony in the rough. He did so, and the paper is not produced, and we may fairly infer from this that there is nothing in the paper which could conflict with the credibility of this witness. He stands in this position. He is the clerk in the Registry of Deeds office at East Cambridge. He has been employed there many years. He was fully acquainted with Dr. Parkman, and he swears to you that he met him at 20 minutes past 2 o'clock. I do not suppose that this witness is to be discredited upon a part of the ground of the cross-examination. This biological state of which he speaks is nothing. We all know that many individuals have their belief, which seems strange and fantastical and groundless, but which they in the utmost sincerity adopt for themselves. Yet because they adopt these strange beliefs of theory, we cannot say that they are not sincere. More frequently they are the most sincere, and they adopt them on this very account. They adopt them not to make themselves agreeable by falling in with the common tone of society, but they adopt them from conviction, because they believe them to be true, and whether the world says yea or nay, in all truth and integrity, they feel bound to adopt and promulgate them. This is the position of this witness. There is no attempt to impeach him. They have not attempted to disparage his visual organs, and he swears they are good. And he also swears that he saw Dr. Parkman in Causeway Street at a time which is incompatible with the proposition upon which the government rests this prosecution. Mr. Wentworth, a witness probably well known in this community, a man whose personal appearance upon the stand certainly entitles him to a favorable consideration, testifies that in the afternoon of the Friday of the disappearance, between the hours of half after 2 and half after 3, he met Dr. Parkman in Court Street. The witness was walking with Mr. I.H. Russell. He saw Dr. Parkman approaching, and at the point of meeting, he crossed from the right-hand side to the left-hand side of the street. And as he crossed over, he saw Dr. Parkman was coming, and Dr. Parkman turned round, placing his hand under his coat, and he mentioned it at the time to Mr. Russell. He says that he went to his dinner, came back, and waited there till his young man, who went at 2 o'clock, returned, and that he thence went to the market to purchase his provisions for the succeeding day, and that he knows that he did it upon that day, and that he knows that he did not do it at any other time. And he fixes it by saying that on Saturday his business required him to be at his store at a later hour than on any other day. He was informed by his wife that the two men came to his house to inquire for Dr. Parkman, who was missing, and he immediately said to his wife, "I do not think Dr. Parkman can be far off, for I saw him yesterday afternoon." Now, gentlemen, if this is true, here is evidence inconsistent with the theory of the government. The only circumstance which has been interposed here to affect the testimony of Mr. Wentworth is that Mr. Russell has been called this morning and testifies that he has no recollection of that event, none at all. He remembers now that at some time he was walking with Mr. Wentworth, that they met Dr. Parkman, and that Dr. Parkman was spoken of to him by Mr. Wentworth. But the time when it was has faded from his recollection to such an extraordinary extent that he told you he could not say whether it was 1 day or 3 months before the disappearance of Dr. Parkman. It has faded entirely from his recollection. He remembers nothing at all about time when or place where, but he remembers simply the fact that it did occur. He says, indeed, that if it had been on the occasion mentioned by Mr. Wentworth, he thinks when the disappearance of Dr. Parkman came to be spoken of, he should have recollected it. It may be so, or it may be not. We cannot explain the workings of our own minds. I put it, gentlemen of the jury, to your experience. We are engaged in a vast number of occupations. We see a vast number of individuals. Crowds pass in the street. A casual observation is made. We speak to this friend and to that, and there being nothing to impress it upon our mind, no impression is made. No process of association can bring it back again. And I put it to you, gentlemen of the jury. You have been separated from your fellow citizens many tedious days. Throw back your recollections to the day of your separation, and answer to your own consciences and your own understandings individually, whether you can now account to yourselves or to anybody else all the persons whom you saw the day before you came, and the conversations that took place. The important transactions of that day are stamped upon your minds, but the unimportant, the transient ones are gone, my gentlemen, with the air that you breathe. And so it is with Mr. Russell. The thing was of no consequence. It passed out of his mind, so utterly passed out of his mind that time, place, and circumstances are gone, and all that he can bring back is that, sometime or other, something of this sort took place. But Mr. Wentworth, on the other hand, is unimpeached, and I stand here to say an unimpeachable witness, with a responsibility which touches this government, a responsibility for which he is to answer here and hereafter, stands here to say that he knows when it was, that he has always known it, that this fact did make an impression on his mind, that he found the trace of it at the moment when he knew that Dr. George Parkman was lost, and that he not only recognized that trace then, but that he gave audible utterance of it at the time. Such, gentlemen, is the testimony of Wentworth, and such the position he occupies. We come then, gentlemen, to the testimony of Mr. Cleveland, the witness from Chelsea, a man of intelligence, and one would think from the account he gave of the pursuit in which he was engaged on the afternoon of the 23rd of November, connected, as he is, with valuable institutions and a man of standing and substance in the community, that he would be a witness entitled to your most implicit confidence. Mr. Cleveland tells you, gentlemen, that on the morning of that day, he, as a member of a religious society in Chelsea, as an agent acting in its behalf, was taking measures to secure the attendance of a clergyman upon the next Sabbath morning, that he wrote a note to one of his friends, and that note was dispatched, but returned to him unopened, that he had occasion to write another to one of his friends, to which he received an answer. The note returned was thrown into his desk, and those notes can now be produced. They are on the table and can be presented to you the moment the Attorney General is willing. He knows this was Friday, from the business in which he was engaged, from the time in which he did that business, and from the notes which were written, one of them by himself and the other by a clergyman, a friend of his, both of which notes he offers to produce, to fortify his recollection. He says that in the afternoon he had occasion to go to Franklin Street to meet a clergyman, that he passed through Devonshire Street, Theatre Alley, into Franklin Street, saw his friend, had his communication with him, and then immediately passed into Washington Street, and in that street between Franklin and Milk Streets, at an hour which could not vary much from 20 minutes after 3, he saw Dr. George Parkman coming towards him. He saw him under circumstances which particularly attracted his attention. He thought them a little peculiar. He knew the position which Dr. Parkman occupied in society, that he was a man of affluence and wealth. He saw him walking with a laboring man in his common and ordinary dress. In consequence, he watched him. He discovered that they separated, that Dr. Parkman was not walking with this individual as he thought he was. He kept his eye upon him, and they passed side by side. He saw him at a distance of 4 or 5 rods, and saw him when they met and passed each other. About the time there can be no question. About the place there can be no question. It was Friday, the 23rd of November, 20 minutes after 3, in Washington Street, between Franklin and Milk Streets. Was it Dr. Parkman? Mr. Cleveland knows him as well as you know his honor on the bench. He had known him for years. His attention was particularly attracted towards him. It was fixed in his mind. And when it came to know of the disappearance of Dr. Parkman, he communicated it to the government and was told that it was of no consequence to inform the police of it, because Dr. Parkman had been seen on Washington Street at the South End afterwards. Here is a gentleman, beyond all doubt and suspicion, who tells you that he saw Dr. Parkman at this hour. Then, gentlemen, there is the testimony of Mrs. Rhodes and her daughter. They say that on that afternoon they visited this part of the city. They came from the westerly part of the city where they reside to do some shopping for the family. Among other places, they went to Hubby and Company's store in Winter Street, and they have purchased a dress. The number of yards and price were given, and going to Mr. Hubby's, it is found that on that day there was sold this article, precisely at this price per yard, and precisely this price in the aggregate, and that there was no other such sale as that on that day. I suppose that no one in his senses will question that this dress was purchased, and that they went home. Mrs. Rhodes says that the bundle was carried by her daughter, and the daughter says she carried the bundle, and as she passed Dr. Parkman, she shifted the bundle onto the other arm, in order to avoid striking him with it. I suppose there is no doubt that they passed an individual who they say was Dr. Parkman. Mrs. Rhodes says that she was acquainted with Dr. Parkman, and had been for many years. She was a member of Dr. Francis Parkman's church, and knew the brother in the pulpit and the brother in the world, the one as well as the other. She says that this acquaintance between them was such that they always bowed to each other as they passed, and, as she came up to this gentleman, that she did bow to him, and that he recognized her and returned the bow. The daughter says that she noticed what took place, saw Dr. Parkman, knew who he was, saw him bow to her mother, and saw her mother bow to him. It was Dr. Parkman. They both tell you so, upon all the responsibility which can rest upon any individual in society. They have much at stake. They know perfectly well the importance and the materiality of this testimony of theirs. They know, gentlemen, that it contravenes the hypothesis of the government. They know that it comes in opposition to views now taken, and now held, not only by the government, but by the family and friends of Dr. Parkman. And Mrs. Rhodes, a woman of unblemished reputation and unsuspected character, knowing full well how this thing is held out to the family, how her friends think in relation to this matter, that she is laboring under a mistake, has dwelt upon it with all hope and all desire to come to the truth, and she asserts that she must now say, let the consequences be what they may, that this man whom she met at that time was Dr. George Parkman. Do you know that it was not? Another witness, Mrs. Greenough, says that on the same day, 10 minutes before 3 o'clock, she met, as she believes, Dr. Parkman in Cambridge Street. She is a woman of much respectability, as I venture to say any of you will admit. She had occasion to come into the city on an engagement of a social character. She had occasion to see her son, who left his home at 3 o'clock. She says that, as she was coming through Cambridge Street, making no particular observation, she saw her old acquaintance Dr. Parkman on the other side of the street. She recognized him, passed on, and looked at the Lynn Street Church. She fixes the hour and at the time and place. She does not state as strongly as the other witnesses that the person she saw was Dr. Parkman, but she believed it then and believes it now. She would not say in dogmatical language that it was not possible for her to be mistaken. On the next day, her husband informed her that Dr. George Parkman was missing. She immediately said, I saw Dr. George Parkman yesterday. End of section 25. Section 26 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 16. This, then, gentlemen of the jury, is the testimony upon which we rely to convince you that Dr. George Parkman did separate from Dr. Webster, that Dr. Parkman went from that college and was abroad in various parts of the city. During the afternoon of that day, he was seen in different and, to some extent, in distant parts of the city. He did not return to his family, and that is strange. He was never seen afterwards, and that is strange. Something intervened that day that was very strange. Something occurred that day which we cannot understand, which we cannot reach or know. What that was, who can tell? Can you, upon the evidence which has been presented to you? When his friends made first a comparatively slight and fruitless search, they gave notice to the world that they put their minds upon causes which might produce a strange effect, and it is neither uncharitable nor unjust, nor unreasonable to suggest to you now what upon the greatest deliberation was suggested by his friends then. We start no new theory, but we take up the theory of his friends, those who knew him best. They say, in the advertisement which they put forth to the community, that he might have strayed away under the influence of some sudden aberration of mind. They thought that reasonable, or they would not have said it. They would not have put forth a suggestion of that sort under a reward of $3,000 without believing it, and yet they did it. We cannot tell whether it was so. We know that responsible, unimpeachable men and women with organs of vision capable of determining this question did see this man abroad. Who can say that that is not true? The suggestion may be that they are mistaken. They may be mistaken, but are you certain that they are mistaken? So certain, gentlemen, that these men and women are mistaken, that you dare touch the heart's blood of this man who is upon trial? Gentlemen, contrast this proof with some other that has been presented here. When the mangled remains of this human being, whosoever he was, were spread out on the floors or on the tables of this medical college, and exposed to medical gentlemen and friends, they were asked to view and see if they could find anything dissimilar to the frame of Dr. Parkman, and they bring the answer to that question here as a fact, from which you are to draw an inference. Yet in the same moment that they are asking you to systemize the evidence which they present in regard to the want of dissimilarity in these remains, so that you can draw such a conclusion as that, they are asking you to believe that responsible men and women are mistaken, not in the naked leg, but in the open face, the open, clear living peculiarities of the living man. What are we here for? What is your solemn duty? To weigh all the evidence, not apart, not to take up the system, the theory of the government, and see whether the evidence of the government will sustain that theory, not to see whether the evidence which they produce tends to establish that hypothesis. It may be that all the facts they maintain should exist, and yet that the prisoner at the bar should have had no hand in the atrocious perpetration of the murder, because they parted after the interview had taken place between them. I commend it, gentlemen, to your sober consideration that you have upon this question as solemn a responsibility as ever rested upon the consciences of human beings. Gentlemen, I shall proceed to the examination of the testimony which the government have brought to your consideration, and I mean, gentlemen, to treat the testimony with all the fairness of which my mind is capable in examining or in presenting it to you. I do not feel, gentlemen of the jury, as if I was here in strife or in contest with you or with anyone. I do not feel, gentlemen, as if I were here in strife or in contest with my friend, the Attorney General. We come here not to contend for victory, but to learn the truth, to vindicate justice, to administer the law. And when I speak to you, I do it in the hope that I may aid you in the great duty the solemn duty which you have to perform. If I sometimes speak earnestly from deep convictions, I know that you will not understand me as fearing or apprehending that I have anything to overcome, any resistance to be encountered, any opposition to contend with. No, you are my friends, the friends of the prisoner at the bar, as you are the friends of all men in the community, of which you are brethren with them. Let us look, gentlemen, to the facts, in the order in which the government are bound to prove them, and see how far their evidence, direct or circumstantial, tends to prove their case. The government must prove the guilt of the defendant. I say they must prove it. The burden of proof is exclusively upon them. If they do not establish beyond reasonable doubt the several facts which they are bound to prove, they cannot claim nor ask for a verdict or conviction. The law presumes that the prisoner at the bar is not guilty, unless it is forced upon the minds of the jury by a just consideration of the evidence brought against him. And it is upon these two great and leading presumptions of the law, that the defendant is innocent until his guilt is proved by the government, and proved beyond reasonable doubt, that I approach towards the consideration of them. They are first, to establish the death of Dr. Parkman. Secondly, to establish that his death was occasioned by the agency of the defendant. First, had they proved to your satisfaction that Dr. Parkman is dead? They have much evidence, certainly, tending to establish this fact, and I wish to state that evidence to you, with the single remark that it is for you to pass upon, before you can proceed into the investigation of the other more material parts of the case. Dr. Parkman entered the medical college on Friday, the 23rd of November, and since that day he has not been seen. To show that he is dead subsequent to that day, certain remains of a human body are found, and evidence has been given to you in reference to those remains, tending to show the identity of that which has been found with that which was lost, tending to identify the dead with the living. In the first place, gentlemen, there were remains found in the vault beneath the privy, other parts in the tea chest, and still other parts of a human body in the cinders of the furnace. Intelligent and most respectable gentlemen have been called here to testify with regard to each and all the parts of this body. Dr. Wyman, who has exhibited much skill, much science, much knowledge in his profession, has stated to you that the bones, the fragments of bones, which he finds, corresponds with or belongs to parts of a body which were not found in the tea chest or vault. And he states that these fragments of bones constitute part of the head, neck, arms, hands, feet, and one leg below the knee, and that there was among these fragments nothing duplicated, no fragment which must necessarily have existed in two human bodies, no fragment which could have existed in any part of that found in the tea chest and vault. Now, upon this testimony, you are to consider, and I have no doubt of the result at which you will arrive. If all these fragments did constitute the parts of one human body, in different states and in different conditions, the inquiry then is, were those remains the body of Dr. Parkman or not? And upon this point, certainly, you have strong proofs, perhaps entirely decisive, but of that you must judge. You have the testimony of these same medical gentlemen who say that the structure of Dr. Parkman was somewhat peculiar, that these remains, examined in the best way they could, corresponded in all particulars with the body of Dr. Parkman, in the form, the structure, the size, the height, the color of the hair, the growth upon the back, certainly very strong circumstances, tending to establish a probability that this was the body of Dr. Parkman, and this is done, perhaps effectually, perhaps conclusively, by the testimony of Dr. Keep, the medical gentleman who had occasion to make the teeth of Dr. Parkman 3 years before, who had occasion often to examine them, who has compared the teeth with the model to which it adapts itself. He declares that he cannot entertain a particle of doubt that they are the same, and these connected with circumstances which tend to show that they were fused while in the mouth of Dr. Parkman. These circumstances are strong. We have called your attention to the testimony of Dr. Morton, an eminent and intelligent and skillful dentist of this city, who has given to you clearly his views on the subject. Not that we call him to contradict Dr. Keep, but that you may understand this testimony which has been presented. This has enabled the government to bring in Doctors Harwood, Tucker, and Codman, who have confirmed the general statement of Dr. Keep. And I have only to say that this is a question about which you are to pass. If you are satisfied that this body is the body of Dr. Parkman, that settles that point. If you are not satisfied, their case is gone. What was the cause of the death? And that is the thing which requires your particular attention. Have the government satisfied you beyond reasonable doubt that Dr. Parkman died by violence? I shall not now, of course, call your attention to any part of the testimony of the government by which they attempt to implicate Dr. Webster, but taking the circumstances having a tendency to show that Dr. Parkman came to his death by violence, separate from anything which implicates Dr. Webster, let us see whether it is certain, beyond reasonable doubt, that this body which was found came to death by violence. I suppose the government will rely upon two circumstances which have been given in evidence as tending to show this fact, which two circumstances are quite insufficient in justifying a jury to come to such a conclusion. I refer to the supposed fracture of the skull and to the perforation of the side. As to that portion of the bone presented by Dr. J. Wyman as having some tendency to show that there was a fracture, I have scarcely occasion to say more than to remind you that, in answer to an inquiry from the Chief Justice, Dr. Wyman said that though there was an appearance that that fracture occurred before the bone was subjected to heat, yet there was nothing which would enable him to determine whether it was before or after death. But with regard to the other question, even whether it was before or after calcination, Dr. Wyman was by no means certain that it was before it. If it had not gone so far in the calcination, then he might not have found the ragged suture, as it might have been caused by calcination. Dr. Holmes, a young gentleman. A voice, not young. Dr. Holmes, a middle-aged but very respectable and intelligent physician, who was old enough to have been one of the physicians in the Massachusetts General Hospital and a professor in the medical college, tells you that, in his opinion, this fracture was not caused before calcination, and when asked whether he would not defer to Dr. Wyman, he says, not in this particular, though I would cheerfully in others. In reference to this particular examination, he says that he has examined, and his own observation is as good as anybody else. It is uncertain whether that fracture was before or after calcination, whether it was before or after death, and so it furnishes no guide to the jury in determining whether death was caused by this fracture or not. Next, as to the perforation in the side, it appears from the testimony of Mr. Eaton and Mr. Fuller that this perforation was discovered almost immediately after the thorax was taken from the T-chest. They noticed it. If they are right, it was so. I shall not stop to question their accuracy. It was there before. But how? Was it a cut? Dr. Woodbridge Strong testifies that it was a clean cut, made with a knife, and in his judgment it must have been with the knife. On the other hand, you have the opinion of three intelligent and scientific gentlemen called upon to make the examination of the body, Doctors Lewis, Stone, and Gay, and who made the examination with care and precision, writing down their testimony at the time, preparing to testify before the coroner's jury, an examination made at the moment when all inquiry was of the utmost importance, when every circumstance was sought for as a momentous matter, in ascertaining the truth in relation to this great and overwhelming calamity which had come upon the community. They tell you, one and all, that there was no knife cut there, that it was a ragged opening, that there were no indications upon the side, external or internal, that it was a clean cut, made before or after death. Now here is a disagreement between these medical gentlemen. What are you to do? Do you know how the fact is? If you do, you can act upon your own judgment. If you do not know, but are trying this cause upon the evidence, then you have the testimony of 3 witnesses that, whenever or however that hole was made, it was not made by a sharp instrument. If that is a fact, then the government are destitute of evidence to show that Dr. Parkman, if this was his body, came to his death by a blow upon his head or a stab upon his side. How did he come to his death? Remember, it is not for the prisoner at the bar to explain how these were dead remains, but the government are to show you that a living man was killed. How was he killed? Was he killed at all? Do you find upon the person wounds, blows, and evidences of destruction sufficient to take human life? To take a man's head off kills him. To take his breastbone out and separate all the internal parts of the body kills him. To cut off his arms and his thighs kills him. To put his head in the fire and burn it to cinders kills him. Was Dr. Parkman killed in any of these ways? Do you think he was burnt to death? Was his limb placed in the fire? That limb of which you found fragments, was that put in the fire till the fire scorched him to death? Was his head placed so as to be burnt alive? Nobody believes it. Do you believe that he was killed by having these 2 legs cut off? That he was laid upon the floor upon an anatomist's table and held there until his legs were chopped off? Nobody believes that. Or was he held there until his arms were chopped off and all his limbs severed? Nobody believes that. That is to say that, though you find this body mutilated, distressingly mutilated, yet nobody believes that this mutilation was the cause of death. What then was the cause of death? After all the investigation which has been made, this matter is as dark as it was before light went into the cavern underneath the medical college. How the man, the victim, call him which you will, how he died, no man knows. Then, gentlemen of the jury, are the government to ask you to say that this was a death by violence, when they cannot say how it took place? When the charge shows that they don't know, can they ask you to draw the inference that he must have been slain? Can they ask you to draw the inference from the fact that he was alive on the 23rd of November, and that on the 30th his mangled remains were found, that it is an inevitable consequence that he must have been slain? Take the case which is ordinarily put of presumptive evidence, and see how widely it differs. A man is seen running from a house with a bloody sword in his hand. The spectators immediately pass into the house and find a bleeding body, convincing them that there has been a sudden death. Upon examining him, a wound is found upon his side, which corresponds with the sword. The inference is unavoidable that the man has died in consequence of the flowing blood. He is suddenly found dead. But here, the disappearance on the 23rd, the discovery of the body on the 30th, 7 days afterwards, and there is nothing found but what might have been inflicted after death. How then is it certain beyond reasonable doubt, so that it is safe to say there has been a murder here, that this body was brought to its death by crime and violence? Gentlemen, death visits the human family in 10,000 forms. Sometimes its approaches are lingering and slow. Sometimes it takes us suddenly by the hand and relieves us at once of life. Can you say certainly, have you this evidence, that because 7 days after the disappearance of Dr. Parkman, his mangled remains were found in this college, that he did not die a natural death, which might have reached him as it often reaches the rest of the human family, suddenly and unawares, that in some strange way which you cannot see, because of the thick darkness in which all human life is shrouded, because you cannot see how it is done, you will leap through the thick fog and by circumstances almost irrelevant imperfectly conclude, that death came in the form of violence applied to him. Gentlemen, you will take care in forming your judgments upon this matter. If one man has gone, if that man was our friend, if he was most respected in the community, if his loss has left a deep chasm in society, if his absence has touched many hearts, and he be mourned over by many friends, still you are to remember that before you affect the rights, the liberty, and the life of one of your fellow beings, you must be sure that the great fact of death by violence was established. Lord Hale said, in reference to circumstantial evidence, that he would never advise a conviction upon circumstantial proofs unless, at least, the body had been found. Gentlemen, the writers upon law, the expositors of the law, upon the bench and in the books, have declared that this same caution is equally applicable to the means of death as to the discovery of the body. When the body has been found and can be identified, the first care should be to see that the proof is clear that that body ceased to live by violence applied. And if it cannot be shown, by direct or by indirect circumstances, that the body came to its death by the agency of another, though strong suspicions may exist, and the greatest of jealousies may fill the minds of men, still there is a want of that perfect judicial proof, upon which men, conscientious men, acting in the discharge of their duty, are bound to proceed. It is so here, gentlemen. I do not undertake to say to you that Dr. Webster can, or that his counsel can, supposing these remains to have been those of Dr. Parkman, explain how he came to his death. We do not pretend to do any such thing, but, gentlemen, we do pretend to say that the government must prove this fact, an essential fact in the case, and when we say that these marks might have been inflicted long after death, and that there is no evidence that they were inflicted before death, when death comes in 1,000 forms, when he might have fallen by the wayside, when some robber may have seized the body, and having plundered it, then in the midst of an excited community, searching everywhere, fearful of discovery, have thought to have taken these remains and placed them there. Can you say that such was not the case? Or can you say that these circumstances impelled you irresistibly to the conclusion that George Parkman came to his death by the agency of another person? I submit it, gentlemen, to your calm inquiry, and if the evidence on the part of the government upon this subject comes only to create a strong probability, but does not come up to the clear fact, beyond reasonable doubt, that this body was slain, there is an end of this trial. End of section 26. Section 27 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 17. But, gentlemen of the jury, suppose that you pass these questions by, that you come to the conclusion that this was the body of George Parkman, and that his death was caused by the violent agency of another person. What was the crime which was committed in taking his life? I shall here necessarily, gentlemen, be obliged to anticipate, but I ask you carefully to discriminate. I am going to attempt to show you upon the circumstances which have been developed upon this trial, taking all the government's case, and making the worst of it for the prisoner in their behalf, that the crime which was committed, if it was committed by Dr. Webster, was not murder, but manslaughter, because the circumstances warrant the conclusion that it was the lesser crime. Do not misunderstand me. As the counsel of Dr. Webster, called here to protect him in this hour of peril, when his life is at stake, his counsel do not feel at liberty to stand exclusively upon the ground upon which he stands. He denies that he took the life of Dr. Parkman, but, gentlemen, His counsel cannot know what effect the evidence which the government have presented upon that question may produce upon your minds, and therefore, if it should come to that you should arrive at such a conclusion as that Dr. Webster did the deed, then, gentlemen of the jury, we must ask you to say, what was it that the prisoner did? What law did he violate? What crime did he commit? I contend that it was manslaughter, if it was committed at all. Gentlemen of the jury, the law upon the subject of murder and manslaughter was stated to you, in the clearest and most distinct manner, by the counsel with whom I have the pleasure to be associated. The distinction is simply this: homicide with or without malice, and we contend that the evidence in the case will warrant the jury in coming to the conclusion that if there was a homicide here, that if Dr. Parkman came to his death by the hands of Dr. Webster, it was under circumstances of such extenuation as reduces the offense from murder to manslaughter. You understand that if a homicide be committed, it is murder, unless there is extenuation. That is to say, unless it was done with sudden combat or with justifiable provocation. The question then is, if a homicide occurred, if Dr. Webster was the cause of the death of Dr. Parkman, did it occur under such extenuating circumstances as will reduce the crime from murder to manslaughter? Now, gentlemen, you will receive the direction of the court as to what is necessary for the government to do in order to establish the fact of malice aforethought. Without malice, the crime of murder could not have been committed in a homicide. I do not understand the case of York precisely as it was understood by the Attorney General, though I do not know as the difference is material. I understand the case of York to have the same bearing as the case of Sir Michael Foster, that the fact of the murder being first proved, all the circumstances of extenuation, which are to reduce from murder to manslaughter, are to be established, or it is murder. The opinion put forth in the case of York, as it was applicable to that case, was on the question whether it was voluntary or not. I do not understand that it made a difference whether it was done in secret or not. This reference to secret murder being argued by the magistrate. Chief Justice Shaw. The proposition that was affirmed there is universally applied. It was that the fact of homicide, voluntary killing by design or by the use of a deadly weapon, having been first proved, the circumstances of justification in self-defense, or in whatever other way it may be instigated, may either be established by proof or arise out of other circumstances on the case. Mr. Merrick, that is as I understood the case, and as I had supposed the law of the case would be stated to the court. Chief Justice Shaw, the evidence on both sides is to be taken into consideration, and the instigating facts may arise out of all the circumstances of the case. Mr. Merrick, that is all material to this case. Gentlemen of the jury, upon this question whether the homicide was murder or manslaughter, if you are satisfied that Dr. Parkman came to his death by the hand of the defendant, and that he killed him by design, then the law implies malice, or malice aforethought accompanies the act of killing by design. The use of a deadly weapon indicating design or purpose to accomplish that object. But in determining this question, the jury are to look at all the evidence in the case and see under what circumstances the homicide must have been committed, and if, upon the consideration of all those circumstances, it shall appear to the jury, by a fair and proper inference from all of them, that the homicide was not by design, but was committed under extenuating circumstances of provocation or sudden combat between the parties, then the crime committed was manslaughter and not murder. I suppose, gentlemen of the jury, that the government mean to put to the jury that there is evidence in this case of express malice. It was so stated by the Attorney General in the opening of the case. I understand what that express malice is understood to consist in, and therefore, Before I go to the circumstances of the case, I would call your attention to the other circumstances which go to establish the fact that there was malice prepense. That is, that this crime was premeditated, that he designed to kill Dr. Parkman before he went into the college. That is the broad statement of the government, that Dr. Webster planned this homicide, that he devised the means, that he seduced him to the college by false pretenses. The ground upon which this conclusion is based is this. Dr. Webster states that on Friday the 23rd, Dr. Parkman met him by appointment. The appointment was to accomplish a particular piece of business, namely, that Dr. Parkman should bring to his place certain papers and notes, and that he should receive there certain money, and cancel those papers. Professor Webster says that following this appointment, the interview took place and the business transaction occurred, that Dr. Parkman came there bringing with him all, or a part of the papers, that the business was transacted between them and that they separated. The government deny this. They say that this business transaction did not take place, that Dr. Webster did not pay Dr. Parkman this money, and they ask you, gentlemen, to believe and to conclude that he did not pay it because he had not the means of paying it. And then they ask you to conclude that, as he had not the means and did not pay it, that this appointment was the means by which he intended to induce Dr. Parkman to come to the college. It becomes then necessary to allude to the evidence of the government in relation to this matter. They have called several witnesses. They have called Mr. Petit, who sold Dr. Webster's tickets to the medical course of lectures, and they have shown how the money was paid by Petit to Webster. And they have shown evidence from the deposits in the Charles River Bank that deposits to an equivalent amount followed the payments of Petit for the tickets. Then they have shown either what become of these deposits before Dr. Webster was arrested or since, and they attempted to show in that way that all the funds which Dr. Webster derived from the students were used in such a manner that he had none of them to pay Dr. Parkman with. The evidence seems so satisfactory that I shall not attempt to contest it at all. I suppose it is so. Not only do I suppose it is so, but I am fully authorized to concede it was so. That was not the money paid to Dr. Parkman. Then the government had called certain other witnesses, Mr. Henchman, who testifies that on the morning of this day, the 23rd of November, Dr. Webster presented him with a check drawn on that day or the day before for $10, which Mr. Henchman cashed for him. He had funds in the bank and the money might have been paid. And if the check had been sent over at that time, it would have been paid. There is no doubt of that fact, that Dr. Webster wanted this small sum of money for his temporary use. He was in the habit of depositing for his daily use in the Charles River Bank, and as he wished to use the money, he drew it out. And accordingly, you will find that in almost all the instances, the money was drawn out in small checks. Then they have called Mr. Smith to show that Dr. Webster was unable to pay or unprepared to pay a small bill to him, and that Dr. Webster wrote back to him saying that that bill should be paid when the money came in from the sale of his chemical lecture tickets. That is true. You perceive that that debt, like that of Henchman, was unpaid on account of his daily expenses. That was to be paid from the chemical lecture fund. We conceived that Dr. Webster wanted money for his daily expenses, and that he drew it from the source from which he was accustomed to draw all his money, and that he did not wish to appropriate this money to other uses. Now, as to this money paid Dr. Parkman, I am free to say to you that we have not offered proof to show where it came from, and this we cannot do. Yet the circumstances of the case are such as do not show that Dr. Webster had malice in his heart to contrive the perpetration of this most atrocious crime, for the want of this money. Gentlemen, you know now, as well as Dr. Webster knew then, that he was a debtor, and that Dr. Parkman was his creditor. You know that Dr. Parkman had made up his mind resolutely in reference to his debtor, and that Dr. Webster knew it too. You know that Dr. Webster knew that there had been transactions between himself and another party which, unexplained, throughout to the community, would touch to the core the reputation of a man standing in the position in which he did. You know that, in the exigency of the time, he had mortgaged his property to George Parkman. That consisted in part of his minerals. You know that, subsequent to that, in his exigency, he had afterwards raised $1,200 by a bill of sale of those minerals, which had exasperated Dr. Parkman, but which Dr. Webster vindicated by a long letter to Mr. Shaw, which unhappily is not here. Dr. Webster knew that the time was coming, and that speedily too, when he must answer to Dr. George Parkman. He knew that the time was coming when he could no longer ask for delay or forbearance, but must be prepared to meet the claim. I will not call it inexorable, but the earnest claim which Dr. Parkman must make against him. He must be prepared for that great day, for it is a great day with a man in Dr. Webster's situation, with a man with a large family, with expensive habits and an expensive condition in life. When such a man is called upon to pay a considerable sum of money, he is obliged to strain himself on that side, and on this side, and to gather in a $50 bill here, and a $20 bill there. And it was in this way that this money for Dr. Parkman was hoarded together, little by little, gathering it where he could, and collecting it where he could, knowing that the time was coming when he could not put off the day. If you will examine the books, you will find that of $195 paid at one time by Mr. Petit to Dr. Webster, $150 were deposited in the Charles River Bank. All the other sums which he received from Mr. Petit were deposited in the bank. But of this $195, $45 were saved out, and made up, gentlemen, with the previous savings, the means of meeting the claims of Dr. Parkman. In the meantime, he was subject to calls from other quarters, and though he might, at somewhat of an earlier day, have made payment to Dr. Parkman, yet, from the relation in which they were placed to each other, he was not over willing to gratify the immediate demands of Dr. Parkman, but was willing to put him off as long as he could. There was no friendly relation between them. All he meant to do was to put himself in a situation. When the time did come, and Dr. Parkman came with the pressure that he could no longer resist, that then he could meet him, pay him, and be rid of him. And that, gentlemen, is the history, as far as I can detail it to you, of the circumstances in this case. There are corroborating circumstances, gentlemen. Understand me, that this is not gathered from imagination. Do not say that Dr. Webster, to some extent at least, is not fortified by the facts in the case. Let us see if we cannot find such facts. Remember two circumstances. Dr. Webster says that he paid $483. Of that money so paid, $100 was in a bill of the New England Bank. Another circumstance in this connection. Brown, the toll man, says that on Friday he saw Dr. Webster passing the Cambridge Bridge and asked him what he paid Dr. Parkman. He replied he could not tell. Some large and some small amounts, some of which came from the students in the medical course. The tollman asked if Dr. Webster could recognize that $20 bill, said that an Irishman had offered a $20 bill to pay a 1-cent toll, that he thought it rather strange that an Irishman should have that money and pay it for toll, and suspecting he might have got it from Dr. Parkman, he went to ask Dr. Webster about the bills that he had paid to Dr. Parkman. He had been at the college, and spoke of this as he was passing back to Cambridge. The tollman said that he understood that the money came from the students, but the idea intended to have been conveyed to the mind was, not that every dollar was derived from the students, but that portions of it were. This is apparent from the fact that he had received a considerable portion at a much earlier date. A considerable portion of the money received was distributed at once. $230 was paid to Dr. Bigelow. $195 were received afterwards, and $150 the next day were deposited, as the records, the testimony of Petit, and the bank books show. and therefore it is perfectly obvious that the idea Dr. Webster meant to convey to Mr. Brown, the tollman, was that he could not tell because he could not recognize the various bills that were paid, as the money came without defining the precise source. I suppose that the tollman was the last man to whom he would tell his particular affairs, but some of the money came from the students, on which there are two suggestions to be made. The first suggestion is of the saving of $45 from the $195. Second, that there was paid, according to the statement which he early made, the note of $100 from the New England Bank. Mr. Petit went to the New England Bank to get his money. He can't swear that he was paid, or that he paid Dr. Webster in money of the New England Bank. But your personal acquaintance with such matters shows, the experience of everybody shows, that they do not pay anything but their own bills from banks. He laid this money aside and paid it to Dr. Parkman. He had saved the rest of the money, but with the exception of the $100 bill. He could not identify what he had paid. He could not determine whether the $20 bill was one which he had had before. I suppose that he took this $100 which he had received from Mr. Petit and kept it, and deposited other money in the Charles River Bank. I wish to fortify these presumptions. I wish I could go to the persons from whom he received this money. Suppose that Dr. Webster had apprised his counsel. Why, I received such a sum of money here and such a sum there. A careless man in his money matters, and that $20, $40, or $100 in another place were received. And it should be proved not to be so, that there was a mistake about it. How hazardous a case it would be for him. Then it comes back to this course for daily savings. It appears that this situation was such as to require him to do it, that he had means, and that it might have been done. He says it was. You see, Dr. Parkman was his creditor, and his pressing creditor. The time of the lectures had come, and at that moment he must preserve his place. Dr. Parkman had him in his power. He prepared himself for the time. He availed himself of all practical means to come to it. Then see if Dr. Webster is, or is not, corroborated in his statements on this subject. The government counsel apprised us, after all the evidence was in, that he should claim not only that there was this money due to Dr. Parkman, that Dr. Webster says he paid, but that the large note comprehended debts which were due to other parties, amounting to $512. Gentlemen, there is no other evidence in the case upon that subject from which the Attorney General can argue. Nothing but the note and papers in the case. These notes and papers are, then, to be taken into consideration to see whether this is so or not. Now, the mere fact that Dr. Webster is found in possession of these papers would, under ordinary circumstances, create a presumption in his favor that he was fairly and honestly and justly entitled to them. And as the law presumes that he is innocent until he is proved guilty, therefore, this presumption exists in his favor until the government establishes the contrary fact. Now, Dr. Webster does not pretend, and he never pretended, that he met Dr. Parkman in order to pay anything else than the small note. Now, gentlemen, if you will look upon that small note and see how the $483.64 is made up, you will find that it is made up by computing the interest which is due to Dr. Parkman, not to the date of payment, but to a day considerably ahead. That is to say, apparently Dr. Webster paid Dr. Parkman more than was due. How comes that? Simply that these parties understood each other, and there was some doubt about how much was due. And then there was a proposition, as Dr. Webster said to some witnesses, that when Dr. Parkman came and said, "There is so much due," "Yes," he replied, "that is what we agreed upon." That is to say, they had fallen into some difficulty about it, and then had finally agreed on that amount. Then, gentlemen, you have another circumstance. It is stated by everyone who speaks of the conversation of Dr. Webster, in relation to that individual that Dr. Webster spoke of the mortgage. He did speak of the mortgage. He says that after the money was paid, that is, the notes were canceled, something was said in relation to the mortgage. It was rather an imperfect statement, but the amount of it was this, that Dr. Parkman said he would take care of the canceling of the mortgage. Accordingly, you perceive that Dr. Webster did, on the next day, not only believe that the mortgage was to be canceled, but, in point of fact, went to the city office to see if it was so. This is important because if you can find a basis of truth in that statement which is made by Dr. Webster at that time, it will enable you to complete the parts, just as Dr. Wyman found, from the fragments of bones which he collected, sufficient indications to determine to what parts they belonged, and to assist in reconstructing the entire skeleton. Dr. Webster says that Dr. Parkman would see it. You do not find the mortgage in the possession of Dr. Webster, but it has been produced here from the papers of Dr. Parkman by the government. Now I think, gentlemen, that this is a strong corroborating circumstance. Look at the whole series of these business transactions. It appears that Dr. Webster was the debtor, that Dr. Parkman was the creditor, that Dr. Parkman meant to have his debt paid at all events, and that the note must be met. Then, as to a portion of his money, you find that Dr. Webster did receive money from the New England Bank, which would correspond in part with the money paid. Some portion of the money received from the tickets was not deposited. You find that the business transaction took place, that Dr. Parkman went down there with the expectation that something would be done. He did carry his papers with him. That took place between the parties at that time, which resulted in this, that Dr. Webster got possession of the notes and Dr. Parkman kept the mortgage. Now I put it to you, that in this state of facts, although this is not clearly proved, yet that the explanations are sufficient to refute this assumption taken by the government. This inference from his want of means, from the idea that Dr. Webster had not any money, and so seduced Dr. Parkman by false pretenses to come to his place, is totally groundless. These are all the considerations that I have to present upon this subject, and I ask you to consider them. I do not say that the argument on this part is perfect, but it is for you carefully to discriminate and to secure the truth, and consider whether it is not ample to repel that suspicion of the government, that it must have been that Dr. Webster had not any funds, and so premeditated this awful crime. I put it to you, whether it is not more reasonable that this outline of this condition in which Dr. Webster was is true, than that a man of his standing in life should have set down deliberately the way of blood. And yet to one or the other of these conclusions you must come, and you must come to the latter conclusion, or you cannot sustain this hypothesis of the government that there was malice aforethought expressed, because Dr. Webster had not the means of making the pecuniary payment. I beg you to weigh it well, for on it are the issues of life and death. That was to be paid from the chemical lecture fund. We conceived that Dr. Webster wanted money for his daily expenses. End of section 27. Section 28 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 18. I wish now, gentlemen of the jury, to call your attention to those circumstances which tend to show the character of the transaction. Upon the supposition, with the idea or hypothesis, that the death of Dr. Parkman was caused by the prisoner at the bar, at the time of the interview between them, at the Medical College, November 23rd. And here you perceive, gentlemen of the jury, that we were under the necessity of relying exclusively upon the circumstances If Dr. Parkman died under the hands of Dr. Webster upon that occasion, no human voice can relate to you the circumstances except the voice of the prisoner himself. No direct testimony can come to you. Still, you are judges of the fact, and in this instance, as in everything else in this case, you are to weigh circumstances and deduce from circumstances the inferences which are the just and proper conclusions from the fact. Now, gentlemen, I contend that the circumstances which must have accompanied that scene of death, if death they were, must have been such as to have extenuated the offense committed, from the crime of murder to the crime of manslaughter. What was the relation of these parties to one another? The circumstances under which they met, and from which they never separated, according to the government, both alive. You have heard of the relation between these parties, of debtor and creditor. You know that for a long period of time, Dr. Webster had been indebted to Dr. Parkman. You know that Dr. Parkman became exasperated to some extent against him, in consequence of the acts on the part of Dr. Webster's which Dr. Parkman denounced as unjust and dishonest. And under that imputation of injustice and dishonesty, you know from the evidence given that Dr. Parkman meant to pursue and did pursue him. I speak in terms well measured, so early as the first conversation which he had with his brother-in-law, Mr. Shaw. The feelings of Dr. Parkman were much excited against the prisoner, and I believe that from that hour to the last hour, when he was known to be in existence, that feeling never was removed, but became increased. You have the testimony of Mr. Petit, with whom Dr. Parkman had several interviews. He in vain endeavored to realize the money that was coming to Dr. Webster from his annual course of lectures. He was disappointed and chagrined. He had said to Mr. Shaw that he would have this money, and Mr. Shaw had endeavored to calm his mind. Both these gentlemen occupy a relation in respect to pecuniary means, well understood by the community. It was not the amount due from Dr. Webster to Dr. Parkman which made the money a matter of interest or of importance. A loss of that amount would never have been felt by Dr. Parkman, and undoubtedly under other circumstances he would freely have parted with much more than that, perhaps to Dr. Webster himself. But there were relations between them of an angry character. Dr. Parkman, as I say, was disappointed and chagrined with his want of success with Mr. Petit, yet he never forbore the purpose he had in his mind to enforce against Dr. Webster the payment of this money. He did not call in the aid of the law. He did not ask for a writ by which his property could be attached, but he assumed by his mode, I will not say of harassing the feelings of his debtor, that he should be able to obtain this money. Accordingly, you find that his pursuit was constant, his purpose unchanged and inflexible, and his manner, I think, never calm, in relation to this matter. He sent by Mr. Petit a message which, if it reached Dr. Webster, could not but have exasperated him. That message or another like it did reach him, I think you cannot question. So early as Thursday evening preceding November 23rd, there were irritating circumstances connected with this subject. Dr. Webster was aggravated. Probably never a profane word was spoken by Dr. Parkman. Yet that rash language was used, and in the common parlance, vulgar language was used, which came in some way to Dr. Webster, certainly showing that there was not a kind relation between the two. I doubt not. You see, it developed in other circumstances. So early as Monday evening of that week, that fatal week, Dr. Webster was at a late hour in that laboratory, where he toiled for his daily bread, reading a chemical book, as Littlefield has said. You find Dr. Parkman, I will not say intruding upon him, but calling upon him. A conversation ensued, and Dr. Parkman departed with a menace upon his lips. Something must be done tomorrow, said he. The time is passing. The morrow passed. Dr. Webster in the morning of that day, according to Littlefield and Maxwell, wrote a note to Dr. Parkman. I wish it were here, and did hope at one time That, with the multifarious papers produced on this trial by the government, that also would be presented. He wrote a note. Its precise terms are not communicated, but you will have no doubt that it had relation to the circumstances existing between them. Dr. Webster says that he came to him. That is a part of the memorandum found upon his arrest, and it is, therefore, confident for you to take into consideration that Dr. Parkman called again. At any rate, during that week he was watching the highways, endeavoring to anticipate the approach of Dr. Webster to the medical college. He was more than once at Cambridge Bridge. He was on the watch. He was on the inquiry. He asked the toll-gatherer the passages of Dr. Webster. On Thursday, having been at the bridge, according to the testimony of the tollman, he procured a conveyance, drove out to Cambridge, and when near Dr. Webster's home, made inquiries for it and returned. The next day they met, and by appointment, under the state of feelings and excitement which had been generated by their whole course of dealing, and by the pursuit of Dr. Parkman, so constant and so intermitting, so pressing and urgent, they met. Is it strange that men, meeting under such circumstances, should get into a wrangle? Is it strange or unnatural that one party, who felt himself to be pursuing a dishonest man, that he had been personally injured, would therefore take, I will not say the law into his own hands, but take that which would do more for him than the law could do, and would pursue his debtor? Is it strange that the debtor who had been thus pursued should retaliate, that this should breed angry words, and that personal collision should follow, and that personal collision should be followed by that which, when done, death would ensue? I am arguing under probabilities. There is in morals as well as in politics a regular succession of events. Passion has its way, as well as the laws of nature. The action of the mind is as regular as the motion of the planets in their spheres. It was as natural that men should fall into altercation, that altercation should be followed by blows, and that blows should be followed by death, as it is that any cause should produce its effect. Gentlemen, the parties met under these circumstances in this state of excitement, and we are now to suppose the death of this individual. This is all that we know. The creditor, pressing with a firm, if not with a hard hand. The debtor resisting. Justice may sometimes seem to be too exacting in its requisitions. The claim of right may seem to him against whom it is pressed to be urged too far, and the party will turn upon the other, who seems to him to be the aggressor. Word after word will be followed by blow after blow, and deadly consequences may ensue. Which, when we are speaking of probabilities, is more likely? Which most likely? The sudden altercation bringing the parties to combat, and from combat to death, or that there should have been on the part of Professor Webster a cold, slow, fearful calculation for a sin like this, that he prepared the way, that he seduced the victim, that he led him onto the snare, and coldly and deliberately slew him? No, gentlemen, the annals of crime tell no such story as that a man like Professor Webster, who was such a character in such a position, has at one single step leaped away from all the influences of education, social life, religious instruction, all at once, to the highest and worst crime that man can commit against his fellow. And yet, gentlemen of the jury, unsight and unseen, with these surrounding circumstances and these amazing probabilities, you are asked to believe that this crime was deliberate and with express malice, not that these parties, hot and excited from former altercations, freshened from every moment of intercourse that occurred between them, meeting for the last time when the work was to be done effectually for Dr. Parkman, that it should have led on to a combat. There is no alternative. You are to judge which it was. You are not to go beyond this period of time, but to stop there. What had transpired between those parties before that time? Nothing which afterwards transpired could change the character of the act, which was then complete. I leave to you, gentlemen, as rational men, who are called upon here to decide upon the most numerous collection of circumstances that were ever presented to a jury, to determine whether you will not gather from the circumstances surrounding these parties and under which they met the conclusion that it must have been beyond all semblance and all reasonable doubt that death came, not from premeditation, but from suddenness of anger, when there was a fearful heat of blood between these parties, exasperated the one against the other, exasperated until it came to death. I have said that you are not to go beyond the act to ascertain the character of the act itself, and it is easy to show that it must be so. Should you think that you could go further to see what disposition was made of this body when it was once killed and gather premeditation from that, stop and consider a moment. We should hope, perhaps we should even expect, that parties so situated if they came to combat, if combat went on till death came, I say we should hope, and perhaps expect that the party who, in the heat of blood, had been guilty of crime, would have been so overcome that he would have rushed from the place and said, God have mercy upon me, to the first person he met. I have killed my friend. From angry words we proceeded to blows. Fuel was added to the flame, and in the heat of passion I smote him to the earth a bleeding corpse. I say that we should have hoped that a man would do this, but would all do so? Professor Webster was a man of standing in society. He had a wife and children. He was poor. While his blood was hot and passion high, his victim slain, he does one rash act more. Before his blood cools, he does one act more. Surrounded as he was, the temptation came over him to conceal, and he did that first act of concealment. From that moment, all disclosure was too late. The expected line of his salvation, by a public disclosure, was passed, and all that followed was the necessary consequence of the first false step that he took after his brother was no longer a living man. He attempted to conceal, and having attempted to conceal, and having cut himself off from all possibility of public disclosure, the arrest follows. One false step leads to another, and at length the temptation comes upon him to conceal and destroy. To conceal and destroy. The temptation comes upon him to avert suspicion, to shut out proofs, to turn away inquiry. If, then, gentlemen of the jury, he shut up his doors, if he gave out false statements, if he did, what I do not think the evidence will warrant anyone in saying, write these anonymous letters to the police, it would be only a continuance of that first false step, by which he shut himself up from his duty, and then, to cover up the crime he had committed, attempted concealment. Wrong in his impulses he certainly was, but still after it was done, and the concealment must come. Painful as it was, he had driven himself into the circumstances, and I put this to you, to ask if you do not see that the explanation of this subsequent conduct has no tendency whatever to show you the character of the act. Then, riddle this testimony in all its parts. See the relation in which these men stood. See one pursuing the other. How natural to prompt resistance. How natural for them to have had a combat. The combat makes heat of blood. In the suddenness of passion, life is lost. And then, according to the plain statements which have been made, you are to judge whether these probabilities do not show clearly and satisfactorily, to any reasonable mind, that the crime could not have been premeditated murder, but must have been extenuated by the heat of passion and the combat of the parties into that great but still lesser crime of manslaughter. Pass now, gentlemen, to the consideration of other matters, and yet before I enter upon the evidence of the government, which bears directly upon Professor Webster, I have to ask your attention to that defense which was suggested by the counsel associated with me, and which I may term the technical part, the indictment and its avertments, the duty of the government in relation to it, and the effect of the evidence which they have produced. The first and second counts in this indictment, gentlemen, in my judgment, are substantially for all practical purposes in this trial the same. The charge is that the defendant, with a certain knife which he had in his right hand, made an assault upon George Parkman, in and upon the left side of the breast of him and said George Parkman, then and there, feloniously, wilfully, with malice aforethought, did strike, cut, stab, and thrust, giving to the said George Parkman, then and there, with the knife aforesaid, one mortal wound. The second count charges that, with a certain hammer which he, the said John W. Webster, in both hands then and there held, him, the said George Parkman, then and there, feloniously, wilfully, and with malice aforethought, did strike, giving unto him, the said George Parkman, then and there, with the hammer aforesaid, in and upon the head of him, the said George Parkman, one mortal wound. Both of these counts charge that he killed George Parkman by striking, and I suppose that any evidence to show you that the death was occasioned by any instrument would sustain either indictment. I suppose that any evidence that would satisfy you that death was by the hammer would be sufficient to support the charge that it was by the knife. But the proof to support these counts will not be sufficient to support the third, which charges that he did strike, beat, and kick in and upon the head of George Parkman and cast him upon the floor. The fourth count charges that the individual, in some way or manner, and by some means, weapons and instruments to the jury unknown, did cause the death of George Parkman. Now we claim, and upon this claim we shall receive the instruction of the court, by which you will be governed. We claim that the government are bound, in a charge of murder, to set out the charge in a plain, substantial, and formal manner. We claim that the law has distinctly declared what formalities are necessary in an indictment. We claim that, among these formalities, the law has prescribed that the manner of death shall be distinctly described. We claim that no indictment is sufficient which does not set out distinctly and precisely the means of death. We have called the attention of the court to such legal authorities as we think fully sustain this proposition. They were read to you by the counsel associated with me. Of course, I have no purpose to repeat the particular statement, but to reassert generally the proposition that the government are bound to make such an exact statement in the indictment, or the indictment must fail. The defendant cannot be convicted under such indictment. He is not bound to answer it. With respect to this indictment, we say, and we trust that we shall be sustained in this by the court, that it is incompetent for the government to offer any evidence, or to supply any evidence which is offered to support it, because it does not aver how the death was occasioned, in some particular way and manner. That last count, gentlemen, is no more than saying that the defendant might have killed Dr. Parkman by strangling, by poisoning, or by drowning him, in some way or some manner. Which of these, under this count of the indictment, is the defendant to prepare himself against? The fire, the water, the knife, or the poison? He has a right to know, and therefore it is that the law has provided that before an individual is brought to trial, the government may set out the offense which is charged against him in just as many different forms, and under just as many different allegations as they choose. These different statements in the indictment are called counts. The law provides that the government shall not be limited at all to the number of counts. They may be extended, as my Leonard Flint said, as far as the ingenuity of the man can carry them. But still, when the case comes to trial, the government are held within the counts which they have drawn, and the party is to be tried exactly upon the counts. And if it be that the government are bound to set out the manner of death, if there be any count in the indictment which does not set out the manner of death, but it is entirely indefinite, so that it may have been done in one mode or in another mode, each of which is recognized by the law as a distinct method of taking life, and to be set out in a distinct form, then the government cannot make out its case, because it does not affirm either the one or the other positively, but is loose and general, and does no more than if it had said these words, John W. Webster murdered George Parkman. If this proposition is correct, there is but one thing more I wish to say upon this point. That is, that in applying the evidence, they must apply it to those counts which the evidence can sustain. For instance, if the government can satisfy you that death was inflicted upon George Parkman by a knife or a hammer, you may apply the charge to the first or second count, but it would not support the third count, which charges a mean of death recognized by the law, and if relied upon the government to be distinctly charged. Then again, if they present evidence to show that death was caused by striking with the hands and feet and casting against the floor, that would not support the first two, but would the third alone. With this statement, I proceed to add that in my judgment there is no evidence in the case, and I submit to you whether there is any evidence in your minds that you can apply to either of these counts to show that death was occasioned in that particular way by the hammer and the knife. Do you know it, and can you affirm it, that this was the mode in which death came? It was not thought quite so certain by the grand inquest, by whom this indictment was presented. That is nothing. You are to pass upon it. The only proof tending to show in my judgment that death was produced by either the hammer or the knife is the evidence of Dr. Wyman about the fracture of the skull and the perforation on the left side. Will the evidence of those causes of death satisfy you beyond reasonable doubt that either of them were the causes? Remember that the government are claiming that George Parkman was murdered by premeditation. Remember that they are saying and asking you to say to John W. Webster the fatal word, that he did premeditate this murder. If he did it premeditatedly, do you think he left the way of death to chance, to a chance blow, to the hammer which he might find or the knife which he might seize, or that he prepared in advance the way? Will you say that he did not strangle this man, that he did not take care instantly to stop his breath by the lasso? Is that an unreasonable suggestion? When the government are called upon to prove, beyond all reasonable doubt, that it was by striking or by beating his body with his hands and feet, are you prepared to say that this proof, which comes to no more than this, that he was living and is now dead and mangled, shows that the death was in a particular form? Will you say, gentlemen, that it is impossible that George Parkman might have been seized and that liquid poison could not have been poured down his throat, while his head was held fast? Will you say that provision was not made by which he cast himself voluntarily upon the floor? This man, who always went down those steps in haste, that he did not throw himself down and destroy life in that way? We are in the broad field of conjecture. The government asks you not merely to conjecture, but to decide and to determine. It may be that there was a knife. It may be that there was a hammer. But is it certain? Unless it is certain that it was so, you cannot be satisfied of it. For it is necessary that the government should aver and prove the cause of death. I ask you, gentlemen of the jury, if it be proved, beyond a reasonable doubt, that death was occasioned in the forms and in the manner that the government have set forth. I know that the Attorney General said to you in the opening that if he had relied upon his own judgment, he would have put the charge only on the fourth count, because he would regard the assertion that the indictment could not be sustained under it as a reproach of the law of the land. It may be a reproach. The question is not, is it a good law? If the law requires that certain specified forms must be gone through with, those forms must be gone through with, and which, I ask you, would be the highest reproach to the law, to leave such rules unamended, or for the courts and juries, knowing what the law is, to legislate on a man's life or a particular case, make a new law when a man's life is in peril? No, gentlemen of the jury, if this be the law, if the government proof does not come up to the demands and requisitions of the law, then I say it is a great duty which you have to do, upon the state of things, viz., to discharge the defendant. Guilty he may be, but what says the law? Better that 100 guilty men should escape than that one innocent man should perish. And therefore it throws around the life of every man these guards and protections of the law. It makes rules for circumstantial evidence. It makes rules for indictments. It hampers its own officers with technical forms for the protection of life. It means that it shall be so. And I say to you, gentlemen of the jury, that to acquit even a known felon of an offense odious and atrocious, I say to acquit him, according to law, is a nobler triumph than was ever witnessed in the groans or agonies of convicted guilt upon the scaffold. If, gentlemen of the jury, you shall receive instruction in conformity to the views which you have taken of the law upon this subject, if you cannot find beyond reasonable doubt how this death came, for your country's law and your country's justice, I ask a favorable verdict from you on that point. End of section 28. Section 29 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 19. Gentlemen of the jury, I shall proceed now directly to the consideration of the evidence upon which the government claim that they have brought home to the prisoner at the bar the charge which they made. And here, gentlemen, we must pause for one moment to see again the precise position which the parties occupied. I say then to you, once more, that the government claimed that George Parkman entered the college between the hours of 1 and 2 on the 23rd of November, and that he never came out. The defendant admits that Dr. Parkman was there at the hour of 1:30, and that he left the college. You see the position which the respective parties take. If the government will not take the admission of Dr. Webster that George Parkman was there at 1:30, but choose to take a different hour, that different hour is by them to be proved. Now, gentlemen, I wish to call your attention particularly to the evidence bearing upon this question. I wish to do so because involved in it is another consideration. The government claimed that Dr. Parkman came to his death by Dr. Webster's hands. Dr. Webster denies that statement. The government claimed that the remains which were found were those of the body of Dr. Parkman, and that they have proved that he came to his death by violence. This is neither admitted nor denied in this state of the question by Dr. Webster, but he says he knows nothing of it. We stand then, gentlemen, on that as from the beginning, when Dr. Webster on the morning of the 1st of December, after such a night as a man has scarcely ever passed, recovered partially the power of speech, he uttered, in simple but expressive language, his defense. I do not think those remains are the remains of Dr. Parkman, but how in the world they came there, I am sure I don't know. His proposition then, gentlemen, you perceive, is that by some ways and means and for some purpose or other, those remains were placed in that building without his agency and without his knowledge, and never has he professed to know what they mean. He cannot now profess to be able to explain them. This he says, I am guiltless of my brother's blood. The evidence of the government, how summary soever it is, cannot and ought not to avail. I wish then, gentlemen, to trace as well as I can the evidence of the government which bears upon these two propositions. There are a few subjects which, it seems to me, can be disposed of now better than in any other stage of the cause, and I now propose to dispose of them before going to the great propositions. The great circumstances which the government rely on are that Dr. Parkman entered the medical college and never went from it, that shortly after the remains were found in such a manner as to imply that Dr. Webster must have known about them. There are several auxiliary circumstances connected with them. In the first place, I call your attention to these anonymous letters. 3 letters were received by the marshal. They are brought in here for the purpose of showing that Dr. Webster attempted to avert the attention of the police from the college. And it is said the argument must be that Dr. Webster, if conscious of innocence, if there was no occasion for diverting the attention from that college, could never have written such letters. The argument is strong, if the fact is established beyond all doubt. It would be difficult to assign a motive why Dr. Webster, as an innocent man, should have written such letters for any purpose, except to divert from himself the inquiry. But then we are to consider first, is the fact proved that these letters were written by Dr. Webster? That, gentlemen of the jury, is utterly denied. I mean to state it to you from him as strongly as I can. It is utterly denied, and I mean to call your attention to the proofs in the case for a moment or two. I am sorry, gentlemen, it happened that these letters came so recently into my possession as they did, that I should have had so little opportunity to make a personal examination, and to go abroad, and to see what examination could there be made in relation to them. They were put in the last of the government's evidence. My engagements were of the most pressing character, and those of my associate also. We were drawing towards the close of the trial, when we were to make preparation for this hour, and our attention could be less effectively given to these letters than it otherwise would. And yet I have seen sufficient of these letters, enough to satisfy me that the evidence is not such as to convince you that Dr. Webster wrote them. The evidence that the government has is, first, the letters themselves, and then the testimony of experts. Deacon Gould says he has, for a long time, known the handwriting of Dr. Webster, and that he has some superior knowledge. But I think it cannot have escaped your attention that it was presented on the ground that he has effective skill. Now, as to these letters, there is quite a difference between them. Mr. Smith, the engraver, sustains Mr. Gould about the Civis letter, but not about the others. That letter was dated on Monday. The others were dated the 30th. Indeed, one was dated the 31st, but postmarked the 30th. Now it is these that Mr. Gould has expended his force upon, and if either of these is in the handwriting of Dr. Webster, the Civis letter is. I have not had much time to examine this, but I wish to call your attention to some things which Mr. Gould states. He sees the resemblance in certain letters, in which he says they are precisely alike. Now I have unpracticed eyes. I claim no skill as an expert, quite the reverse, but I think I have skill enough to discover that in some of these particulars, and I think you will decide in all. This Mr. Gould is the merest visionary ever called upon to testify before a jury. I am about to ask you, when you retire to your rooms for the last solemn decision, that you will take these letters. Remember that you are not to be governed by the opinions of Messrs. Gould and Smith. They are only opinions, and you are to consider whether it is proved, beyond all reasonable doubt, that these letters are in the handwriting of that man. In connection with that opinion, you may have your own opinion, and exercise your own judgment, and from comparison of the same papers from which that witness has formed his opinion, I will show you a specimen. Among other things which the witness says were made alike, you will remember were the figures 1, 3, and 9. You will find in the Civis letter that they are made different. Here is the date, 1849. The last shall be first and the first last. I wish you would look at that 9, and then look at those upon every one of the checks, believing, gentlemen, most confidently, that letter is not in the handwriting of Dr. Webster. It would take quite too long to go into particulars. I have to say generally that I think the most careful scrutiny of it, in comparison with the real letters which have been produced, will show that the objection of Mr. Gould upon this subject is of such a character that no jury will feel safe to act upon it in unimportant matters, much less to be sufficient to justify them in acting at all upon any part of the evidence. I know that I need not dilate upon this. I have stated my own convictions. The court will state to you what the evidence is. The court will state the law. And I will leave to you to form your judgment upon those letters with the genuine papers in the case. And have no doubt that when you have done that, though the government have been zealous and honest, have done no more than what is right and fit in laying the evidence before the jury, yet you will come to the conclusion that you have no other right and no other evidence in relation to that than to lay it out of the case. There are one or two other considerations. The government have introduced testimony here in relation to certain articles found in the possession of Dr. Webster. They have called testimony here to show you that on Friday morning Dr. Webster ordered a tin box. So he did. How does that connect Dr. Webster with this murder, or anything in relation to it? Why, it may be argued that it is a box in which the remains could have been put, but was the box made for that purpose? Did the doctor say anything which indicated that it was to be made for that purpose? The doctor said no such thing. Where were the remains? And where was the box to go? The remains were at the medical college. Was the box to go there? The box was to go to Cambridge. Now see the position in which the government was placed. Dr. Webster calls at Mr. Waterman's, orders a box, and is asked what it is for, and he tells. He is asked where it is to go, and he tells. The government asks you to think that that is a lie. The government say that it was a good thing to put the thorax and the thigh in, and therefore conclude that it was so. Gentlemen, you are able to be satisfied beyond reasonable doubt, not what is probable, not what is likely. And yet, gentlemen, seriously, the life of Dr. Webster is dependent upon this very thing. Suppose that the case were so balanced that the jury should say, we are satisfied. If it is proved that this box was made for this purpose, the government say they can prove it. They call in Mr. Waterman, who says, the doctor said it was to put small things in and to be sent out of town to be filled. All you can say is that that is not true. That is to say, there is no proof, one way or the other, as to the cause to which it was to be applied. And yet this object is just as much to be proved as you are to be satisfied beyond reasonable doubt of the murder itself. Every fact which the government present makes an issue, and if it is disputed, then that fact is to be established by proof, and not by conjecture. And if the proof falls short, then that fact is to be laid out of the case. It is to have no influence, because it is not proved. That is the whole argument with respect to the tin box. I have only to say to you with respect to this, and the fish hooks, that Dr. Webster had ideas of his own upon this subject. We cannot prove it by what he said to his wife, or children, or anybody else. He cannot get up in court and testify to it. He does say they had nothing to do with it, and puts the government upon proof. Standing in a land of law, he has a right to say that they are not proved. With regard to the fish hooks, the government say, probably, that they were to be made into a grapple. Where have they the proof? Will they take this statement of Dr. Webster as to what he intended to do with it? No, they will not. And if they will not take that statement from him, take you none from them. Prove all things, and hold fast that which is good. Now then, I say that the government, with reference to this, have given no more than a possibility, not an application. And they may show the application or the intent to apply these articles, or they can have no effect. At one time, another matter seemed likely to cause perplexity. I refer to the bag of tan which was brought to the college by Lawson. With respect to the tan, it seemed at one time momentous. Dr. Webster sat in, at one time a bag of tan from his house. A part of these remains were found embedded in the tan. Here were these remains on Friday, and the tan was sent in on Monday. Dr. Webster is able to prove that the tan was there on the morning after his arrest. The bag of tan was seen on Tuesday morning by Mr. Kingsley, but it existed untouched on Friday morning. There is no proof that there ever was seen any other bag. It does not appear that the tan was ever used or touched. Still here, as in the other case, I suppose the government asked you to make some inference from it. The truth is, the tan was there for a purpose which Dr. Webster could explain. If you go into the laboratory and see all the contrivances, you would hardly be surprised that anything which mechanics use should, in larger or less quantities, be found in a chemist's laboratory. I did not know, gentlemen, at one time, but that we should be in danger from another matter, of which evidence is in the case. That bunch of keys which was found after Dr. Webster's arrest. I did not know but that they were to be brought in some way, to the connecting Dr. Webster with this awful crime. But all that we have upon this subject is the explanation of Dr. Webster. He says he found those keys and thought they might be useful. The keys were separate and distinct, and it turns out that a portion of them will apply to the dissecting room, and to 2 doors in his own room. He had a right to go to the dissecting room and to his own room, and therefore the keys are nothing. If he were on trial for burglary, there might be proper evidence. Being on trial for murder, deadly weapons would be proper. The keys touched the burglar. The deadly weapons touched Dr. Webster. I submit that there is nothing which affects or which ought to affect this case in the slightest degree. Mr. Littlefield has testified in relation to a sledgehammer, which was there at the time when it is supposed this crime was committed, that he has searched diligently for it since, and it is gone. Another witness has testified in relation to twine. There was twine found tied around the bone of the thigh that was inserted in the thorax, which was buried in the tan. This twine corresponds with twine which was found in the private room of Dr. Webster, and that which was on the fish hooks which were purchased. Now, if Dr. Webster committed this offense, he might, or he might not, have twine. If he made that grapple, and used that, it could be proved that while he was doing it on one side, he was tying the thigh with the other. It might convict him. But take our hypothesis, and it explains it. How these things came here, I don't know. The government's case does not exclude the idea that all these things have been placed there by another agent. If another man came there and did any of these things, that is enough. If another man came there and brought these remains, that man could dispose of them, could carry sledges away if he pleased, could use sledges, and if he found a ball of twine there, could tie it round the leg of a human being, and therefore the twine and the hammer are explained, if at all, by the agency of the third person. 1 or 2 words upon 2 or 3 other topics before I come to the main topic. Something was said about a $20 bill. Dr. Webster came to Trenholm and inquired about the $20 bill which he had heard of from the marshal. Dr. Webster knew nothing about it and inquired. Mrs. Coleman testifies that Dr. Webster called on her and asked if she saw Dr. Parkman on Friday. She said, no, it was on Thursday. He asked again if it was not on Friday, and she repeated her answer. Just as he was going out the door, he asked the 3rd time. She seemed to indicate by her manner that he had asked enough, and she answered something sharply to him. Everybody was inquiring at that time if anyone had seen Dr. Parkman. Dr. Webster was interested in everything that touched public excitement, and he was as likely as anybody else to inquire of anyone whether they had seen Dr. Parkman. When passing from the college to his home, he called on her and asked her if she saw him on Friday. She says, no, on Thursday. Now it happens that it was almost immediately afterwards that he was arrested, It was on Friday that he called. On Friday, the day of the arrest, when he was going on a voyage of discovery. He said to Mrs. Coleman, formerly Mrs. Bent, "I saw him on Friday." I cannot but think that Dr. Webster must have understood Mrs. Coleman differently, or he would not have asked them to call in and get her conversation. There is no pretense that Dr. Webster sought to induce her to make any representations upon the subject. He did not persuade her, or attempt to persuade her, but he simply asked for personal information, and having obtained that, howsoever he understood it, he did not ask her to make false representations. I shall leave that with an assurance that it cannot make an unfavorable effect upon the interest of my client upon the present trial. There are two matters testified of by Mr. Littlefield, which would be better disposed of with this class of miscellaneous testimony. I refer to the blood, testified to by Mr. Littlefield, and to the inquiry of Dr. Webster relative to the dissecting vault. In the first place, with respect to the blood, Dr. Webster was entirely open in his communication with Mr. Littlefield upon the subject, asking him to go to the hospital and saying that he wanted it for his own lecture. There is no evidence as to the use intended to be made on that occasion. Professor Horsford has said that it is not unusual to use blood in the course of chemical lectures. If the subject was proper, it might be used to advantage. There is a presumption of law in reference to this as to all parties, that the innocence is presumed unless the contrary is shown, and unless it can be shown that there was an inappropriateness of the use of blood in that lecture, it is nothing. He probably wanted it to show to the class, as teachers of chemistry sometimes do. Then, as to the dissecting room vault, Dr. Webster inquires whether it was mended, adding that there was some talk about having it done. Littlefield said it was done. "Well," says Webster, "it is tight now. Does it generate gas?" No, the doctor did not ask the question, but he obtained information so that he might infer it. Said he, "Did you ever try a light?" "Yes," says Littlefield. "Dr. Ainsworth asked me to put a light down, and I put one down and it went out." Dr. Ainsworth could not get the article he was in search of. Dr. Webster says, "I want to get some gas," as soon as Mr. Littlefield told him that the light went out. "Can you, sir?" says Littlefield. "Yes, I can," was the reply, "and I will do it at another time." And there the conversation ended. It is a fact that Dr. Webster made this inquiry for an innocent object, and it is made use of on this trial against him. The truth is, if he contemplated this murder at all, it was so complete a place, and he was so assured of its safety, that you would certainly, if Dr. Webster had done it, have discovered the body there instead of anywhere else. I submit to you that the evidence is insufficient to prove that for which the government presented. I am sorry to delay you so long about these subjects. They are a part of that immense mass of evidence which is thrown into the scale against the life of the prisoner at the bar. I do not believe that, in the final adjudication of this case, you will feel at liberty to regard them at all, and I pray you that unless they are clearly proved, and unless you are satisfied beyond all doubt that they have to do with the case, that they will be removed from it. End of section 29. Section 30 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman, Boston, Massachusetts, 1850, Part 20. I come now to the evidence bearing directly on Professor Webster, viz., to the first proposition, that Dr. Parkman never left the building, and that the remains were those of Dr. Parkman, slain by Dr. Webster. Dr. Webster's proposition is that Dr. Parkman was there at 1:30, not after, not at 10 minutes of 2, but at 1:30. And how the remains came there, he is sure he don't know. And now I have to ask you to consider that the government theory is altogether incorrect, and that there is strong reason to believe that these premises were invaded by an unknown form. I have called, gentlemen, your attention carefully, I hope candidly, to the evidence which the defendant has been able to produce here, tending to establish the fact of the alibi of Dr. Parkman. That alibi, according to the evidence of the defense, commenced at 20 minutes after 2:00, when he was first seen in Causeway Street by Mr. Thompson. I mean now, gentlemen, by the most precise and careful analysis of the evidence in this case, that I am able to make to satisfy your minds, not only that we, on the part of the defense, have proved the alibi, that is, the separation of Dr. Webster and Dr. Parkman, but that the government have fully and clearly and unequivocally established it. I mean, gentlemen, that this evidence, when all considered, all that they have put in, connected with all the facts in the case, will fairly warrant the conclusion that, at the times when the government witnesses say they saw Dr. Parkman, it was after he had been in and finished his interview with Dr. Webster and had gone away. This, gentlemen, you perceive, is a matter of the greatest importance because, if it be true, has the strongest possible tendency to show that although appearances may be now so much against Dr. Webster, and although this testimony presses so that at times it might seem impossible to escape, I say, if this be so, it has the strongest possible tendency to exculpate Dr. Webster and fix the crime somewhere else. Not that Dr. Webster can explain it, but it shows that there is a theory and a hypothesis which the government's testimony does not overcome or reach. Remember that rule which governs circumstantial evidence, which was so admirably explained to you by my associate, that the government are to prove first the facts as the basis of the conclusion. Secondly, that the facts shall tend to establish and actually prove the proposition which the government assert. And thirdly, that they shall exclude to a moral certainty every other reasonable hypothesis. Now, gentlemen, if the government testimony goes only to show that their testimony will support their theory, but falls short of excluding any other reasonable hypothesis, and excluding it to a moral certainty, then, howsoever strong suspicion or probabilities or bias of mind may be, if the fact asserted by the government cannot be said to be proved beyond reasonable doubt. Let me call your attention to this question of time. It becomes of the utmost consequence. Recollect that the assertion of Dr. Webster is that the time was 1:30, not more than that. Was that the time? The government witnesses, Mrs. Martha Moore, her son George, Dwight Prouty, Jr., and the Messrs. Fuller, clearly established at the time Dr. Parkman was seen going down Fruit Street into North Grove Street, could not have been earlier than 10 minutes before 2:00. Dr. Webster says that is 20 minutes after he was at the medical college. Where was Dr. Parkman during that 20 minutes? Had not he got there and gone away? I will endeavor to satisfy you that he went there and finished his business and had gone. At 1:30, Dr. Webster says he was there. What did Littlefield tell you that he testified on this subject on a former occasion? He fixes it now, approaching 2:00. He does not fix it entirely. He leaves it something loose. But he tells you that on a former occasion he thought and testified that it was earlier. Mr. Littlefield fixes it indefinitely. What he said upon a former occasion has no bearing. Dr. Webster fixes it at 1:30. What was the hour of the appointment? Here we are not left to the statements of Dr. Webster, but we have testimony from a witness on the part of the government, and from a person who knows something in relation to it. I refer to the testimony of the servant of Dr. Parkman, Patrick McGowan. He did not hear all the conversation, but he did hear enough to know when the hour of the appointment, and the hour of appointment was 1:30. Then we have these two important facts to aid the assertion that Dr. Webster first asserts that it was 1:30. There was an appointment, and the hour of 1:30 was mentioned. This appointment, I think fairly to be inferred from the testimony of Patrick McGowan, was at 1:30. It is likely that, according to that appointment, Dr. Parkman was there at that time because, according to the testimony of his friends, he was the most punctual of men. If he made an appointment, he kept it. And exactly, and especially, and strongly in this particular case, he was pursuing Dr. Webster earnestly and closely. If Dr. Webster appointed to meet Dr. Parkman at 1:30 upon this business, do you believe that the most punctual of men would have given to him the opportunity of an apology? You were not here at the time, and therefore I say upon the proof of Dr. Webster's own assertion in the case, on the testimony that comes from Patrick McGowan, and the probability arising from Dr. Parkman's habits of punctuality, it is extremely probable that the statement of Dr. Webster is true. But now I come to the testimony of Dr. Bosworth, and to compare that with Littlefield's, who says that he saw Dr. Parkman coming towards the college on Friday noon, November 23rd, and that the door was wide open. The door being wide open and Dr. Parkman coming toward the college, he went into the adjoining room and saw no more. There was another man there when Dr. Parkman passed. Littlefield was standing there looking out, and immediately after saw Dr. Parkman go up to the door as he passed by. Dr. Parkman went up on the steps. Now, Littlefield did not see Bosworth. Littlefield has not given any account of seeing any man at that time. One thing more, which shows that there were 2 times when Dr. Parkman came there. When Dr. Parkman was coming up from Grove Street to the college, the door of that college, according to the testimony of Littlefield, was wide open. When Bosworth came there and crossed the top of the steps in front, the door stood ajar, that is, partly open. Now, the testimony of Bosworth, in connection with the statement of Dr. Webster, the time appointed as attested by McGowan, and the punctuality of Dr. Parkman to meet all appointments, I put it to you, if it is not the most probable thing in the world that Dr. Parkman was at the place at 1:30, and then went away. 15 minutes after, he was in another place, according to the testimony of Mrs. Hatch, who testifies that at 15 minutes before 2:00, she saw him going up Cambridge Street. I put it to you whether this is not clearly evinced by all the testimony, that the appointment was made at 1:30, that the most punctual of men kept it, that the interview was, as Dr. Webster says, very short, that he left the college, and then, for some purpose or other, came back again, but shortly after was seen by Mr. Thompson in Causeway Street. I do not see, gentlemen of the jury, how this conclusion is capable of being avoided. The appointment was at 1:30. Dr. Parkman was the most punctual of men. Dr. Webster had no earthly reason to state a false time. If he were guilty and made a disclosure, he would disclose the true time. Dr. Bosworth saw Dr. Parkman when Littlefield does not speak of seeing anybody, and when the door was in a different situation from what it was when Dr. Parkman was there the second time. I put it to you, when we are in a case surrounded by nothing but probabilities, perhaps hurrying this prisoner to the last hour of life, whether a deduction cannot be drawn, which will satisfy the mind of any rational man, that Dr. Parkman had finished his business, and that this proof of the government shows that he came there again. Let me ask your consideration to one thing more. Dr. Parkman stepped into Holland's store and talked about butter and sugar. Only consider that he had not been to the college. He had made an appointment to be paid by Dr. Webster, after pursuing him in all directions, going to Petit and to the Toll Man, going to Cambridge, watching the highways and byways, and then he goes down to meet his appointment. And do you think he would stop in to Mr. Holland's to spend a quarter of an hour about buying butter and sugar? Take another hypothesis. He had seen Dr. Webster, comes away, and goes to Holland's door. Holland says it was about 1:30. Mr. Moore says it was a little later. He steps into Cambridge Street just in time to be seen by Mrs. Hatch, and then you will find that afterwards he was upon the college steps for some purpose or other. Here are these facts. I cannot explain them. There is mystery everywhere. If it cannot be explained, give to the defendant the advantage of all probabilities and arguments in his favor. Do not let your decision be more fatal than the events of that day. If then, gentlemen of the jury, there be a strong probability that Dr. Parkman has been murdered, I cannot conceive anything stronger than this position I have taken. The testimony of Bosworth strikes my mind with vast force, not seen by Littlefield. The door partly open, and not as Littlefield testified it was when he was there at 10 minutes before 2:00. Now, gentlemen, let me go one step further. I have said to you in an earlier stage of the case that it was not uncharitable nor unjust nor unreasonable to suppose that in this state of excitement he might have been touched by those causes which occasionally touch and overcome human infirmity, and that if his friends believed that he might have been overcome by aberration of mind, this may account for his irregularity of movement, for his failure to return home, his conduct in one instance at least peculiar. Now let us trace that night down, and see whether the government testimony excludes all reasonable theory. If Dr. Parkman was out, you see the foundation for a reasonable theory exists. If his dead remains were found, Dr. Webster had nothing to do with them. That night at 10:30 he was at home, or at Mr. Treadwell's, found at home at 12:30 or 1:00, and at home in the morning. A medical student has testified that he saw Dr. Webster Friday evening at 6:00. I leave it to you to say whether he is not mistaken. Mr. Kidder saw him at 5:00 buying cologne. The young ladies say that he was with them at tea and spent the evening with them. That night, when I have shown you that Dr. Parkman might have been brought into the college, Mr. Littlefield was careful to fasten up that building, bolt the dissecting room door on the inside, and leave it bolted. The next morning, Dr. Webster at home during that night, and all night, that dissecting room door, which was bolted on the inside, was found unbolted. Somebody had been there. Who was it? I don't know. Somebody had been there. Inexplicable, mysterious, but important. Most important for your consideration. Somebody had been there. Monday and Tuesday, these rooms of Dr. Webster were passed through, at least if not searched. Nothing then was found. Wednesday, after he returned home at 11:00, Dr. Webster was in Cambridge and remained there till evening, till he went to pass the evening with his friend Cunningham, spent Thanksgiving at home, and came into Boston Friday morning. In the meantime, had anything else transpired? During this period of time, Dr. Webster's rooms were accessible, because Littlefield got in, though not through the door. But he who unbolted the door on Friday night could have got in the same way as Littlefield did. But during that time, a change of some significance had taken place. Kingsley made an examination with Littlefield. Slight it may be, but still some little examination. And among other things that he saw was this tea chest, at that time filled with tan, and partially covered with papers containing minerals, or with minerals in papers. Partially covered, not entirely, only covered in such a way that he could see the tan just as well as he could see the minerals. Between that Friday and Tuesday, there was a change in that particular. The chest then was only partially covered up with minerals. A change had taken place, and in the meantime this building was accessible. It had been entered in a mysterious way on the very Friday on which Dr. Parkman disappeared. A change took place, and accompanying that change there are these two very remarkable circumstances. In this tea chest, what else was found? In it that knife, as clean as one taken from the merchant, with no spot upon it, was placed. Wherefore so? Dr. Webster had made no concealment of it. Wherefore conceal? The silver weapon was exposed. Why hide this, a clean knife, by the side of that tan? If Webster had done so, why? If another man had done so, he had a motive. That was to bring in direct connection Dr. Webster with these remains, and therefore his knife may have been placed there. Another circumstance. Why was that twine put upon the bone of that thigh? Can you conceive the reason? Assume that Dr. Webster did it. Wherefore did he put the twine upon the bone? He did not put any twine upon the remains which were cast into the vault. He did not tie it round the thorax for the purpose of pressing it together, but it was tied to the bone. Wherefore? Dr. Webster could not have done it. If there was a mysterious being there, who changed things while he was gone, who did all the business, then, gentlemen of the jury, you can see a reason why that twine was there. It was to bring, if the matter were ever discovered, that portion of the body into an immediate connection with somebody. Now, gentlemen of the jury, these remains were not found, any of them, on Monday or Tuesday. On Tuesday, remember, the testimony of Mr. Kingsley was that he saw a fire burning in this furnace, a bright fire burning there. But there is no pretense, I think, that then the head or the arms or the limbs of any human being were in that furnace. There is no such pretense as that. If there was a bright fire burning, it was seen, and if human flesh or bones were burning, they would have been noticed. On Wednesday it was said that there was a great fire burning in the furnace, but Littlefield saw none. Yet he did see Webster carrying the materials. For what purpose we do not know. But this we do know. Watched or not watched, Dr. Webster left early on that day and did not return till Friday morning. In the meantime, the room was open to whomsoever might go there. And if there was a person who disposed of some of these remains by putting them under the privy, finding the fire left by Professor Webster in the morning, might he not have conceived the idea of burning a portion of the remains there, and so the whole be accomplished? Now, I have said that these were mysterious circumstances. Probably Dr. Parkman wandered around the city and finally went in the evening to the college. But there is a mystery beyond. There is one mystery concerning what is found. The remains found are those alone of the naked dead body of a human being. Where are the remnants of the traces of the garments? In this furnace, mark, so accurate and so exact was the examination of the chemists, that they were enabled to detect a quantity of tea chest lead. It is in the report which has been read to you. So exact and minute was one examination as that. Where is anything, or the remains of anything, but the naked dead body of a human being? And yet, gentlemen, it is certain that Dr. Parkman wore garments from head to foot, and had a coat and underclothes and boots. And there undoubtedly was, as there is about all of us, something of an incombustible character. The buckles of our suspenders, sometimes the buttons on our coats, and the nails in our shoes. Somewhere or other have not remnants or specimens of the remains of these been found? Now I put it to you, if when in that college you find nothing but the remnants of a naked human being, if you know that Dr. Parkman had garments upon his person, if you find that there is a probability that he might have been an aberration of mind, wandering in different places, I submit to you, if it is an extravagant visionary theory, that he was stripped elsewhere, that his garments never were in that college, that he was taken in there a naked body, and treated as he was treated till danger was thought to come, and then his body was disposed of. You are the judges, but upon these facts, these probabilities, these circumstances you must pass. They cannot be disguised. They cannot be discarded. And if they make doubts with the government's case, if they leave you with all their accumulation of proofs in a state that you cannot say with positive assurance, I am convinced beyond reasonable doubt that every other reasonable theory is, to a moral certainty, excluded. Then our innocence may not be manifest, but our salvation from conviction is, under the laws of the land, made certain to us. End of section 30. Section 31 of American State Trials, Volume 4. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. American State Trials, Volume 4 by John D. Lawson. Trial of Professor John W. Webster for the murder of Dr. George Parkman. Boston, Massachusetts, 1850, Part 21. I wish for a few moments, gentlemen of the jury, to ask your attention to the consideration of some of the testimony of the government, which has been thought to be, and perhaps rightly thought to be, of a very conclusive, at any rate of a very material character. I refer to the testimony of Mr. Littlefield. I regret, gentlemen, that my duty compels me to allude to the testimony of that witness. I regret that I am obliged to do so, because I am confident whatever is said about this has a tendency to point a suspicion toward him as the perpetrator of this crime. Now, gentlemen of the jury, you must not misunderstand me. I will not take upon myself the fearful responsibility in defending one man to charge another with the same crime. Far be it from me to say that I will charge Ephraim Littlefield with this crime. Far be it, whatever may be the tendency of my comments, if the effect should be to fix it upon him. Far be it from my intention to connect him with this crime. But, gentlemen of the jury, it is my duty to examine, and it is your duty to weigh, the testimony of this witness, and if there be anything which tends to affect the testimony of that witness, you must give it weight, whatever the consequences may be, so I must discuss it. Gentlemen, I shall discuss this subject in the fearless discharge of duty, leaving consequences to direct themselves, but without making the slightest imputation upon Mr. Littlefield as the murderer. You are to consider, gentlemen, the testimony of this witness. It is important because it has a tendency, I admit, to exclude the theory which I insisted upon on behalf of the defendant. It has a tendency to show the more direct agency of Dr. Webster with the various facts and circumstances connected with these remains, and therefore to endanger my client's life. Then let us see if there are circumstances which should abate our trust in that testimony. If there are, we must give them weight. We will not charge crime on others, but we will save those who are charged with crime from an erroneous conviction. You are to weigh the testimony of Mr. Littlefield. He is, to some slight extent, corroborated by the testimony of others, by Selwyn, the expressman from Cambridge, who says that he brought things from there and left them in the entry, as he never did before. I suppose they had never brought such things before. He says the doctor told him, not that the room was locked, and that he would not find the keys, but to leave them in the entry. But he went there and concluded that he would take the key from the kitchen and stepped in to get it, but it was gone. First, Dr. Webster did not say the room was locked. Secondly, consider that he said nothing on the subject of the keys. Third, Mr. Littlefield had said that he had continued to go to this door, that he had tried it and found it bolted on the inside. from which I think it not improbable that the key was in the possession of Mr. Littlefield himself, he retaining the key, not for the purpose of deception, but in the natural course of things. And I think so far as that the doors were locked, Mr. Littlefield is confirmed. To about the same extent, Mr. Littlefield is confirmed by the testimony of Mrs. Littlefield. It is not very material. She had been asked to do something and after a time was unable to do it, without explanation from Dr. Webster. But Mr. Littlefield says much more, and it is not, after all, so much the effect of the testimony of Littlefield in finding this door or that door fastened, which exerted an influence, but the tenor of his testimony, that Dr. Webster entirely changed the character of his conduct, entirely changed the mode in which he took care of his room, and gave outward manifest appearance by changed conduct that something was wrong. When this is the purport of a witness's testimony, it becomes of the highest moment to understand how full is the credit to be given him, if he is to be fully credited. If he is not, then human liberty and human life cannot rest upon any deductions to be drawn from such proof. We do not attempt to impeach the testimony of Littlefield as to general character. We do not rely upon discrepancies and contradictions. Some mistakes he has made, some errors he has fallen into as to time, some difference, upon a close analysis, I think, would be found in his testimony, relative to results, and the testimony of others. But upon these matters, gentlemen of the jury, I am not disposed to dwell, though I must say that we should be careful, extremely careful, where life is in peril, not to place too much dependence upon a witness who, in giving part of his testimony, has fallen into error. A wide berth must not be given to witnesses upon whose testimony depends the fragile thread of human life. Yet it is not upon the ground that he mistook the time of the interview that I should ask a jury, even such a case, to question his testimony. But the material part of it is upon the character and conduct of the party charged with the offense, and it is my duty to call your attention to this intrinsic, internal evidence, and to ask you whether there be not something from which a disposition to give credit and reliability starts back. Gentlemen, consider this testimony. Consider the accounts which he gives of himself in reference to Dr. Webster, and these remains. That is the material amount of his testimony. It spreads over a vast surface. He occupied the time for some 3 or 4 of the longest of the government's witnesses. But after all, it narrows down in importance to a few matters, and the credibility which is to be given to it depends upon a few circumstances. Gentlemen, in considering this testimony, let us take a point from which we may make our observations. That point is Sunday night, when he had his conversation with Dr. Webster, who then inquired of him when he saw Dr. Parkman last. He replied, on Friday, which in passing, gentlemen, you may recollect is quite different from what he said to Trenholm on Saturday, that he had not seen Dr. Parkman for 3 or 4 days. Dr. Webster told Littlefield that at the hour of 1:30 Dr. Parkman came and he paid him $483. And then, by the narrative of Dr. Webster and his manner, it came, says Littlefield, into my mind that Dr. Webster was guilty of this awful crime of murder. Up to that moment, between Littlefield and Webster, there had been as kindly a relation as there is between you gentlemen from your long acquaintance upon this panel. The professor occupying a chair in that college, Littlefield holding a place in part under Dr. Webster, and Dr. Webster a man of fair character and reputation in the world. Yet this brief conversation, as Littlefield said, forced upon his mind the clear, settled, firm conviction that Dr. Webster, the man whom he was talking with, was the murderer. He had a sharper vision than the police officer Fuller, who visited Dr. Webster and had more conversation with him that evening. So clear and certain was Littlefield that he went to his wife, his bosom companion, unfolded to her his convictions, and she replied to him, "For mercy's sake, don't say or think of such a thing as that." Now, gentlemen, is not that somewhat remarkable, that this strong, mighty, overwhelming conviction, that this should have come into the mind of Littlefield at that time from that conversation, not from what had transpired elsewhere, but from that conversation, not from what had transpired, but from that conversation. Now we have this point of observation. This witness says that at this period of time his suspicions were strong and overwhelming, thorough, certain, complete, and undoubted. Now mark his conduct before and after that time, and see whether it squares with the statement that he makes, that his conviction was so strong upon his mind that it was only under the exhortations of his wife that he was silent for a moment. Before that Sunday, on Friday, again and again during the afternoon, he visited all the doors in order to enter and make fires. He went to the party. He came home late. He went to all the doors at that time of night. And what for? Surely not to make fires at that time, when the next day was not lecture day. He testifies that he went to the party and came home in his party dress, that he went to these rooms and examined them all. In a man who had no suspicions, this vigilance was remarkable. You are called upon to note extraordinary circumstances in the prisoner. Note them in the witness who testifies against him. Saturday he watched. Sunday he tried the doors of Webster. Why? Surely not to make the fires on Sunday in the morning. Remember, no suspicions were then excited. Wherefore all this action before the suspicion. Now go to the day after. You see the vigilance before his suspicions were excited. See how it was after. On Monday morning, the very next morning after this deep and awful conviction came upon his mind, when he came to the overwhelming conclusion that the professor, his friend, the teacher, had been guilty of the most awful crime that had been committed in the community. He goes into that room. He passes through that laboratory alone, that day, twice, 3 times, I believe, and once with the police. Yes, 3 times. He was there 4 times. 3 times alone, and with an opportunity to search just as much as he pleased. In the morning, Dr. Samuel Parkman first came there. Mr. Littlefield was not found by Dr. Samuel Parkman, who found, on the contrary, Mrs. Littlefield, and she showed him up to Dr. Webster's room through the lower laboratory, and through the door of the laboratory stairs. Littlefield afterwards came in, ascertained that Dr. Samuel Parkman had gone up, went to the door by the laboratory stairs, and entered the laboratory. That is the first time that he enters the laboratory after the suspicion had come into his mind that Dr. Webster had committed this awful crime. Would not his eye naturally have fallen on every object that could have attracted attention? Would his vision have been closed to anything which would startle a man who was put upon his guard by the most grievous and horrible suspicions? And yet, he passed through the laboratory to the upper room, heard a part of the conversation, and turned and went back. Opportunity ample. Dr. Webster he knew to be engaged, his own suspicions most strongly excited. Then he knew how these rooms had been watched and guarded, if he had been as vigilant as he says, and yet he makes no observations. Afterwards, Mr. Blake comes there. He goes to gain admission for Mr. Blake through this same laboratory, and finding the door open goes through it, and makes no observation whatever. Then again, gentlemen, that same day, Kingsley, the agent, and Mr. Starkweather, the policeman, go there to gain admission in order to search in this college. Mr. Littlefield tells you that, many hours before they came there to make search, he had his mind impressed with an ineradicable conviction that Dr. Webster was guilty of this murder. If that was his conviction, if the police came there, armed with the power of the law to investigate with regard to this matter, I ask you how a man with such suspicions would have conducted. Would he not have searched? Would he not have watched? Would anything that came within the range of human observation have been overlooked? Would he not have turned the suspicion of the police to everything? And yet, he says that he passed through that building in the most formal and imperfect manner, without a search at all. Follow this subject up. Before this time, he was watching and watching and watching these rooms, when his suspicions were grievously excited. When his convictions were most firm, he made no search at all. Tuesday came around. The police came again. The convictions had not been eradicated from the mind of Littlefield at all. He goes with the police. Mr. Clapp says, "We do not suspect you at all. We are ordered to search this part of the city. The neighbors will object to our searching their houses until after we have searched here." Mr. Littlefield says that he believed Dr. Webster was a murderer, but he would not give a hint to that officer that was worthwhile to be a little more vigilant. And when he had got into the laboratory, and that inquiry was made about the privy, and Webster diverted attention from it, then Littlefield did not even say that it was necessary to be more exact. Nay, he was the least observant of all. Mr. Kingsley tells you that he made the discovery of the spots of nitrate of copper, and yet they escaped the attention of Littlefield. In the nature of things, can it be that this suspicion should have existed, which would make everything deserving of observation, and yet that Mr. Littlefield did not draw the attention of anybody to the spots, so plain upon every step, or even notice them himself? I say, the want of vigilance creates a suspicion and distrust in his integrity, which appeals to a jury for a careful estimate of his testimony. Again, that same day in the afternoon, that friendly intercourse took place. When Dr. Webster rang the bell and Littlefield went to answer it, he gave him a turkey, and Littlefield thanked him. I must confess that I can hardly conceive how he could have taken that order from Dr. Webster, furnishing his Thanksgiving dinner, that food over which he was to be grateful to Providence for all the past favors he had received, and was taking it, as he believed, from the red right hand of a bloody murderer. He took it, thanked him, and they passed down together towards Cambridge Street in friendly conversation. And when Dr. Webster asked him where he was going, he said, "To the lodge." Then said Dr. Webster, "You are a Freemason, are you?" "Why, a part of one, they call me." And there the conversation ended, friendly and kind. He had just received from Dr. Webster this present, and was harboring in his heart the suspicion that Dr. Webster was a murderer. I do not speak without proof, for Mr. Littlefield tells you that the same night, when he came from the lodge, he stopped at Dr. Hannaford's, and there spent an hour during which he breathed out to him his suspicions against his friend Dr. Webster. Can it be so? Can his conduct be explained consistently with the idea that his testimony is to be taken as solid, substantial truth? Go to the next day. The next day in the morning, he watches. All the discovery is that fire is made in the furnace. He goes away. In the afternoon, he returns. He discovers in a strange way the fire in the furnace. And passing through that dissecting room entry, he says that the heat was so great he felt it upon his face. That is a great heat to arise from that furnace. You have been there and have seen it, and I think it deserves the careful consideration of gentlemen, whether he could have discovered it. He felt it hot, and thought the building was on fire. Because the brick was hot, he thought the building was on fire. He attempted to enter into those rooms. He went to this small furnace. The fire was substantially down. How can this be? How the wall, on the outside, could give out so much heat as to make a person think the building was on fire, after the assay furnace had been substantially extinguished, is beyond my belief. I submit whether it is not beyond yours. Then go one step further. Mr. Littlefield saw there was a strong fire here. He has this building to himself. His suspicions are vehement. He goes to the Hogshead to see if he can find the body of Dr. Parkman, but was so observant of Dr. Webster's directions to him of his little affair in that laboratory that, though he believed him to be a murderer, though this fire is strange beyond all things, and he was making it when Littlefield was watching him, yet even he will not take off a crucible and did not do it. He left without making any more of an examination about the body, except in the hogshead. I believe he discovered the acid at that time, but he did not go to the privy, and he made no effort to get in there, though he thought Dr. Webster had diverted the police from that place. Thursday, he told his hired man. Then his conduct changes. He is gradually unfolding his suspicions. An axe is sent for to Harlow's, and then he takes a hatchet and chisel to see if he can find the remains of Dr. Parkman. Why should he go there? It was the privy that Dr. Webster had excluded him from. Why not contrive some way or other to open the door and get in there? Perhaps all this painstaking of getting in would have been needless. Why not go above? And if the body was not found above, why not drop a light down the vault? It would have shown everything. But no, this process was too simple. He goes below to dig through the wall, but he works imperfectly. He does not accomplish it. Having got the axe from Harlow's, he went to work with the hatchet, but it does not work effectually. And yet, gentlemen of the jury, is it not a matter of some surprise? Is it not a matter that requires some more explanation than a mere passing word? How it was that Mr. Littlefield had then made up his mind to undermine the college? I believe the last reward for the body was published coincident with Mr. Littlefield's exertion to break through that wall. Though he disclaims all intentions of claiming it, yet I can see no earthly reason why he should not claim it. But the parties are able, and he has been the object of some obloquy. His exertions were coincident with the last reward, which he now disclaims. He went to work with this mighty conviction, and yet he left that work unfinished and incomplete. Was it the conviction that he was upon the very track of the murderer, and that he should find, decaying there, the body of Dr. Parkman, which could the next day be carried off to some other place, and yet he delayed for want of tools? He went to the party and danced 18 out of 20 times, with the conviction that a dead man's bones were almost under his apartments at home, laid there by the hand of the wickedest criminal that ever lived since Cain. On Friday, he does not rise very early or go to his work very early, and what is very remarkable, at 9 o'clock, while he is at breakfast, Dr. Webster comes in and speaks to him in the same calm, easy manner in which he has spoken to others about Dr. Parkman, inquires after the news, and he then tells him what, but a short time before, he had been told by someone in Dr. Henchman's shop, the story that he had heard of mesmerism, the cab, and the blood. I believe Henchman has been upon the stand, and might have been asked whether Dr. Webster made that statement without authority, but he was not asked. Littlefield says that there are so many stories flying abroad that he does not know what to think, and this was the conversation that took place when half the college wall was undermined, and when Littlefield was meditating the completion of it. In the course of that day, what strikes me as most remarkable is that Mr. Littlefield, in all the long testimony which he gave, never once, from that moment Dr. Webster conversed with him in his kitchen, looked for, or sought to ascertain where Dr. Webster was. I have looked at my minutes, and I cannot find that, from after the time on Friday when this easy conversation took place with him, that Mr. Littlefield even went to the laboratory door, or to the lecture room, or anywhere else, to see if Dr. Webster was in the room. And for aught I can see, he told his wife to watch whether Dr. Webster was coming before having taken the precaution to ascertain whether Dr. Webster was in his laboratory. Now, this is Friday afternoon. Mr. Littlefield goes to work again. He goes then to the Messrs. Fuller. And gentlemen, bear in mind the reason which Mr. Littlefield is given for this work, rather than that of finding the body of Dr. Parkman. He says he could not go up to town without being told that the body was under the medical college. He says he went to work there to satisfy his own mind and that of the public, and yet he had thought Dr. Webster guilty, and had not failed to mention it on fitting occasions, first to his wife, then to Dr. Hannaford, to his neighbor, and to Trenholm, and on Friday to Doctors Bigelow and Jackson, the latter of whom said to him, "Do it before you sleep." He borrowed, as I was saying, tools of the Fullers. He was engaged in the work as serious as you are at this moment. He was to find the body of a most respected citizen who had been murdered. He was, by that finding, to charge another respected citizen with the crime of murder, which would consign him to an ignominious grave. And yet, mark his language, he joked with the Fullers about it, and at length Starkweather and Kingsley, and shortly afterwards Trenholm came. He had then accomplished his work and perforated that wall. All he had to do was to apply the force of the bar. A hole, the size of the bar, had actually been made. 2 policemen and the agent of Dr. Parkman came. Starkweather put that question to him as he has testified, though Littlefield does not mention it. Has every place in this building been searched? Mr. Littlefield replies, yes, it has, except the privy of Dr. Webster. Remember that Littlefield has said that the suspicions that the body was concealed there were universal in the community. He tells Starkweather that every place except the privy had been searched. Well, said Starkweather, let us search it now. No, said he to Starkweather in substance, wait till Dr. Webster has gone home. He has got the key. I do not mean to say of the privy, but the keys of his establishment. Then, said Starkweather, I will come tomorrow morning. Why not then? Why not have had one disinterested witness who might, at this moment, have testified about it? Why did he put off Kingsley and Starkweather when the hole was actually perforated? Throughout the hole, those men had been there with him, those men who could have been vouchers for his integrity. Mr. Littlefield talked with them about the crime of Dr. Webster. He made no secret and had no delicacy upon the subject, and yet, when they desired to see beneath that privy, and when the hole was perforated, he sends those men away. And then came his friend Trenholm, and he told him. But he said, away, be gone, for 20 or 30 minutes, and come back. This is positively fearful. Why not now? He penetrated that wall, gentlemen of the jury, exactly up by the wall on the north side, I believe, of that building, and there, almost in the very front of the hole he made, some few feet distant from the perpendicular line of the privy, were found these remains, with the water dripping on them from the sink. Gentlemen, I bring to you the facts of the case. If they are startling facts, if they demand explanations from Mr. Littlefield, which cannot be given, I bring them to you only that you may say what ought, in justice and in truth, to be deducted from his testimony. And if the chain be impaired by the want of credibility of this witness, if you, in short, do not believe, because of these internal difficulties, these intrinsic corruptions in the testimony, then, gentlemen, this mass of network, these great theories and hypotheses of the government crumble away, as the cloud and the mist are dispersed in the beams of the rising and refreshing sun. End of section 31.